Magandang umaga, ito ang UNTV News Break. Naniniwala si House Prosecutor at Lanao del Sur 1st District Representative Zia Alonto Adyong na dinedelay ng kampo ni Vice President Sara Duterte ang impeachment trial. Ito'y kaugnay ng inihaing petisyon ng kampo ni VP Sara para questionin ang otoridad ni Senate Impeachment Court Presiding Officer Francis Chis Escudero. Noong Lunes, naghain ng petisyon sa Supreme Court ang kampo ng Vice Presidente. Mga kasangbahay, tunghayan muli ang pangatlong araw ng makasaysayang impeachment trial ni Vice President Sara Duterte. Ihahatid ng UNTV News and Rescue. Tumutok lamang sa aming official YouTube channel. Ako si JP Nunez at dito sa UNTV, Diyos ang aming sandigan, serbisyo publiko ang aming pinahahalagahan. Magandang umaga.
Hi, VP.
Hi, VP. VP statement. VP, any statement, VP?
Wala na. Oh. Hi, ma'am. Good morning, ma'am. Good morning.
Hi, ma'am.
Good morning, ma'am. Good morning po, ma'am. How are you, ma'am?
Condolence.
Thank you po, ma'am. Thank you po, ma'am.
Wala.
So, ma'am, kamusta po? Opening statement po kayo.
Okay. Just two sentences, one sentence, and then no questions. Yeah, I know. Sadly, no? Sad. Siya ang may kasalanan. Sabi niya no questions daw.
Ma'am, over.
Yes. So, my statement is, in this bloodbath and bludgeoning, I will be blooded but unbowed. Maraming salamat.
Ma'am? Ma'am, kamusta kayo, ma'am? Ma'am, kamusta kayo, ma'am? Pwede, ano comment nyo na,
Hi, VP. VP, are you attending the trial, ma'am?
Ma'am, are you prepared to slug it out? Ma'am, are you prepared to slug it out till the end? Ma'am!
Dumating na po si Vice President. Oo, no? Dito sa Senado. Isa rin po wala pa po conclusion kung
Okay, yes. I will read my statement for today, just a short statement on what happened. So first, there are administrative updates. As to the BIR box, the BIR box was transmitted by the impeachment court clerk on July 7, 2026 and was received by Attorney Ann Lorraine Garcia Marquez of the Office of the BIR Commissioner at exactly 11:07 a.m. We will be attaching a photo of the receiving copy to the briefer that we will give you later. As to the House Panel of Prosecutors subpoena request, the request for issuance of subpoena duces tecum regarding tax documents of respondent Manscarpio and 22 businesses which respondent allegedly has interest in was received on July 6, 2026 at 3:35 p.m. by the clerk of the impeachment court. The renewed request for issuance of subpoena duces tecum for bank records as addressed to Honorable Eli Remolona Jr. as chairman of the Anti-Money Laundering Council was received on July 6, 2026 at 3:35 p.m. by the clerk of the impeachment court. Based on the order of the impeachment court on July 6, 2026, the respondent's counsel will be given a copy and 5 days upon receipt may file comment and opposition therewith. Afterwards, oral arguments will be scheduled. Senate President Sherwin Gatchalian called the session to order and convened as impeachment court today at 2 p.m. with 20 senators present. As to the preliminary matters, the inquiry of the Senator Judge Lacson on the 16 votes required to convict as a definitive ruling and not merely a personal opinion, the presiding officer confirmed and affirmed that such is a definitive ruling subject to the legal recourse of any party regarding the matter. As to the manifestation and query of the Counsel of Prosecutor Lorna Kapunan to the respondent's counsel on the plan of the prosecution to call the respondent as a hostile witness, the presiding officer reiterated that the respondent vice president can be allowed not to appear but will deal with the matter once the prosecution files the appropriate pleading in court, and will deal with it the same way as before, giving the other party the chance to oppose or comment within 5 days and with oral arguments to be scheduled. The start of presentation of prosecution's evidence in chief, NBI agent John Mark Calilong, was presented today. On the defense's motion to have Agent Calilong's testimony be excluded for being not part of the Articles of Impeachment, the presiding officer denied the motion, citing the case of Enrile versus Sandigan Bayan as the Supreme Court held that the additional evidence is allowed as complaint is just the summary of the charge against an accused. It does not include the evidence to support the charge in the Articles of Impeachment. The direct examination of the witness was conducted by the Counsel for Prosecution, Attorney Ligutan. The presiding officer allowed the showing in open court of the 2-minute and 18-second video, Exhibits P4-10 and contained in Exhibit P4-10A, despite objection from the defense on the need to show the whole 2-hour video instead. The presiding officer as well made several evidentiary rulings on motions and objections of both parties. Several senator judges asked questions to the prosecution and its witness. Of note is the question of the Senator Judge Ontiveros on why Article 4 is tantamount to an impeachable offense, to which the Counsel for Prosecutors, Attorney Ligutan, answered in the affirmative with explanation. This prompted a motion from Senator Judge Pia Cayetano to move to strike the response of Attorney Ligutan. The presiding officer moved to table the motion to strike out and to be taken up at a later time. And then the presiding officer ruled that the cross-examination of prosecution witness NBI agent Calilong will be done tomorrow. The trial has adjourned and will resume tomorrow, Wednesday, July 8, 2026, at 2 p.m. for the continuation of the testimony of prosecution witness NBI agent Calilong for cross-examination by the defense. That's all. Tama po. because the cross-examination will entail long time. Based sa experience natin bilang litigator din, ine-expect natin na matatagalan yon, and some senators are already tired sitting there. So pwede naman po yun, ginagawa yon so that mas ma-appreciate ng mga tao po pag hindi tayo pagod. Mas ma-appreciate din yung storya at testimonya ng testigo kapag nakapahinga rin siya. Kasi tuloy-tuloy rin siya kanina. Kawawa rin naman.
Moving forward, sir, ito ba yung maaasahan natin parang schedule ng trial na hanggang 6 or before 7 p.m. ay matatapos?
Yes. I think we want to make the trial very compact and expedient. Medyo long day lagi tayo kapag may trial, alam niyo naman. So gusto natin na as much as possible lahat ng mga incidents ma-resolve kagad at mabilis yung mga pagpepresenta ng mga testimonya at ebidensya.
Although, sir, that would also mean ma-extend pa yung 92, at least 92 days.
Hindi pa natin alam kasi sometimes the court will schedule a specific 92 days, but because of exigencies or yung mga ganito na hindi naman kasalanan ng both parties, hindi rin kasalanan ng korte, just as part of court management, the court will necessarily extend the trial dates as need be. So hindi talaga siya 92 or 93 days na nakatali talaga.
But what transpired to the attorney is hindi na sunod yung sana'y target na
One day, one witness rule. Katulad ng any provision ng mga rules natin, no, ito po ay pinapasa lang o pinapasunod sa atin para may orderly na pagpresenta ng mga ebidensya at ng mga testigo. Pero hindi naman po ito hard and strict rule. While we want na talagang masunod yon, pero depende po sa case-to-case basis, exigencies of the time, ang mas nananaig pa rin po talaga yung mas makuha yung katotohanan. At mas makukuha po yon kapag lahat po ng parties ay medyo hindi napagod sa gantong klaseng kahabang mga testimonya.
May epekto po ba, attorney, yung schedule ng oral argument para dun sa pagsupina sa mga bank records dahil kakain po ng oras ito instead na magpipresenta ng ebidensya ang prosecution?
That is an expected result of the delay o dun sa pagka-cross-examine ng first witness ng prosecution. Siyempre mauurong lahat yun. However, the impeachment court will try its best to figure out how to squeeze in the incidental oral arguments po doon sa mga trial dates na mga sinet po natin for the meantime.
Anong target ng court for the oral argument? 1 day or 2 days, 3 days?
Of course, it will just be 1 day kasi nakalagay sa Senate Rules on Impeachment, the parties will just given 1 hour to argue their motion and 1 hour for the other side. So medyo mahaba na po yung 2 hours na yun. Kaya it will take up much time kapag magkaroon po ng oral argument sa lahat ng mga incidents.
Attorney, any response dun sa petition for DRO laban dito sa trial dahil nga lang po sa pag-elect kay Senator Cheese bilang presiding officer?
As the presiding officer said yesterday and was confirmed earlier, any person can raise the matter. Pwede po nilang i-exhaust yung kanilang mga legal remedies and yun po yung nakita natin. But since meron na pong kaso po sa Supreme Court yun, we will respect the sub judice rule at hindi na po magko-comment yung impeachment court regarding that matter.
But pag maglabas ng DRO, susunod po yung
Hindi, I think pagbobotohan po yun ng impeachment court as a collegial body. Yung kung katulad po ng last year, no, pinagbotohan po nila yung mga insidente na may concern po sa pag-i-implement po ng mga orders ng ibang bodies or branches of government. So because this is a collegial body, not a single person can speak for the body. So mas mabuti pong pagbobotohan kung susundan ng Kongreso o ng Senado yung mga ganong order from another co-equal branch of government.
So kahit kung mayroong ganong petition, magpapatuloy lang ang pag-
Tama po, tama po. dahil wala naman pong in-issue na TRO or status quo ante order.
Medyo speculative lang, attorney. Pero mauulit ba yung nangyari yung mga naunang impeachment proceedings sa Senado na may desisyon ang Korte Suprema na hindi sinunod?
Ano po doon? Can you please clarify? Ano po yung specific na incident na sinasabi ninyo na hindi sinunod ng Senado yung order ng Korte Suprema? Kasi mahirap po magkomento ako dito ng very general statement pong ganun na walang specific na detalye po. So, kung naalim po, lahat po may possibility na mangyari.
Na maaari nilang hindi sundin sakali maglabas ng TRO ang Korte Suprema?
Of course, it is within the plenary powers of any co-equal branch of government. However, as we have seen before po, the Senate always respects the balance of power. So kung yun po yung guidance natin, makikita po natin na susundin nila yung co-equal branch of government nila so long as it does not prevent them from exercising their own powers under the Constitution. So pag ganyan po, ayaw po natin ng constitutional crisis, and sa history naman po ng ating mga three branches of government, wala pa naman tayong umabot doon sa ganong pag-violate nung co-equality ng mga branches of government po. Yes, kasi yan po yung nakaschedule na ng prosecution na ipresenta ngayong linggong to, dalawang NBI agent po to testify on the videos as well in relation to Article 4 ng Articles of Impeachment.
How would you describe the second day of the impeachment trials?
Compared yesterday na medyo mabilis kahapon, very efficient, very fast. Today po, it was long because of the technicalities of the law. Sana po maintindihan ng publiko natin na kasama po yung mga ganong mga procedure, mga formalities ng pagmamark po ng ebidensya, na pag-identify at authenticate at paisa-isang pagtatanong po to establish the chain of custody at saka po yung pag-identify ng mga dokumento at ebidensya. Kasama po yun sa araw-araw na ginagampanan ng lahat ng abogado po sa korte at lahat rin po ng korte. So, nasisilip po natin bilang publiko yung inner workings of the court in process. So, medyo pagpasensyahan lang po natin yon, but it is necessary po for the to keep the rights of all the parties in place po.
Kahit sir yung paulit-ulit na objections ng defense, talagang
Party po yun, opo. Party po talaga po yun. They have the right to raise objections and they have the right to ask for a ruling on their objections po.
Attorney, can we ask for you, I think there's precedent po during the Corona trial about the TRO. Can you elaborate to us? Ano po yung precedent about the Senate possibly voting on the TRO?
Can you clarify what TRO was issued during the Corona?
Po of Corona.
Ano po?
The Senate during the Corona trial voted about the TRO on opening the dollar account. So do we see a similar scenario?
It's hard to hazard a guess because case-to-case basis po. So ayoko pong pangunahan kung ano po yung magiging aksyon ng ating mga senator judges at ng impeachment court. But I think we have to just wait for it when the time comes. We will cross the bridge when we get there.
sir, may gag order ba sa mga senator judges na gusto pati sa voting representatives?
Yes, it is part of the Senate impeachment rules and it was reiterated by the presiding officer in his opening statement yesterday.
Hindi pwede po kasama merits or ano, pero yung presentation lang po, pwede hindi.
Yung merits po, bawal po. May tanong pa po kayo? Thank you po. Ay. Cross-examination po kay Kalilong, and kung maikli lang po yung cross-examination, then possible po na maipresenta rin po yung pangalawang testigo po ng prosecution. Maaari rin naman pong walang cross-examination. Nangyayari naman po yon sa ordinary na experience ng mga korte at mga abogado po sa litigation. So kung wala rin pong cross-examination, then the prosecution will move to their next witness po na si NBI agent Lontok.
Possible tomorrow yung more than 2 hours na online
Possible po. Hindi ko po alam kung ano yon. Sige po. Salamat po. See you again tomorrow. Bibilangan kita. Wala. Ganon po yun pag kasabi naman po ng natin ng presiding officer, he will be liberal in the implementation of the rules because the other party naman can also question it eh. Yes, pagbibigyan lang po. It's better po na ipasok na as much as possible kung may matters of admissibility lang. Let the senator judge decide on the probative value of the evidence. Kesa po magkamali na hindi ipasok, then hindi na mako-consider yun ng mga senator judges in their deliberation doon sa kanilang ultimate question kung guilty or not guilty. Minsan kasi po, hindi po nagko-cross-examination ang isang abogado ng kabilang party kung wala pong nagawang damaging testimony yung sa direct examination at walang kailangang klaruhin o hindi binibigyan ng importansya yung testigo na yun. Opo. Ay, hindi ko po alam. Hindi ko po nakita sa vantage point ko eh. Kung nakita ko po siya kanina nandito, so I don't think nag-walk out po. I think Senator Judge Cayetano already said na pwedeng payagan tumayo o lumabas, umihi o uminom yung any party. So I think ganun lang po. Hintayin natin. Siguro ripe yung for the matter na yon kapag may nag-raise ulit na, kunwari open na yung natin, yung schedule, baka dun na lang nila talakayin. Kasi pag medyo tight yung schedule ng impeachment court, baka hindi muna talakayin yun. Yes, medyo wala namang ganong prejudice on both parties kasi technically, pinapa-strike out lang on the record eh. 'Di ba? So, and since narinig nyo na rin po naman lahat, technicality na lang yun na pagdating doon sa deliberation, sa ultimate question, sa huling-huli na, kung ano na lang po yung nakalagay doon, kung tatanggalin ba yun o hindi. So, bahala na po yung Senator Judge by that time.
Pero i-announce naman yun sa floor.
I-announce naman po yun sa floor kung time na to already tackle it. Thank you po. Thank you po. Good luck.
Presiding Officer, Cheese Escudero, it was very fair at nabigyan ng pagkakataong mailabas ang ebidensya sa tamang pamamaraan. I'm happy and I hope that this will continue throughout the impeachment trial days as we go on. At yun lang naman ang hiling natin, simula pa dati, na malabas ang ebidensya para makita hindi lang ng ating mga senator judges, kundi ng lahat ng Pilipinong sumusubaybay. All I can say is if it's in the subpoena that we filed, we will decide next week how and who and when we will present them. I can't talk on the merits, but our pleadings will speak for themselves. I can tell you right now, every time the prosecution would assess our strategy, it can change, so I won't tell you for now.
But maybe confirm po, since nabanggit na po kasi ni Attorney Kapunan earlier that Mr. Daray na patawag po siya, maybe confirm na ipatatawag na po ng House Prosecution Panel to
I can only confirm that we have a reservation to call additional or other witnesses if necessary when the circumstances warrant it. But for now, I can confirm that we will call or subpoena the Vice President. And it's only a matter of coincidence na nandito siya kanina sa Senado. So naitanong na lang din ni Attorney Lorna Kapunan kung nandito pa siya habang ongoing ang trial at kung dadalo ba siya.
But
Matagal na naming nire-request ang Vice President na dumalo sa Kongreso pa lang sa Committee on Justice. Tuwing may hearing kami, may imbitasyon ang Vice Presidente. And we leave it up to her. She has the right to attend or not to attend so long as naandyan ang kanyang mga abogado. At hanggang dun lang muna ako para hindi ko makwento ang strategy ng prosecution.
Sir, hindi pa ba enough yung pong mga video na presente po na yung pong mismo statement galing sa kanila?
Para sa amin, yung mga video na yon ay sufisyente, enough to prove betrayal of public trust, to prove culpable violation of the Constitution and high crimes. But we leave it up sa ating mga senator judges how they will assess and appreciate the evidence that we have just presented today na napakarami at kita ng buong sambayanan kung gaano kadaming video at statements ang lumabas in support of the Articles of Impeachment. We were very satisfied with the outcome of today's trial. No victory can be claimed until matapos ang verdict. But today was a very satisfactory day for the prosecution team. Lumabas ang lahat ng ebidensya naming gusto ihain sa Senate Impeachment Court at lahat ng statements na gustong ilabas ng impeachment team na ilabas namin. At mabuti din at mahusay ang mga abogadong humawak nitong trial at itong unang testigo namin, si Attorney Virgil Ligutan. He's an excellent trial lawyer and hats off to Attorney Virgil Ligutan.
Sir, can you describe how you engaged with the defense team kanina, especially during your introduction po ng Article 4 kasi parang dun pa lang po kinokontra na po.
But your manifestation was allowed to be entered into the records, although not evident.
I'm glad that the presiding officer allowed my manifestation to be said in open court. It was meant to guide our senator judges kung paano namin ilalatag ang ebidensya, kung ano ang kabuuan ng ebidensya naming iisa-isahin through our witnesses and our documents, at para mabigyan din ng paglinaw sa mga kapwa nating Pilipino sa pamamaraan na maiintindihan nila at mauunawaan nila ng husto. Ano ba itong binabalak nitong Article 4 kung saan, sabi ng Presidente, may nakausap na siyang taong pumayag na at nakaabang at handang pumatay sa Presidente ng Republika ng Pilipinas.
Sir, clarification lang. Instead na siguro victory, would you think na nakascore, nakapuntos yung prosecution ng victory?
Yes, malaking puntos itong araw na ito. Ang aming testigo ay nakapaglabas ng ebidensya sa mahusay na pamamaraan ng ating private prosecutor. And it's also a victory for all camps because the court was very fair in allowing the evidence to be presented. Naging patas at naging pantay ang Senate Impeachment Court at ang presiding officer. At matagal na nating gusto ito para hindi pagsabihan ng mga Pilipino na hindi impartial ang Senate Impeachment Court. So they acted with impartiality, they acted with fairness, and they acted with integrity today.
Sir, kunin ko na yung pagtingin niyo regarding dun sa move ng defense na i-play yung buong 2-hour video instead yung clip lang na 2 minutes. What do you think of that? Is it something of a means to delay or?
Para sa prosecution, ang relevant lang o ang kinauukulang ebidensya lang naman na gusto naming mailatag ay yung 2-minute portion ng 2 oras na video. Kung panahon na ng depensa sa kanilang pagpresenta ng kanilang evidence in chief, pwede naman nilang i-play yung buong video kung gusto nila. Dahil nakalatag naman yon at nakamarka noong pre-trial pa lang.
Sir, nakascore po ba yung prosecution because the videos were finally shown noong October and November? Or dahil dun sa sagot ni Atty. Ligutan sa question ni Senator Hontiveros? Or both because of those two, can you say kaya those two developments today, would you say na yun yung nagpanalo for the prosecution for 2-2?
Score kami sa video na lumabas na dapat naman talaga makita ng Senate Impeachment Court. Score kami sa ibang mga statements pa na lumabas galing sa Vice Presidente na sumusuporta sa Articles of Impeachment. Hanggang doon na lang ang statements o ang sagot ni Attorney Ligutan, hayaan na muna nating mahusga ang Senate Impeachment Court kung anong gagawin nila doon. Pero we are very satisfied with the outcome of today's trial, and we hope to continue that, and we will sustain that throughout the 90 days total of the impeachment trial days. We are ready to sustain this kind of trial.
Follow-up lang. Sir, may sinasabi yung defense about copies ng mga NBI report. Are you concerned na mag-issue to?
No. Yeah, we are not concerned about the objections of the defense team. Normal din sa kanilang depensahan nila ang kanilang kliyente. But as far as we are concerned, kapag lumabas ang isang dokumento, nasa kamay na ng mga Senate Impeachment Court judges natin. Ang importante, nakita nila na ang mga Articles of Impeachment ay suportado ng testimonya ng mga testigong may personal knowledge, suportado ng mga authenticated documents and videos, at suportado ng magandang proseso at legal na pagpapalabas nito sa loob ng Senate Impeachment Court. Marian? Rose? I will let Attorney Ligutan answer that. Hindi ko personal na nasubaybayan yan. And hindi ko lang nasubaybayan. I was busy talking to the team and preparing kung ano ang susunod na itatanong.
Pero ano pong assessment yung sa gawin po ng defense during po sa examination po ng testigo niyo?
Normal lang sa kanila na mag-object. Pinaghandaan namin ng husto yun. Kung nakikita nyo, hindi natitinag ang prosecution team sa kahit anong objection. Kahit sa pag-object lang nila sa aking manifestation, alam namin kung anong isasagot. Bawat tanong na anticipate ng prosecution team sa aming paghahanda.
What can you say? Paano po assess yung mga motions ni-raise nitong defense? Even yung pagpopos ni Attorney Ligutan sa kanyang questions, pati yan po yung sinungkulan ng defense. What can you say?
Ang prosecution team handa sa aming strategy. Sana hayaan na lang kami kung papaano namin ilalatag ang pagtatanong, ang manner ng aming pagtatanong is always part of a lawyer's strategy during trial to not only bring out the evidence from the witness, but to present it the best way possible for the senator judges to appreciate the answers of the witness. Alam namin na iti-technical kami, inaabangan namin yon at handa kami. At natutuwa ako na sinabi na ng Senate Impeachment Court at ng presiding officer na ito na malinaw na ang impeachment ay hindi dapat bigyan ng striktong interpretation pagdating sa procedure at technicality ng isang korte o isang criminal or civil court. This is a sui generis proceeding, kakaiba ito, at susunod tayo sa ating impeachment senator judges kung anong husga nila base sa kanilang rules. Yes, Milky.
Sir, inulan mo ang article number 4 doon sa grave threats laban sa Pangulo, sa First Lady, and former Housekeeping. Sabi mo, nakapuntos dito ang prosecution. So, ibig sabihin, tama na yung desisyon na inuna ang article 4.
Tama ang desisyon na inuna ang Article 4. Last year pa, strategy na ng prosecution team yon at napagdahandaan namin ito ng husto. At nakita ninyo na ang pagtatanong, ang pagpresenta ng dokumento, pati ang aking mga sinabi to introduce Article 4 ay handang-handa kami. So I won't tell you what other strategies we have starting tomorrow, but all I can tell you is that we are prepared for this impeachment trial and we have anticipated every technicality or every scenario possible sa aming paghahanda. Aasahan yung mauulit itong ginawa namin ngayon. We will sustain this kind of energy during the trial and we will continue to be respectful to our senator judges.
Sir, what is the strategy behind letting Attorney Ligutan do all of the examination of the witness instead of you as the lead prosecutor for Article?
At tandaan natin na under the Senate impeachment rules, allowed naman talaga ang private prosecutors. In fact, they have been acknowledged during their entry of appearance noong July 6. We have our own internal strategy how to manage the witnesses and the lawyers assigned to the witnesses. And I can tell you for now, Dwight.
Sir, yung House po, naghahain na po sila ng request for sa pinaka-attorney sa local office for grade defense pa rin na article by next week po yung nakalagay dun sa first person pinaka-on. Bilang kayo po yung prosecutor sa article na ito, how will you help in strengthening your case before the Senator?
I want to answer your question, but I won't, because all you have to do is wait for our strategy to lay out during the impeachment trial next week.
Sir, in terms of scheduling lang, bukas ba, Jerry Veloso will face, or bukas expected lang na counter?
Antayin na lang muna natin bukas, Dwight, kasi sa palagay ko tapusin natin ang cross-examination ni Kalilong, at kung meron mang redirect examination si Attorney Ligutan, sigurado akong papayagan naman ng presiding judge natin yun. Thank you, everyone.
For staying. Sige po, we can start para everyone can...
Attorney, of course, second day of course, ang daming, well, ang comment mostly ng social media, bakit ang daming objections daw ng defense doon sa testimony ni NBI. So, what's your take? Ano po yung comment ko, bakit ang
Well,
daming objections?
natural lang naman yan. You will see naman sa lahat naman ng litigation, sa lahat ng trial proceedings, lalo na sa examination ng witness, talagang magkakaroon ng mga objections ang bawat panig, lalong-lalo na kung sa tingin namin, leading yung question, because, for example, para lang sa kaalaman ng ating mga kababayan, pag ikaw ang nasa direct examination o kunwari yung prosecution today, kung anong ginagawa nila sa direct examination, you cannot kasi lead the witness, meaning you cannot, usually, more often than not, the general rule is you cannot ask questions that are answerable by yes or no. Kasi parang, kumbaga, ikaw na yung sumasagot, ikaw na yung nagtitestify, pinapa-confirm mo lang. No? Except for, syempre, may exceptions pa rin dyan, yung mga preliminary matters, okay lang naman na yes or no. So, natural lang na may ganyang mga objections. At syempre, we want to put on record yung aming mga objections, specifically on the documents that they're presenting. So, whether naman, nasa court naman yan, nakita niyo naman kanina, whether the objection is sustained or overruled. Sustained meaning pumapanig sa atin yung korte sa ating objection, or overruled meaning hindi nakakalusot yung objection natin. Okay lang naman po yan, sa amin naman po as long as we put things on record.
Sir, binabanggit ni Congressman Adyong na kiniklaim nila yung victory today dahil sa dami nga ng mga na-overruled na mga objection ninyo.
Well, sa amin naman, I always respect the positions taken even by the opposing counsel and even yung House. No? So, I will not comment on that. Pero pagdating sa defense, we don't really kasi count wins or losses per day. Lalong-lalo na, we're only on our first witness and on the second day. So I think it's, for the defense lang hindi ko po kinukontra si Congressman Adyong because that's their position. Pero for the defense, hindi namin yan binibilang na win or loss kasi masyado pang maaga para magbilang ng ganyan para sa amin.
Sir, comment niyo po dun sa school of thought na kasi pwede mag-object na lang daw pag formal offer of evidence na kumbaga kasi objections during their examination ay parang futile attempt to disrupt lang daw. Comment on
The general rule is for documents kasi the objection is made during the formal offer of the documents. But the defense feels it's really important for us to put matters on record, especially because, as you know, during our answer, we have raised issues, no? Kaya meron tayong motion for exclusion on certain documents na we feel kasi should not be considered dahil hindi naman siya naka-attach sa original complaint, while others naman ay hindi saklaw nung years kung saan impeachable officer ang ating Vice Presidente. So we are just putting matters on record.
Attorney, what can you say doon sa manifestation ni Senator Riza na pina-strike off ng
Well, sa akin naman po, the senator judges are entitled to raise their manifestation. So, we leave it up to the presiding officer kung ano po yung tingin niya doon. Sa atin, I think, in fairness to Senator Judge Risa, she also clarified na she wasn't naman provoking any parang closing statement or summation. I think she just really wanted to know what the relevance was of all these video clips. So, I want to be fair and more than that, I don't want to comment any further.
Attorney, what's your reaction with the manifestation naman ni Attorney Lawyer Nakapunan na they're planning na maging key witness si VP Sara for grave threats? Though sinabi na kanina ni Senator Cheese na hindi daw pwede kasi nakabase sa inyo. Pero posible ba na payagan ng depensa?
Well, sa amin, we will comment when the motion is there. I think it's premature right now. Narinig naman natin yung mga pahayag. Narinig din naman natin, that's very clear under the Constitution, yung right against self-incrimination, na pag yung respondent mismo o yung akusado mismo ay hindi pwedeng i-compel, no? Na mag-testify against himself or herself. That's very clear under the Constitution. But of course, there's room to argue here and there. Abangan na lang natin. Siguro once the motion is in fact made by the prosecution, we will definitely submit our position on the matter.
Attorney, may mga nag-question ng legality ng pagiging presiding officer ni Senator Cheese Escudero. Anong komento niyo doon?
Wala naman kaming, sa amin, no comment pa muna as of this time, no? Sabi nga niya, anyone is free, any party may raise that issue at some point, hindi ba? So, tingnan na lang natin. Pero sa amin, hindi pa namin napag-uusapan ng defense yung mga bagay na yan. Kung sakali, but sa totoo lang, para lang hindi ma-mislead yung public sa defense, wala pa kaming pinag-uusapan na ganyan about the presiding officer.
Attorney, nabanggit po kanina na nag-walk out tapos
SP, the presiding officer?
Well, first of all, I don't think we have the right to be satisfied or unsatisfied. But yeah, I mean, it was I think for the past 2 days, there has been an orderly conduct of the proceedings. So we submit ourselves to the court.
Attorney, merong manifestation ng prosecution kanina to call Yusek Zuleika Lopez and the Director Pedro Mativa for next week po yata. Magsisend po ba or magbibigay po ba ng sagot ang defense ito sa manifestation na ito?
Well, I think they are asking for the issuance of yung subpoena duces tecum and ad testificandum. So natanggap naman natin yan. So we will just prepare for that.
Attorney, many are asking bakit daw dito ginawa yung meeting po kanina with the Vice President?
Well, as I've mentioned earlier, yung Vice Presidente kasi natin, at least as far as I know her, yan talaga yung character niya. So ayaw niyang nai-inconvenience kung sino man yung ka-meeting niya. So even ako noon, she would ask me kung anong time ako pwede, saan ako pwede, saan convenient sa akin. Usually she's the one who will adjust, no? Specifically for today, because alam naman niya na ongoing yung impeachment trial, and alam naman niya that the defense is here at least around lunchtime or so para sigurado hindi kami malilate sa 2 p.m. So, para sa kanya, mas convenient para sa defense na dito na lang ganapin yung aming pulong. So, kaya siya pumunta dito. Wala, we cannot because that's subject to attorney-client privilege.
But sir, you mentioned intimidation or any kind of intimidation or intent po sa Senator Judges as well as the Senator?
No, I think that's so far off. I think we're making something out of nothing. Intimidation meaning the Vice President being here. No, parang I think we're creating, ma'am, I'm sorry, but I think that's really creating a story out of nothing. No, it was a meeting. I don't think the Vice President coming here would intimidate anyone, hindi ba? Oh.
Attorney, kanina po may nabanggit na na-walk out daw po si Attorney C.
Hindi po totoo yun. Talaga pong kailangan lang niyang mag-toilet break. No? Kahit naman ako kanina 2 beses ako or 3 beses pa nga yata ako lumabas. So she was really on her way out. Tapos nung nasabing nag-walk out siya, narinig yata niya, so bumalik siya. Sinabi niya na, no, I'm still here and I just need to go to the toilet.
Pero may mga moments po kanina na habang nagsasalita po yung Prosecution Counsel, parang nagre-react po yung defense. Normal po bang nangyayari?
Well, yeah, because sometimes, but siyempre, we should all try to compose ourselves and try to make, not to react so much. But hindi naman, kasi we're a team, di ba? So we all, even if someone's the one that's anchoring for the day, merong nakatayo dun sa podium ba yung tawag doon, no? Para sa atin, or rostrum, kami naman, we're a team. So as you can see, we help each other, we pass notes, ganyan, to help each other out. So hindi naman, normal lang naman po siya.
Attorney, without going to the merits, attorney, may we seek clarification from the defense? What's the wisdom behind insisting to play the 2-hour press conference earlier instead of going with the 2-minute
Sige, ang hirap, I really hope I'm not cited in contempt for this, but it's really context. Yan lang naman ang gusto natin. Nasabi na naman kanina siguro yan, so I can just be factual. It's really context. Kasi ang utterances natin, di ba, if it's taken just certain phrases, sometimes it's taken out of context. So sa amin, what we wanted to show is just context. But beyond that, please don't make me comment any further at baka po ma-cite ako in contempt, no, for violating the rule.
Kamusta po si Attorney Carlo Narvasa? Of course, siya yung parang naging first defense lawyer na humarap kay Attorney Decutan. And some comments are saying na baka na mapagod na rin si Attorney Narvasa or baka na-overwhelm siya. Have you talked to
Hindi naman. Hindi naman. Okay naman siya. Hindi naman. We're all of our lawyers are litigation lawyers, so we're used to grueling hours in court. You know, it's not the first time that na kahit naman sa regular courts tumatagal rin ng ilang oras, no, sometimes even one full day ang examination of witness. So hindi naman siya issue. He's doing well and he's okay. I just spoke to him before coming here. So
based on your statement that the Vice President's it's her habit to be not inconvenience her staff. Will it be a regular occurrence for her to be visiting the Senate before the session or
wala naman kami napag-usapan na gano'n na magiging regular yon, no.
Because you've known her for quite some time. So pwedeng mangyayari ulit yun na bibisita na lang siya anytime.
Well, that's always a possibility na bibisita siya, pero wala kami napag-usapan na schedule or anything.
Will not that affect more or less the effectivity of parang she's already here and yung subpoena, hindi ba yun, in your opinion, will it not affect more or less the decision to subpoena her as a hostile?
I don't know. I think the decision to move for the issuance of a subpoena is up to the prosecution. But that's up to the prosecution, ma'am, and I will not answer for the prosecution.
Attorney, marching orders po ba sa inyo si VP Sara kanina nakita po?
Wala naman. But again, I cannot disclose what is discussed between an attorney or a counsel and our client, no? But sa totoo lang, parati akong tinatanong sa marching orders, you know, if at this point kailangan pa namin ng marching orders, ibig sabihin hindi pa kami handa. At hindi, that's very far from the truth. Matagal na po kaming handa, so there's really no need for any marching orders.
Attorney, maybe you have the comment of the defense team doon po sa statement ni Representative Terry dito na hindi may tuturing na bloodbath yung impeachment trial kung proxies lang yung haharap, yung mga abogado lang haharap.
Well, as I always say, that's always, you know, we just respect the position of everyone, including, of course, Congressman Terry Redon. So that may not be our position, but you know, he has he's well within his rights to say what he feels and thinks.
One last, attorney, kanina regarding po ng short statement ni VP Sara nung nandito siya, nag-react po dun si Representative Terry. Ito po yung exact statement niya. Maraming salamat sa inyo pong payag, Madam Vice President. Makakadagdag po ito doon sa batayan kung bakit totoo yung Articles of Impeachment on threats against the Vice President. Your reaction? Against the President.
I don't know what ano yung context ng sabi na, so it would be unfair for me to comment on Congressman Terry Redon's statement. But I guess the defense is just here. We're focused on our case regardless of the statements made by personalities. Sa amin, no, we just want to insulate ourselves from that and just focus on the case at hand and focus on the proceedings like what is scheduled for tomorrow.
Okay po, thank you so much po.
Thank you. Thank you. Thank you. Thank you. Thank you. Thank you.
Will now call the roll.
Roll call of members. The Honorable Senator Judge Aquino, Senator Judge Cayetano Alan, Senator Judge Cayetano Pia, Senator Judge De La Rosa, Senator Judge Ejercito, Senator Judge Estrada, Senator Judge Go, Senator Judge Ontiveros, Senator Judge Lacson, Senator Judge Lapid, Senator Judge Legarda, Senator Judge Marcoleta, Senator Judge Marcos, Senator Judge Padilla, Senator Judge Pangilinan, Senator Judge Soto III, Senator Judge Tulfo Erwin, Senator Judge Tulfo Rafi, Senator Judge Villanueva, Senator Judge Villar Camille, Senator Judge Villar Mark, Senator Judge Zubiri, the presiding officer, Senator Judge Escudero, the Senate President.
With 20 senators present, the chair declares the presence of a quorum. We now recognize the presiding officer, Senator Cheese Escudero.
Thank you, Mr. Senate President. The reading of the Journal of July 6, 2026 of the Senate sitting as an impeachment court is hereby dispensed with, and unless there are any objections, the same is hereby approved and adopted. The clerk of court will now please read and call the case before this impeachment court.
Case number 004-2026 in the matter of impeachment trial of Vice President Sara Duterte.
Appearances.
Good afternoon, Your Honors. Same appearance for the prosecution. We are ready, Your Honor.
Noted. Appearances for the respondent.
Good morning, Your Honor. Same appearances for the defense.
Is the prosecution ready to call its first witness?
Yes, Your Honor. However, the prosecution have few concerns which it wanted to raise before the Honorable Impeachment Court. So may I request, Your Honor, that the Honorable Counsel for the prosecutor, Lorna P. Kapunan, be recognized, Your Honor.
Before recognizing the counsel for the prosecutor, ma'am, upo muna kayo. Chair would like to recognize first Senator Judge Lacson. What is the pleasure of the Honorable Lacson?
It's a point of inquiry, Mr.
You may proceed, sir.
Yes, Mr. Senate President, Mr. Presiding Officer, Your Honors, just so it will be clear to our fellow Senator judges, as well as the panel of prosecutors, the defense team, and the public in general, yesterday after your election as Presiding Officer, you delivered your opening statement, portions of which I will either quote or paraphrase as follows. You stated, the Constitution states that conviction can only happen with the concurrence of 2/3 of all members of the Senate. And then you continued, with 24 members of the Senate, a literal interpretation of this means that conviction requires the affirmative vote of at least 16 senator judges. However, you also made it clear that, and I quote, those who disagree have the right to go about it through a legal challenge and sue the Supreme Court by virtue of its power of judicial review, render a different ruling on this question. The impeachment court shall faithfully abide by that ruling, unquote. My point of inquiry, Mr. President, Mr. Presiding Officer, is this portion of your opening statement a matter of legal opinion on your part as Presiding Officer, or does it constitute a ruling by the impeachment court? If the response is, it is the latter, does this mean that this court, through the Presiding Officer, has raised the level of discourse to a justiciable issue or a dispute that the Supreme Court may have legal authority to settle and resolve? In case either one or both panels in front of us decide to exercise their right to challenge the said ruling, should they deem it as a grave abuse of discretion by this court? I submit, Your Honor.
The response of the presiding officer is in the affirmative. In fact, the journal that we just approved contains a similar inquiry by Senator Judge Cayetano yesterday when he inquired if it was the position and ruling of the presiding officer, and the presiding officer answered in the affirmative. So to clarify, yes, I believe it may be considered already as a justiciable controversy, although it is not for us to dictate that but the courts. given that it is a ruling of the chair not objected to nor appealed by any member of this court and therefore stands.
Thank you for the clarification, Mr. Presiding Officer.
Thank you, Senator Judge Lacson. Senator Judge Cayetano, what is your pleasure, sir?
Mr. President, Presiding Officer, may I just further clarify the statement?
You may proceed, sir.
Yes. I confirm that yesterday we heard the same thing, and when the transcripts come out, of course, then it will be available to everyone. Basically, yesterday I clarified whether that was the opinion of the elected presiding officer, and of course, without any offense to my brother and friend, Senator Escudero, we have a continuing objection. I asked him whether this was already a ruling of the court, because if it's the ruling of the court, then as a threshold issue, we will have no further questions. Section 22, Article 22 of our rule says that all orders, decisions may be acted upon without objection, or if objection is heard, the orders and decisions shall be voted on without debate by ayes and nays, which shall be entered in the record, subject, however, to operation of Rule 6, and Rule 6 speaks of whether the presiding officer will rule on relevance and giving any movant 2 minutes. So I may also correct that yesterday I was not allowed to, when I objected to Senator, there is actually a pending case in the Supreme Court entitled Cayetano versus Aquino. That is myself and my seatmate, Senator Aquino. We talk, but we're not talking about the case. So actually, you're correct, Senator Lacson, that anyone can go on this issue itself. And I just like to make sure today and further clarify that there's no objections that as of today, the stand of the impeachment court is that of all members means that as long as you're still a member, so meaning when are you not a member anymore? When you die, when you are removed by finality, and when you resign. No? Otherwise, you are still a member, so you are still counted. And it is in that spirit that we ask, and we're preparing maybe a memoranda for all members to allow Senator Marcoleta and Senator Jinggoy, since they are going to have a vote. And if they are not allowed to vote, then that will be counted as a vote for acquittal. And that might be favorable to the defense rather than a part of giving a fair trial. So all I wanted to clarify today, Mr. President, is that we will continue to thresh out if there are any constitutional issues. But as of today, it is very clear that as a court, we have decided that 2/3 of 24, there are 24 members of the Senate today, 20 are present here today, but there are still 24 members, and 16 ang number of senators needed to convict on any of the articles, Mr. President. Mr. Presiding Officer, thank you.
What is the pleasure of Senator Judge Pangilinan?
Thank you, Mr. Presiding Officer, Mr. Senate President. Just to place on record that I would like to clarify that the ruling of the chair of 16 is as to the issue of whether the threshold number of conviction. The matter of whether or not Senators Marcoleta and Senator Estrada should be participating in the process of the trial is another matter that we will have to discuss perhaps in camera or on the floor at a later date, Mr. President.
Noted. If there are no other Senator Judge who wishes to make a manifestation, the lead prosecutor, Representative Luistro, is once again recognized. What was your earlier manifestation and motion, ma'am?
Your Honor, we respectfully reiterate our request that counsel for the panel of prosecutors, Attorney Lorna Capunan, be recognized.
Counsel for the panel of prosecutors, Attorney Lorna Capunan, is recognized. Will you be the one to present your first witness, ma'am?
Good afternoon, Your Honors, Senate President, Presiding Justice. I do have manifestation. Well, in direct answer to the query of the presiding Senator Judge, I am not presenting the witness today. But I would like, with your permission, Your Honors, to manifest a query that we request be addressed by this honorable court, presiding judge, to the defense.
The lady may proceed.
We are informed, and in fact, we have seen an interview conducted in the Senate premises on the vice, and that she is expecting a bloodbath and a bludgeoning, but she will not. Her head may be blooded but unbowed. My respectful query, Your Honors, please, which could be directed to the defense counsels, is if the Vice President is in the premises, does she intend to appear personally before this impeachment court? And that is preliminary to another manifestation that I would like to make. Your
Kindly
Honors,
proceed
please.
with your next one, Counsel. Because the chair is not yet sure if it will even address this to the Counsel for Respondents or will simply answer the query of the Counsel for Respondents.
This is relevant to the presentation that we will be making this afternoon, Your Honors. This court will recall your own statements, Mr. Presiding Judge, that on Tuesdays, every Tuesday of every week, that the prosecution must indicate who the witnesses they intend to present before this court will be. This is to enable the impeachment court to issue, when appropriate, and if deemed necessary, a subpoena for such witness. And that is my query this afternoon, because an presentation of witness on the first article that we will be presenting, which is grave threats and acts of sedition, Your Honor. One of the key witnesses, hostile, albeit hostile, would be the Vice President. And therefore, if we can inquire if it is her intention to again appear in the premises of the Senate, because we are already respectfully informing this honorable court that we will manifest, that we will have a written request for her presence in connection with this article on grave threats, Your Honor. That is the relevancy of my manifestation.
The chair would like to rule on the manifestation and request of the Counsel for Prosecutors instead of throwing the question to the Counsel for Respondents, for the simple reason that I do not want to, the parties to engage in a debate before this court. You can very well do that with the presentation of your witness through direct and cross-examination, redirect and recross. To answer, the impeachment rules do not mandate nor require the respondent to attend any hearing or trial of the impeachment court. Whether she was in the building earlier or arrived after, it is totally up to the respondent, because from the point of view of the court, she is represented in this court through her counsel already. Should the counsel for the prosecutors desire to call the respondent herself, the court will act on that motion and request once it is made and or filed, and need not make a ruling at this point in time. Because of course, when that motion is made, we will ask the counsel for respondent to make a comment and or reply.
Thank you, Sir Presiding Judge, Justice, Senator Judge. We yield to the wisdom of your decision.
Thank you, ma'am.
With that, we will reserve the right. We are not waiving the right to do call her at the appropriate time and to do file the appropriate request for subpoena ducis tecum and subpoena testificandum. For that, on that matter, Your Honor, I have no further questions and would like to turn over the floor to our lead public prosecutor.
Thank you,
Thank
Counsel
you,
for
Your Honor.
Prosecutors, Attorney Lorna Kapunan, for your remarks, which are duly noted. Yes, the lead prosecutor is recognized.
Your Honor, as manifested yesterday, The Articles of Impeachment is divided into 4 teams, and I would like to turn over to the head prosecutor of Article 4, that is threat, the Honorable Lawrence Defensor. May I request that he be recognized, Your Honor?
The member of the panel of prosecutors, Congressman the Honorable Lawrence Defensor, is recognized for his introduction of Article 4, I presume?
Thank you so much, Mr. Presiding Officer. May I be allowed to make a manifestation to introduce Article 4?
Before you proceed, Senator Judge Cayetano is recognized.
Before that, I ask for your indulgence from the prosecution and the defense. There are certain issues that we are more than willing to listen to the debate here. I'm speaking for myself, but I think for also other senator judges, and of course will give us much leeway. But there are certain issues that we also need time to study. So if we look at our rules of impeachment, suppletory kasi yung rules ng rules of court. And the difference between asking the accused to take the stand and asking someone who's not the accused, but we may say something that is incriminatory, there's a wide difference. So the accused, under the rules of court, hindi mo pwedeng i-force to take the stand. Pero yung hindi accused, they have to take the stand and wait for the question, and then they can claim the right against self-incrimination. But it could be argued that this isn't exactly a criminal court and a criminal offense. It's an impeachment court. So if it pleases the court, or if the prosecution is sure to ask for the subpoena, may I propose, Sir Presiding Officer, that both sides give us a memoranda in advance so that we can also do our part and study rather than spend much more time during the debates, because I'd really like to study that issue also. Thank you, and sorry for the interruption, Congressman.
Noted, Senator Cayetano. However, it is premature at this time. We will do what we did with respect to the motion for the issuance of subpoena ad testificandum and ducis tecum in regard to the bank accounts of the spouses Duterte and Carpio, as well as the AMLC records. We require the parties to submit a memoranda, and we will be scheduling it for oral arguments by the parties. If that is the desire of the Honorable Senator Judge Cayetano, we will do the same with respect to this once the motion has been filed formally by the panel of prosecutors. The Honorable Defensor is recognized. You may proceed, sir.
Thank you so much, Your Honor. Honorable Senator Judges, noong 22 ng Hunyo 2026, nagulat at nagdalamhati ang buong bansa sa pamamaril sa isang paaralan.
Sorry, excuse me.
Your Honor, may I be allowed to finish my manifestation? I will not disrespect and interrupt the defense counsel
but before
once he has started.
this is no disrespect, sir.
Counsel for respondent is recognized.
Thank you, Your Honor. Your Honor, this is improper. The improper for trial. Manifestation, this is not a manifestation proper for court procedure. This is instead them telling a story. This is a narration by the prosecution, which is not allowed. This is not allowed by any rule in any court. So what is proper is that they present their first witness, and
we will be presenting our witness, Your Honor. However, please allow us to freely advocate our position.
That's why, Your Honor,
including
we are
the defense when it's their turn. We will not object to the same.
Kindly let him finish.
Thank you, Your Honor. Thank you so much, Your Honor.
To respond to you. Yes, you were saying.
Thank you, Honorable Senator Judges. Noong ika-22
Honorable Defensor, kindly finish your reply to the objection of counsel for respondent.
Allow us to freely advocate our positions through the proper and respectful discourse. This is not prohibited under the rules. In fact, the court has declared that yesterday the rules will not comply with the strict procedures of a judicial proceeding. Each article is a separate complaint, and it would be the proper guidance for the senator judges, lalo na po sa ating mga kapwa Pilipino na nanonood, para mas lalo nilang maunawaan ang ipipresenta naming ebidensya. The impeachment is a sui generis. Sui generis dahil kakaiba ito, hindi ito judicial, administrative, o civil o criminal proceeding. Hayaan niyo po kaming bigyan ng 5 minuto para mailatag namin kung paano namin maipresenta at ang basihan namin sa pagpresenta ng aming ebidensya.
Your Honor, may I respond?
The presiding officer should rule. Although indeed we will interpret the rules liberally, and although indeed this is a sui generis proceeding, neither will we allow any dilatory moves and/or tactics, and I will bind and hold you to your 5 minutes, Honorable Defensor.
Absolutely,
and
Your
we will
Honor.
clock it.
Your Honor,
we will
may-
afford the same opportunity to the counsel for respondents when their turn arrives.
Thank you, Your Honor. May I proceed, Your Honor?
You may proceed.
Honorable Senator Judges, noong ika-22 ng Hunyo 2026, nagulat at nagdalamhati ang buong bansa sa pamamaril sa isang paaralan sa Tacloban City na ikinasawi ng 3 batang mag-aaral at ikinasugat ng marami pang iba. Ang mga salarin, mga minor de edad, sa kabila ng kanilang murang edad, agad na kumilos ang mga otoridad upang ipatubad ang mga umiiral na batas. Ang mensahe ay malinaw. Ang pagpigiging bata ay hindi nangangahulugang walang pananagutan. Ang pananagutan ay umiiral, bagamat iba ang paraan ng pagpapatupad nito sa ilalim ng batas. Kamakailan, isang pasahero ang inaresto sa airport at kinasuhan matapos itong magbiro na may bomba sa kanyang bagahe dahil mahigpit na ipinapatupad ng mga otoridad ang patakarang zero tolerance policy sa anumang pagbabanggit ng bomba o anumang pampasabog. Sa isang hiwalay na pangyayari noong Mayo 2020, isang public school teacher ang inaresto, pinusasan at kinasuhan ng NBI sa Zambales matapos magbiro na magbibigay ng pabuya sa sinumang papatay sa presidente ng Republika. Ano ang prinsipyo dito? Ang pananagutan ay pinapairal sa lahat, bata man o matanda, nasa laylayan man o nasa katungkulan. The prosecution comes before you today to present evidence for Article 4, establishing that Vice President Sara Duterte committed acts that betrayed the public trust, committed culpable violation of the Constitution, committed high crimes in publicly admitting through a live broadcast that she contracted someone to assassinate the President, the First Lady, and the former House Speaker. We acknowledge the burden of this trial on the senator judges as well as the Filipino people. But it is a duty that we must discharge together, lest the public come to believe that threatening public officials and fostering a culture of impunity are conduct that may be tolerated or condoned, especially coming from the second highest official of the land. Ang mga kilos at salita ng Vice Presidente ay hindi dapat ituring na simpleng krimen sa ilalim ng batas, kundi tuwirang paglabag sa saligang batas. Kaya ang paglilitis na ito ay mahalagang mekanismong itinakda upang tiyakin na ang kapangyarihan ay laging may kaakibat na pananagutan. Accountability must apply to all or none at all. At the heart of this impeachment proceeding lies a fundamental question para sa ating lahat. Can we continue to entrust one of the highest constitutional offices to a public official who, on multiple occasions, purposely and willfully and repeatedly resorted to threats of violence against the very institutions that she swore to uphold and protect? The evidence presented in this article are not just derived from testimonies and authenticated documents, but from the Vice President's own words, own conduct, her very own public admissions. Her words were neither accidental nor taken out of context. They were uttered publicly with the intention to be taken seriously. Huwag kang mag-alala, ma'am, sa security ko, kasi may kinausap na ako na tao. At sinabi ko sa kanya na kapag pinatay ako, patayin mo si BBM.
Your Honor.
si Liza Marcos, si Martin Romualdez. No joke. No joke. What makes these threats especially sinister is that they do not come from an ordinary citizen, but from the Vice President herself, an official who, under the Constitution, stands to succeed the President of the Republic. Such statements carry a gravity far from the exercise of one's freedom of expression. They strike at the very heart of government. This is especially significant given that she has publicly declared her intention to run for president in the next election. What values do we expect from those who occupy the highest office in the land? Delicadeza, palabra de honor, integrity, and loyalty to your oath of office. These are not outdated ideals. They are the foundations of honorable public office. Maraming salamat po, Your Honors.
The remarks of the gentleman are duly noted. However, Chair would like to inform and instruct the Senator Judges that the statement and manifestation made by the Honorable Defensor should not in any way be taken as evidentiary because it was merely a manifestation cum introduction of the fourth article of impeachment. Any evidence to be presented proving the fourth article of impeachment should be done through a witness under oath, duly subscribed, and subjected to direct and cross-examination. Call your first witness, sir.
Your Honor, may I be allowed also to... Your Honor, we move to strike that opening statement. It's improper for trial. It is not evidentiary in nature. And it only provides conclusions of fact and law. Most of it is irrelevant. And fact of the matter is, the prosecution should present evidence and not manifest in this improper manner.
May I be recognized, Your Honor?
No need. Motion is denied. Let it remain in the records and as instructed by the Chair for the Senator Judges not to consider, deem whatever statements were given by the Honorable Defensor as evidentiary in any way, shape, size, or form. Again, Counsel, call your first witness.
Your Honor, may I request permission to recognize counsel for the panel of prosecutors, Attorney Virgil Ligutan, to conduct the examination of our first witness.
Your Honor,
he will
may
be under the direct suspension and control
what is your pleasure?
of
Your
the
Honor,
panel
may
of prosecutors.
Register my continuing objection to the opening statement by the prosecution.
Well, I don't think he'll do it again, but nevertheless, so noted.
Thank you, Your Honor.
Your Honor, may I request that Attorney Virgil Ligutan be recognized to conduct the examination of our first witness.
Counsel for prosecutors, Attorney Virgil Ligutan, so that we can have the records clear. Did I pronounce your name correctly, sir?
Your Honors, magandang hapon. My full name is Attorney Armando Virgil Discartin Ligutan, Your Honor, please.
And you've entered your appearance yesterday,
Yes,
Counsel?
Your Honor. Duly entered my appearance as one of the counsel for the prosecution.
You may proceed, sir. Call your first witness.
Thank you so much. Mga kababayan, we call to the witness stand the first witness for the prosecution in the person of NBI Senior Agent Jean-Marc Santa Ana Calilo.
Kindly bring the witness to the witness stand. Please remain standing. Clerk of Court is instructed to kindly administer the oath to the witness.
Please raise your right hand. You, John Mark Calilong,
I, John Mark Calilong,
do swear
who swear
that the evidence you shall give
that evidence that I'll give
in the case now pending
is in the case now pending
between the Philippines
in the Philippines
and Vice President Sara Duterte
and Vice President Sara Duterte
shall be the truth,
the truth,
the whole truth,
and
nothing but the truth.
and nothing but the
So
truth.
help me God.
So help me God.
Your witness, Counsel.
Thank you so much, Your Honors. Your Honors, mga kababayan, the testimony of the first witness for the prosecution, NBI Senior Agent John Mark Santa Ana Calilong, is offered to prove the following. Number one, si Agent John Mark Calilong ay isang senior agent of the National Bureau of Investigation. Number two, he is well-trained and experienced in the field of digital forensic examination, having undergone extensive training in the field, making him competent in identifying, preserving, collecting, and authenticating digital evidence. Pangatlo, si Agent Calilong ay bahagi ng NBI Cybercrime Division Team na inatasang mag-imbestiga sa mga pahayag at pagbabanta ng Vice Presidente laban sa Pangulo ng Pilipinas, unang ginang at dating Speaker ng House of Representatives sa isang online media briefing noong Nobyembre 23, taong 2024. Pang-apat, partikular na sinabi sa publiko ng Vice Presidente na may kinontrata na siyang tao na papatay sa Pangulo, unang ginang at former Speaker ng House of Representatives. At ito ay nakatatak na sa kasaysayan ng ating bansa bilang unang pagkakataon na ang isang Vice Presidente ay nakipagkontrata sa isang mamamatay tao upang patayin no less than the President of the Republic of the Philippines. Panglima.
Your Honor, may I object? Is this a speech or an offer?
Your Honor, please, with all due respect to counsel,
For the prosecutor may proceed.
it should not be a
May I register my continuing
There's
objection?
no proper ground. This is offer of testimony. Please hold your horses. Number 5, the public statements and threats of the Vice President were publicly live streamed and captured on video. Number 6, Agent Calilong is a designated agent on case for the investigation. Number 7, as agents on case, Agent Calilong personally conducted and participated in the cybercrime and open source investigation relating to the subject video and related digital recordings. Pangwalo, sa takbo ng open source investigation na pag-alaman ng NBI na ang Vice Presidente ay nagpahayag din ng iba pang kahawig na pananakot sa buhay ng Pangulo. Kasama na ang sinabi niya sa publiko na minsan naisip niyang pugutan ng ulo ang Pangulo ng Republika ng Pilipinas. Number 9, in the course of the investigation, Agent Calilong duly identified, preserved, collected, and authenticated the subject video and other related digital recordings. At number 10, the last offer of testimony, Your Honors, Agent Calilong will testify on such other matters as may be relevant, material, incidental to the issues involved in this impeachment proceeding, and will identify relevant and material documentary and object pieces of evidence. That is the offer of testimony of our first witness, Your Honor, please.
Presiding officer will now hear the objection and or comments, if any, of the counsel for respondent to the offer
Prior to my-
made by counsel for the prosecution panel.
Your Honor, may we move for the exclusion of Agent Kalilong for being not previously attached to the Saballa and Cabrera complaints, as well as exclusion on the ground that he was not included in the articles of impeachment transmitted to the Senate Impeachment Court.
Can I respond to that, Your Honor, please?
Counsel for prosecutor may do so.
Mga kababayan, in this stage of the proceedings, the prosecution is about to present a witness, and the defense is invoking the fact that this witness is not listed as one of the witnesses in the Saballa complaint. The Saballa complaint already lived its natural life. Your Honor, this is the impeachment proceeding of the Articles of Impeachment filed by the House of Representatives. Saballa et al. Is done. That should not be a proper objection, Your Honor, please. As to the number 2, I think the good counsel mentioned that it is not part, this witness is not part of the Articles of Impeachment. Your Honor, please, I have been practicing for quite some time. I don't see that.
Your Honor, may I allow to reply also?
Can I finish? It's not a ground. And in fact, Your Honor, please, to settle the matter, this witness is listed in the pretrial order. The issue is settled. The issue is passé. No ground for objection. Let me proceed, Your Honor.
Of course not, Your Honor. There were no rulings.
Counsel
in the
for respondent is recognized
Thank you,
for
Your
a final rebuttal on this issue before the court will, before the chair will issue a ruling.
Your Honor, there were no rulings on the pretrial order on exclusion of witnesses. We have a current petition with the Supreme Court questioning the very actions of the prosecution to allow the presentation of evidence that were not attached to the Saballa or Cabrera impeachment complaints would allow the House of Representatives and the prosecution to circumvent the very procedural abuse condemned in Stonehill versus Jokno and allow the violation of the respondent's constitutional rights as held in Duterte in the House of, versus the House of Representatives. Your Honor, the prosecution says the Saballa complaints have lived their, and they died their natural deaths. However, Your Honor, this precisely does not cure what the prosecution did. This does not cure the violation of the rights of my client.
If I may, Your Honor, please.
The chair will make its ruling. The motion to exclude by the counsel for respondent is hereby denied. Chair cites Enrile versus Sandigan Bayan, which states that the prosecutors may add or rely on evidence during pretrial, even if the evidence is not stated in the complaint or articles, because only a summary is required to be stated in the articles of impeachment, in this case, and or complaint, and not a complete list of the prosecution's evidence and or witnesses. The court in general will not shackle the prosecution by limiting it to the evidence mentioned in the information and or the articles, especially when it is mentioned in the pre-trial brief, not only order but brief, of the counsel for prosecutors. But in relation to this witness, even if you will do cross, you can register your continuing objection, counsel for respondent.
We are registering it, Your Honor, please.
So noted. Counsel for the prosecution may proceed.
Thank you so much, Your Honor. John Mark Kalilong.
Your Honor, may I register my objections to the purposes?
Your Honor, please, I think the purposes must be specified. What are your objections?
Exactly,
On what
Your Honor.
grounds?
May I be
You
allowed?
may comment on the offer of the testimony of this witness for the record.
Your Honor, for the purpose number 3, this is a conclusion of fact and law. For the fourth purpose, it is also a conclusion of fact and law. And the 8th purpose, it is a conclusion of fact and law.
Mr. President.
Counsel for
President.
respondent, before we, yes, Senator Judge Cayetano.
Yeah.
Pia.
I would just like the defense, when you say item number 3, can you repeat what it is? Because I'm trying to follow exactly what your objection is. So either you say it or he repeats it so we can follow.
I was about to do that actually.
Thank you.
Item number 3 in the offer of this witness is that the NBI agent being presented is part of its cybercrime unit that investigated this matter. That's what you're referring to as a conclusion of law, counsel?
Sorry,
Perhaps number 4.
Number 4, Your Honor.
Yes, not number 3. So number 4 and what else?
Number 8, Your Honor.
Number 8 on other threats other than the video mentioned in the press briefing. Yes.
Yes, Your Honor. Correct, Your Honor.
Would that be all?
Yes, Your Honor.
We will not
Duly
reply.
noted.
We will not reply to that, Your Honor, please.
Yes, please.
May I continue, Your Honor, please?
You may continue to
John
present
Mark.
your first witness, counsel.
Thank you so much, Mr. Calilong. Reminder, nakikinig yung taong bayan, pakilakasan ng boses. Okay? Okay. Mr. Witness, maaari bang sabihin mo ano yung pangalan, edad, at other personal circumstances?
I am Senior Agent John Mark Calilong, a Filipino citizen, 31 years old, with office address at NBI Philinvest Cyber Zone Bay City, Macapagal Boulevard, Pasay City, sir.
And Mr. Witness, reminder, you may answer in Filipino or Tagalog or Filipino or English, okay?
Yes.
Mr. Witness, what is your occupation, if any?
Currently, nasa National Bureau of Investigation po ako. I'm an agent since 2021 and was recently assigned at Cyber Investigation and Assessment Center in April 2026.
Okay, you said that you have been an agent of the NBI since 2021, pero you were recently assigned to the Cybercrime Investigation and Assessment Center of the NBI. Now, ano ba yung position mo before you were assigned to the Cybercrime Investigation and Assessment Center, kung meron man?
In 2022, I was assigned at Digital Forensic Laboratory Division and in 2024 in Cybercrime Division, sir.
Okay, now, you said that you were assigned to the Digital Forensics Laboratory Division in 2022. Now, yung tanong, what is the objective, if any, if you know, of that digital forensic examination that you said you were trained to do?
To present digital evidence, sir, admissible in court na ginawa ko na po multiple times.
Multiple times. You appeared in court multiple times. Specifically, how many times?
At least 30 times, sir.
And for how long have you been practicing digital forensic examination?
2 years, sir.
For 2 years. Now, let's go back, Mr. Witness. You mentioned that you were an agent of the NBI Cybercrime Division in 2024. Now, what were your primary duties and functions as an agent of that Cybercrime Division?
To investigate cases in violation to the cybercrime law, sir.
Cybercrime law. Now, Mr. Witness, you are testifying in this impeachment case proceeding trial against the Vice President, the respondent in this case. Do you know the respondent in this case?
Yes, sir.
And why do you know the respondent in this case?
Because she is the Vice President and my team conducted an investigation involving her, sir.
So aside from being the Vice President, your team, you said, investigated the Vice President. The question now is, what was this investigation, if you know?
It's an investigation on the statement uttered by the Vice President during an online press conference briefing dated November 23, 2024.
So statements uttered by the Vice President in an online live stream press conference held on November 23, 2024. Now, yung tanong, ano ba yung naging participation mo, Mr. Witness, kung meron man?
I am the agent on case of the investigation, sir.
Now, sinabi mo ikaw yung agent on case. Now, you tell the court, you tell the public, ano ba yung pagiging ahente on the case? Ano bang ibig sabihin yan kung alam mo?
It means that I gathered evidence necessary for the investigation, sir.
Okay. You mentioned you gathered evidence. Now, you tell us, what do you mean kung meron man, tsaka kung alam mo, ano bang ibig sabihin when you quote gathered evidence, unquote?
It means that I viewed, identified, preserved, collected, and authenticated digital evidence in the course of the investigation, sir.
Okay, now, you mentioned na you viewed, identified, preserved, collected, authenticated, sinasabi mo mga pieces of evidence that you found in the course of your investigation. Tama ba? Yes, sir. Now, Mr. Witness, yung tanong is, ano ba yung mga ebidensya na nakalap ng inyong team?
One of the pieces of evidence that we gathered during our investigation is the video of the November 23, 2024 online press conference held by the Office of the Vice President, which was posted on the Facebook page of Harry Roque, sir.
Facebook page of whom?
Harry Roque, sir.
Harry Roque. Okay.
Yes, sir.
Mr. Witness, sinabi mo, you gathered. And then sinabi mo kanina, pag sinabing gathered evidence, sinabi mo, you viewed, identified, preserved, collected, and authenticated. Preserved, collected, and authenticated. You mentioned the term preserved, correct? Mr. Witness, yung tanong now is, ano ba ang ibig sabihin when you quote, preserved, unquote the evidence?
It means that I ensured that the evidence will be accessible at any time, sir.
Okay, now, let's go to this video you mentioned. The video of sinasabi mo yung isang online media briefing ng Vice President noong November 23, 2024. Ano ba yung mga hakbang, kung meron man, na ginawa nyo to preserve that video?
The NBI Cybercrime Division, through me, initiated a preservation request po kay Meta.
Okay, you initiated a preservation request to Meta. Now, sinabi mo kanina na live stream yung subject video sa isang Facebook page ng isang Harry Roque, di ba? Now, yung tanong, why is it that your request was made to Meta?
Si Meta po kasi yung parent company po ng Facebook.
Mm-hmm.
At under po ng Meta, si Facebook, si Instagram, tsaka si WhatsApp. All requests on that platform will go to Meta po.
All right, now, Mr. Witness, what proof, if any, do you have that you initiated a preservation request to Meta in order to preserve the subject video?
I have a screenshot of the preservation request, a screenshot of the web page wherein I made the preservation request, sir.
Who took the screenshot?
I did, sir, and I used my laptop.
Anong ginawa mo sa screenshot kung meron man pagkatapos dyan?
I first saved po yung electronic copy sa laptop ko, then printed it.
Where is this print out of the screenshot now?
Sinubmit ko po sa Committee on Justice of House of Representatives.
Your Honor, with the court's indulgence, may I move that this representation be assisted by a co-counsel for the sole reason of facilitating the presentation of the documents to the witness, Your Honor, please. For that reason alone.
Sa Tagalog siya mag-aabot?
Yes, Your Honor. Siya po yung mag-aabot ng mga dokumento na amin pong ipapakita for the witness to identify po.
Counsel may proceed.
Thank you so much. Assisted by Attorney Stephen Magallon. Now, if this printout is shown to you, will you be able to identify the same?
Yes, sir.
Now, we invite the defense to also peruse the document.
Your Honor, may I request that one of our counsels be allowed to peruse the document?
Yes, one of the
Thank you.
counsels for respondent may look at the document being presented to the witness.
May I continue, Your Honor, please? Thank you. Now, I'm showing you. Defense, can we give the document to the witness, please? Your Honor, the document must be presented to the witness.
Your Honor,
Give them some time to look at it, but is this one of the documents pre-marked?
Yes, Your Honor, please.
For the record, can you state the pre-marking of this document just so that we can catch up?
Much obliged, Your Honor, please. That would be P-Roman numeral 4-7 for the prosecution, Your Honor, please.
Noted.
Your Honor, may I manifest for the record that this is not a certified true copy?
Noted.
Your Honor, can I respond to that, Your Honor, please? This is an electronic copy. The rules on electronic evidence says a printed version of an electronic copy is an original. Your Honor, please.
Your Honor,
Counsel for the prosecutor, counsel for respondent did not object. He just simply made an observation regarding the document. So you may proceed as soon as the document is returned to the witness.
Thank you so much, Your Honor, please. What relation? Mr. Witness, are we ready? What relation, if any, does this document have with the printout of the screenshot that you mentioned?
This is the copy of the printout that was submitted to the Committee on Justice, sir.
Okay, Your Honor, please, may I proceed with the next question, please? Question, Mr. Witness, how faithful, if at all, is this printout from the actual screenshots?
The printout accurately reflects the screenshot, sir.
And how do you know now that this printout accurately reflects the screenshot?
I compared the printout with the screenshot and with the web page of my preservation and found that the contents are identical, sir.
Thank you so much. Now, Mr. Witness, ano ba ang nangyari kung meron man? At kung alam mo, after you made after you made the preservation to request to Meta in relation to the investigation you did on the Vice President?
Meta acknowledged our preservation request, sir.
Your Honor, please, the exhibits as they come, as they are identified by the witness, are also simultaneously being presented on the screen, Your Honor, please. Okay, you said that Meta acknowledged the preservation request, correct?
Yes, sir.
Now, yung tanong ay ano bang pruweba mo kung meron man that in fact Meta acknowledged the request?
I have a screenshot of the acknowledgement of Meta email acknowledgement.
Now, who took the screenshot?
I did, sir, and I used my laptop.
What did you do with the screenshot kung meron man?
Sinave ko muna po yung electronic copy ng screenshot sa laptop ko and printed it.
Where is the printout of the screenshot?
Sinubmit ko po sa Committee on Justice of House of Representatives.
Now, kung yung printout ng screenshot ipapakita sa'yo, will you be able to identify the same?
Yes, sir.
Now, we are now in the process of showing you yung isang printout ng isang screenshot ng isang tugon o reply ng Meta, Your Honor, that is previously marked as Exhibit P-Roman numeral 4-8 for the prosecution.
Annoyed defensor, clearly, emphatically laid down the prosecution's position that the grave threats issued by the respondent against the lives of the President, the Vice President, and the former Speaker of the House constitute a betrayal of public trust, culpable violation of the Constitution, and high crimes. I think maganda din ho ang nangyayari na-emphasize ho dito that this article is based not just on documents and testimonies, rather than the words uttered by the respondent herself. And maganda din ho yung naging reminder na kung ang mga simpleng mamayang Pilipino, tulad ho ng isang public school teacher na nagbigkas ng threat sa life ng previous president, pati ho ang isang ordinaryong citizen na gumawa ho ng bomb jokes ay mabilis hong naparusahan para dito. We should hold our highest officials to higher standards of morality, decency, and accountability. And nakita din ho natin kahapon, at we're very pleased that Attorney Ligutan was able to effectively present our first witness. As we've seen, despite the repeated objections from the other camp, which is of course to be fair with them, that's expected. They're doing their job, no? But we were still able to present the video footage that you wanted and all of this authentication documents. So for today, yesterday we were able to conclude the direct examination of our first witness, and today we expect the defense, no, to conduct their cross-examination.
Good morning po. Attorney Tolosa, there was a call to play the whole 2 hours of the video. Why shouldn't that be played in whole during the trial po?
It could be done, no? Like what the defense stated, right? They want to see the entire video para makita ho daw yung context, entire context when those subject utterances were made, when the threats were made. But as pointed out by Attorney Ligotan yesterday, and which was found to be correct by the presiding officer, no, discretion ho ng prosecution kung anong parte nung video na yon ang aming ipapakita. Now, if the defense on cross-examination would want all of us to watch the entire 2-hour video, then they can try to do that later on cross.
Sir, how would that affect yung expediency noong trial?
Well, as we could see, that's precisely the reason, no, why on direct examination we objected to that attempt, di ba, na to force us to have everyone sit there for more than 2 hours and watch it because we didn't find it to be necessary. But later, they'll probably try to do that, and we'll see how the impeachment court will rule on it.
Sir, what are we expecting for this afternoon?
As I've mentioned, no, they will cross-examine the witness, and this is their right, no? Ang trabaho ng prosecution, ilatag ang ebidensya, iyo po ang aming testigo. Under the process, under the rules of procedure, ang depensa naman ho, meron silang karapatan na mag-cross-examine ng witness namin. But we're confident, no, na tatayo ho ang ebidensya ang mga linalatag namin.
Yes, Paul, you have something to add?
Sa akin kasi hindi na bago yung video na yun. Siguro napanood na lahat ng tao sa hindi lang sa Pilipinas, baka sa buong mundo napanood na po nila yung senaryo na yun. Pero nag-rule naman po ang ating impeachment judges. Sinabi naman po nila na pwede pong gawin yun during the time ng defense. Klarong-klaro naman po yun. Pero pag umiikot ka naman po, nakikita, ang tagal na po nun. Ilang taon na? Ilang taon na ba yun? 2 taon? Klarong-klaro naman po, binalikan yung mga timestamps saka nung plinayback nila yung mga crucial saka importanteng part. Bago po nag-umpisa itong trial na to, nasa La Union ako umuwi ako Pag tinatanong po ako dito, hindi ako masyado nagde-dwell dun sa... alam kong equally important yung other articles, pero parang dito talaga may kurot yung sa grave threats. Kasi parang ang hirap namang depensahan nung direct threat na yun, yung open threat, sabi nga nila. Sabi nga, sa ibang bansa yan, nako, Secret Service ng nakaharap sa'yo Sabi, yung mga... Usually po kasi mga kakwentuhan ko, mga matatanda Ang sabi nila, nagdakes. Ang sama nung narinig nilang gano'n na open threat na ganyan, na manggagaling po sa matataas na opisyal. Although, ongoing na po itong ating trial. Yun naman po yung importante. Sabi ko nga, ito lang po yung proper na forum para ipaliwanag po lahat. At saka idepensa o ilatag man yung ebidensya. At napakalakas po ng araw ng kahapon, napakalakas po ng sigaw ng ebidensya. Thank you.
Is it possible for the prosecution to present the second witness later, sir?
It will depend. So what will happen is the defense will start their cross-examination when they're done. if necessary, we could also conduct a redirect examination, and then they'll also have the right to conduct recross. So depending on how long all of that will take, if there's enough time, and if the impeachment court will allow us, we'll be ready to present our second witness today.
Thank you po.
Anadi? Okay, Red.
Good morning po, Kong and Attorney. Kong, sabi po kasi ni Attorney Michael Powa, the defense spokesperson, na they're not counting the scores. Hindi naman nila binibilang yung scores kasi nga this was in reply doon sa sinabi yata kahapon ni Kong Sia na parang panalo na raw ang prosecution. Pero ang defense, they're saying na they're not counting down the scores kasi hindi naman daw ito parang parang di man daw ito boxing or it's still early in the game, ika nga nila. What's your take po doon sa sinasabi ng defense na it's too early to keep scores or keep tabs on this?
Should I take it first?
Yeah.
Okay. First of all, the prosecution is not claiming victory at this early stage. As we've stated, we've just said that we're pleased with how the first day of presentation of witness went, because despite the repeated attempts to stop us from presenting our evidence, we prevailed and were able to do that. Now, tama ho yun, kami, again, to be fair dun sa other party, they were just doing their job. I-expect naman talaga natin yan. They will raise objections. But fortunately, sa aming side, we were able to counter them, and impeachment court allowed us to present our evidence. So, naniniwala ho kami doon. Hindi ito paramihan ng objections at paramihan ng favorable ruling sa mga objections na to. Patibayan ho ng ebidensya to. And that's our goal.
1, 2, 3, 4. Ella, sa yugto ng cross-examination, nasa opposing
malakas
party
po kasi
na.
ang kiliti ni Kong Zia. So medyo nakiliti siya. Nakiliti siya kahapon.
May
Kasi
feedback konti.
alam naman po natin, halos magdadalawang taon na po to bago nagumpisa yung trial. So yung pagkasabi niya ng panalo, the mere fact na mapipresenta na po yung ebidensya, magkakaroon na ng trial, is a victory in itself. Klaro naman po yun sa prosecution, sa sentiments po ng mga sentiment survey, sa iba't ibang survey. Tansya ko po, kinilig siya ng konti. Pero again, as explained by Attorney Tolosa, mahaba po yung proseso. Kumbaga, these are the early steps. And sabi nga po, maganda na po na tumatakbo na po itong ating impeachment. It's a big first step for every Filipino.
One last na lang po on my end. Of course, nasabi din po ng defense na yung mga objections nila are it's a way of it's part of the process kasi nga yung iba daw doon sa mga questions niyo were leading questions or questions daw na answerable by yes or no po. And also parang marami din silang objections yun nga yung sa pag-play nga ng video kasi nga yung sa context po. Tell me po, attorney, do you think po ba or does it think po ba na the defense did too much objections na parang, or you think po ba that they are delaying the trial po?
Alam mo, read nila yan, tulad nga ng sinabi namin sa iyo kanina, di ba? In fairness to them, they're doing their job, They'll do their job, they'll try to object to our questions, and we'll do ours, which is to present evidence, di ba?
Okay, let's listen to Ma'am Milky.
Good morning, Attorney and Kong Pao. You were pleased, sabi nyo nga, with the results of day 2. How will you maintain the momentum of the hearing?
Well, we think there's only one way to do that, which is to keep preparing for the trial, for every witness that we will present, for every evidence that we will submit to the court. Yan lang naman ho yan. And I think, klaro naman, that's why we're pleased with how the first 2 days unfolded. This is a result of the hard work of and the months of preparations.
To second Attorney Jane, Actually, ang tinanong ko po dito si Attorney Lorna. Kasi syempre, kumbaga, seasoned na lawyer na siya. Sabi ko, Tita Lorna, nervous ka pa ba? Sabi niya, hindi. Pero I treat the smallest case as the biggest case. Tapos, preparation will outweigh everything. So, preps talaga. Yun ang number one na, yun lang ang laging parang advice niya o when I try to pick her brain na sinasabi niya na kahit anong kaso yan or anong bagay yan, yung paghahanda will always outweigh kahit anong iba to sa prosecution.
My request, sir, ang prosecution for Attorney Zuleika Attorney Zuleika Lopez to attend the hearing. Ito po ba is under the Article 4? At kung hihiramin ko yung term ni Congressman Paolo, makakadagdag ba ito sa kilig sa pagsubaybay sa hearing? Thank you.
Okay, yes, we confirm that we filed the request for issuance of subpoena to direct Attorney Zuleika to appear before the court. No? But it's still currently pending. We're waiting for the impeachment court's action on it. And we hope you'll understand, no, we can't yet delve into the merits and discuss at length what will be her testimony. No? So let's wait for that.
May kilig factor naman doon. Siguro nakakakilig na may mga familiar. Kasi nga, di ba, we used to have the hearings in the House sa Blue Ribbon and sa Quad. So, siguro nostalgic yung feeling. Parang ganun. Di ba? Love wins.
Magandang umaga po. Kenneth from Inquirer. Sir, matanong na lang din po pala, attorney. Cross-examination na kasi mamaya. Will the defense be allowed to pursue leading questions pagdating sa witness?
Yes, that's allowed on direct.
And
I'm
how-
sorry, on cross-examination, that's allowed.
After, sa redirect, pwede pa
Sa
rin po.
redirect? No.
Cross-examinations lang po talaga.
Yes.
And how will this affect the case po? Na allowed ang defense to put forward leading questions into the witnesses? And how is the prosecution preparing against efforts to weaken the evidence and the testimonies of the witnesses being presented?
Okay. That's normal, no? Sa lahat naman ho ng trial work, ganyan ho talaga yan under the rules of court, no? Leading questions are not allowed during direct examination. They're allowed on cross-examination, no? So that's nothing uncommon. So ang mga prosecutors natin ay handa naman ho sa ganyang klaseng proseso. So as you could see yesterday, it went smoothly naman yung presentation of our first witness.
Okay po. And with how the defense raised objections yesterday sa direct examination nga ng prosecution, with the manner how they conducted themselves, with the objections and all, do you think this offers a glimpse into how the defense plans to mount a defense of Vice President Sara Duterte?
Yes, no, again, this is something that we've anticipated from the start. This is consistent with their actions. No? From the time that this thing started before the House of Representatives, diba, they tried to block, no, from the impeachment proceedings from moving forward, filing petitions with the Supreme Court. Yesterday, diba, we all know that another Supreme Court, another motion has been filed with the Supreme Court asking for the issuance of the TRO to stop the impeachment proceeding from continuing, no? And even their answers, they raised affirmative defenses asking for the outright dismissal of the case based on technicalities and other legal arguments. So we were anticipating that, no, that they will try to prevent us from presenting evidence. But again, as I've mentioned, no, to be fair, syempre, that's their prerogative, no? Strategy nila yan, no? But kami naman, isa lang focus namin. We'll continue to present solid evidence to prove the articles of impeachment.
Okay po. And yesterday, the Vice President visited Senator Marcoleta po sa detention. Could this raise arguments against the senator serving as a judge in the trial? And should the visit cast any doubts on the senator's capacity to be impartial throughout the trial.
Kenneth, hindi ko na pang ihimasukan yan, no? And that's her prerogative. She can visit whoever she wants to visit, and we respect that.
Dagdagan ko na lang siguro, di ba, nostalgic nga tayo. Nung isang hearing ng Blue Ribbon noon, kung napapansin nyo, nung nawala po yung hopya ni Senator Marcoleta. Tapos kinain po yata ni dating Congressman Paduano yung hopya niya. Nung break po namin, napansin ko na may baon po na hamburger ang Office of the Vice President. May baon po silang Jollibee. Si Senator Marcoleta lang po ang binigyan niya na congressman ng cheeseburger nun. So siguro medyo may level of closeness sa pagkakaibigan sila without naman judging kung ano man ang relasyon ng pagiging senador or OVP. Siguro one of her BFF siguro kasi siya lang yung binigyan nga ng cheeseburger na congressman. Kami hindi binigyan.
Haji?
Good morning po. Good morning po, Kongs and Attorney. Sundan ko lang po yung tanong ni Kenneth na they will try to weaken the case. So, na-expect nyo po ba later that they will try to attack the integrity or the credibility of the witness that you presented yesterday?
They can try to do that, no? But at the end of the day, we're talking about video footage showing an interview given by the respondent, where she made the threats against the life of the President, the First Lady, and the Speaker of the House. So, as pointed out by Kong Pao, napanood na ho natin to lahat. No? So, regardless of the attacks that will be made on the even character of the or credibility of the NBI officer who authenticated this footage, I think medyo mahirap po sigurong ma-attack yung authenticity ng document itself. But I mean the footage itself. But of course, we don't want to preempt what they'll try to do in cross-examination.
What about po yung sinasabi nila na may sinusundang script? Na-expect niyo po ba na they will, kumbaga, try to establish na meron nga pong sinusundang script? Tapos syempre po, kumpiyansa po ba kayo dun sa expertise na meron si John Mark Calilong?
Okay. Quite frankly, that was uncalled for. No? And Attorney Ligutan properly called that out. No? Dahil napakalinaw naman ho, nung tinatanong yung witness about that document, kaya wala sa kanya, dahil pinasa ho dun sa depensa yung dokumento. No? So, but again, how they'll handle this trial, how they'll defend their client, no? That's their prerogative. Di natin ho pangungunahan kung ano magiging trial strategy nila dito.
Last question na lang po. Although it's their right to request na play nga po yung whole 2 hours ng press conference ni VP that time, do you think na yun pong ipinresent ninyo na 2 minutes and 18 seconds po would provide the context that the public needs or the senator judges need? Tapos po, kasi considering na before the answer of the Vice President, I think may question din po na ni-raise yung isa po na nandun sa press conference. So sapat na po ba yung konteksto na na-provide kung kayo po yung tatanong?
Again, as we've stated, if they want to play the entire video, that's their prerogative. No? Tignan natin kung papayagan sila ng impeachment court na panoorin natin pare-pareho for more than 2 hours itong entire video na to. No? So, but napakaliwanag naman ho, no? Kahit sang konteksto mo pabalik-balik ta rin kung ano ho yung mga sinabing pagmumura at pananakot sa buhay ho ng Presidente, ng First Lady, and ng Speaker of the House. So again, for us, we didn't see the need to play the entire video consisting of more than 2 hours. And what we showed is more than enough.
Saka napakaklaro naman na hindi splice, hindi edited, hindi AI, actual video with the timestamps. Pag nanonood ka naman ng championship sa NBA, pagkatapos ng laro, di ba, papanoorin mo yung highlights. Gusto mo yung winning shot ni Michael Jordan lang paulit-ulit mong papanoorin. So that's the money shot. Kitang-kita natin yun. Alam natin yun.
Pasensya na, medyo late ako pero magdadagdag na rin ako, no? Dadagdag na rin ako. So I got the question. I think it's not only about establishing the veracity and the authenticity of these video clips, but more important is what the effect of the threats that she made, no, against the president to the whole nation. Ano yung epekto nito? Hahayaan ba natin to na basta-basta na lang ma-express without accountability? Of course, you cannot also expect that the agencies will not do anything to investigate, because it was said in a manner by which it should be taken seriously. No, and the threat was done, directed not just for an individual, but it is directed against the head of state, head of government, and the commander-in-chief. That's why it is also a national security concern. That's why many agencies came in and investigated if there was indeed an agreement that was made and reached by the respondent and the hitman. Pangalawa, dadagdagan ko na lang po, the mere fact that she had that idea and made an understanding and agreement with the person whose livelihood is sourced out from killing people is already a betrayal of public trust. Kasi she is expected to uphold the law, she is expected to promote the rule of law, that no one should take justice into their own hands. Yun mismo yung alam niya na merong mamamatay tao at hindi niya ito pinagsabi sa mga pulis, sa mga ahensya ng ating gobyerno, at siya mismo ang nakipag-usap, that alone is a betrayal of the oath that she has taken prior to the assumption as Vice President of this land.
All right, Eden, your turn.
Good morning po. I-follow up ko lang po yun dun sa banta ni VP Sara. Dun sa presentation kahapon, na wala po kasi yung kapag pinatay ako. Kaya dun po papasok yung sinasabi ng yung conditional threat. At ito daw po ay hindi naman pumapasok doon sa Articles of Impeachment. Hindi po siya impeachable offense. Pwede pong pakipaliwanag natin sa ating mga kababayan.
First of all, to be accurate, I think the witness himself repeatedly stated that, no, nung tinatanong ho siya about dun sa mga relevant na portions ho nung interview, sinabi din ho niya yan, no, yung parte na yon bago siya sumagot, no, at pagkatapos yung buong statement ho na yan. So, nailad naman yun. And if the defense would want to emphasize that, they're free to do so. They can do that during cross-examination. No, but our position remains, no, that condition does not make the threat any less unacceptable. No, again, as pointed out by Kong Zia, this threat was made by no less than the person who will benefit, no, should it be carried out. Diba? It was made against the highest officer of the land by the person who will benefit if it happens.
Dadagdag ko lang, no? Remember, even before that response to a question during the Zoom conference, there were already interviews and statements by her indicating that is already that pattern. Puputulin ng ulo, di ba? Huhukayin yung dating Pangulong Marcos, itatapon sa WPS. So, kahapon po, pinresenta din po yan ng prosecution to prove that there is that pattern. No? Even prior to saying, to making these grave threats during the actual Zoom interview ng Vice President. But be as it may, no? Whatever context, no, whatever reason there may be, grave threats should not be tolerated. Whatever the consequence involved, whatever the circumstance, or yung sinasabi nilang context, para maintindihan daw. Contracting an assassin and having reached an agreement with an assassin is in itself a violation of the Constitution, being the second highest official in the land. That alone again, that alone is an impeachable offense. So it's regardless whether the context is, because of there's a rumor or a plan to eradicate a certain family, that does not even give justification to threatening the president, who is the commander-in-chief, the head of government, and the head of state, who, by the way, if that happens, she would be the one to stand to benefit from that.
Janeska?
Good morning, sir. Yung sinasabi lang po kahapon ni Presiding Officer Escudero, on photocopies po kasi ito, kasi the defense seems to be dun sa part na photocopies lang po yung tinetest, the documents being presented and as being testified by the NBI agent Kalilong, puro daw po photocopies. Tapos, hindi daw exactly pareho dahil yung isa may nakalagay na certified true copy. May sasabi siyang ganun. But I understand, ito lang kasi yung nakatch ko dun sa sinabi, sa ruling ni Senate, ni Presiding Officer Escudero, na this is, the prosecution is trying to comply with the requirements enunciated by the Supreme Court insofar as such pieces of evidence is concerned. Sabi ni Senator Escudero. Can you just expound, sir, why photocopies are as good as the original? Thank you.
Okay. Thank you for the question. No? Para mas maliwanagan tayo lahat. I think madami nagtatanong tungkol sa bagay niya. No? So under the new rules on evidence, malinaw ho yan. No? That there's a rule that we call the original document rule. Under that rule, duplicates, no, such as photocopies, are considered as originals, no, provided that there's no genuine issue regarding its authenticity. Now, kung ang riniraise lang ho, no, ng mga discrepancies ay merong marka na certified true copy versus ibang copy, that is not a genuine issue of authenticity that's being raised against it, because it shows that aside from that stamp or that marking, they're the same. It's a faithful reproduction of the original. So, yan ho yung konteksto na yun. No? I think sa social media, madaming nagko-question dyan sa bagay na yan, na ngayon ba, ang passport, meron nagsabing gano'n, no? Pwede ka na ba daw lumipad? Dala mo yung photocopy. Hindi ho gano'n yun. No? Ang sinabi ni Atty. Ligutan, yan ho ay nakabase sa rules on evidence. No? Sa pagpepresenta ng mga dokumento sa korte, again, under the updated rules on evidence, hindi na kailangan na palaging original ang document ay pepresenta mo, subject to the conditions that I've mentioned.
Thank you, sir. Yan lang po from my end. Thank you.
Marian, your turn.
Good morning po. Yesterday po, si Presiding Officer Jesus Cordero, kinonfirm po niya na yung 16 po votes for the two-thirds threshold po yung formal ruling na ng impeachment court. Well, of course, subject pa raw po. So, any legal remedies available to the parties? Questionin po ba ito ng prosecution sa Korte Suprema, lalo na may initial statements po, even you, Attorney Tolosa, Lead Prosec Luistro, considering yung interpretation nga po ng Avellino doctrine?
Well, first to clarify, I've never stated yet our official legal position on this two-thirds issue, because I've always said that it will be improper for me to discuss, our legal position on that, because it was premature at that time, But well, first of all, I'd like to emphasize that our stand on this has been consistent, from the very start. We don't engage in vote counting. Focus namin dito to establish an airtight case backed by overwhelming evidence, so that at the end of the day, no matter how this two-thirds threshold will be interpreted, we'll be able to secure that necessary vote. Okay. As to the legal steps that we may take regarding this matter, it's still under deliberation and discussions by the panel of prosecutors, and let's see how we'll address that issue.
Idadagdag ko lang, I think during the early part of this impeachment process, it also came out the possibility of reinterpreting. But these are ideas and legal opinions that did not emanate from the House Prosecution Panel. It actually came from other personalities who are very much known to be in the legal community. Sinabi naman from the very start ng ating lead prosecutor na si Congresswoman, sabi ng ating lead prosecutor ay kapangyarihan yan ng korte kung may constitutional issue at may controversy. Again, hinayaan doon din natin yung proper na forum at proper na venue para pag-usapan ito. Basta very clear po yung sinabi niya, we will not make any official or formal request before the impeachment court to reinterpret the constitutional requirement of a threshold to reach the judgment by the impeachment court.
Go ahead.
There are no discussions about that matter, no. But because as we've stated, no, we're really focused on just presenting solid evidence before the impeachment court. No? So at the end of the day, if it's 16, then we should be able to get 16.
So, as of now, is that maybe the stand po ng prosecution? You will never bring this to the Supreme Court?
As I've stated, no, there's no decision about that matter yet, and quite frankly, that is not included in any of our priorities. Again, our priority right now is focus on the trial and focus on continuing to prove our case by by presenting evidence.
Just to clarify, Marian, because you were there during the press con when I was with Kong Jinky and Congresswoman Bella Zamora. Remember there was a question whether the House Prosecution Panel will be contemplating on filing for an official or formal request before the impeachment court to readjust or reinterpret the threshold 16. And it was very clear by the response of Congresswoman Jinky that the House Prosecution Panel will not request or make any official request before the impeachment court to readjust the threshold.
Again, in the realm of possibilities, that's a remedy that's available to us under the law and under the rules. But as I've stated, are we discussing it? At this moment, we're not. Is that among our priorities? It's not. Again, our priority is to continue to present evidence before the impeachment court.
Dadagdag ko lang, just so we can clarify the position. Just we can clarify. The one that we're saying and the one that is referring to by Congresswoman Jinky is the Honorable Impeachment Court. If we talk about the Supreme Court, that's a different venue altogether. And it's very evident by the way the House Prosecution Panel approached this trial. Una, nagpresent ng kaso, and never did we intimate or reflect in our position in the pre-trial brief that there will be a possibility that we will file a formal request. Never. And that is consistent with what the lead prosecutor, Congresswoman Jinky Luistro, said in the previous briefing that we conducted in the House at the House of Representatives.
Sir, were you there po all throughout the trial nung I think meron pong comment si Attorney Ligutan, pinuna po niya yung gumawa raw ng eksena, may scene, nag-walk out daw. Kumbaga ito si Attorney Sheila Sison. Can you walk us through? Baka maalala niyo ano yung nangyari kahapon.
I think there was this moment when Attorney Ligutan was responding to a question posed by Senator Risa, right, about the materiality of the evidence being presented yesterday. And I think at some point, the lead defense counsel stood up, so Attorney Ligutan pointed out that it seems that statements were made which were directed to him, but In fairness to the other camp, they clarified that there was no attempt to walk out and they were just trying to go to the comfort room, I think. So we don't want to make much out of that incident. It's already been settled yesterday.
Last na lang po. Follow-up lang po dun sa question ni Ate Eden, do wala na kasi siya. I think baka pwede lang po natin bigyan ng emphasis yung gaano ba kabigat. Kasi po parang ang argument is that conditional threats siya eh. So parang paano siya naging impeachable offense? Ang grave threats ba will fall under high crimes too? Baka hindi lang siya betrayal of public trust, culpable violation of the Constitution. Can you emphasize on that?
Okay. So, again, as pointed out by Kong Zia a while ago, let's remember that the statements made by the respondent, she admitted that she already had an agreement with the assassin. An agreement to end the life of no less than the President of the Republic, the First Lady, and the then sitting Speaker of the House. So, no amount of condition or any other context that they would want to offer will justify that. That would make that right. That is the position that has been made clear in the opening statements made yesterday and even in the answers given by Attorney Ligutan to the questions posed by Senator Riza.
Sir, quick follow-up lang po dun sa tanong ni Ate Janesca. Outside trial lang po, how are you handling or countering lang po yung misinformation and misunderstanding? Kasi kahapon nga po medyo tumatak talaga yung sinabi ni Attorney Ligutan doon sa photocopies being considered original, and meron din po kasing mga nagpo-post din online na nagpo-photocopy nga po ng pera and then sinasabi na pambayad ng Meralco. Paano nyo lang po nakakounter yung mga ganong misunderstanding or misinformation?
Ako na? Ikaw? Hindi kasi yan, marami tayong great philosophers sa mundo ngayon, di ba? Siyempre, meron silang mga chat GPT na pang-reply nila, saka pang-sagot nila. Marami silang tools to make them great philosophers as well. Tuloy ko lang yung sa grave threats, di ba? Wala yatang universe na magsasabi na hindi po grave o mataas na krimen ang i-threaten ang buhay ng pamilya ng Pangulo ng Pilipinas o kahit saan bansa man. Parang walang magdi-disagree nun, except the great philosophers. Pero yung mga pilosopong yan, at saka yung mga henyo na nandyan, kahit nga dun lang sa word na grave threats, pwede mo nang kunin yung sagot eh. Di ba? Grave. Ano yung kasunod ng grave? Threat. Ano yung grave? Libingan. Di ba? Kung kukunin mo yun, grabe. Kung tatagalugin mo yung grave, grabe. Grabing threat. So, kahit na pilosopuhin mo rin yung sagot, wala rin sila mapapalusot kasi it's just there. Nakalatag na kaya. It's so obvious na anong palusot pang hahanapin mo dyan sa mga ganyang bagay. Now, in terms of the photocopy, in-explain na rin ni Attorney Tolosa na yung mga ganyang ebidensya, inaalaw po ng ating korte. Kung yung mga great philosophers, saka yung mga great na nagtatanong, gumawa sila ng sarili ng rules sa korte. Doon, papasa siguro yung mga gusto nila mangyari. Pero, ang hirap pong ipaliwanag, yung bagay na hindi na kailangan ipaliwanag. Marami pong bagay na will speak for itself. At itong article po na to, itong grave threats na to, may sariling buhay yan, hindi na kailangan ipaliwanag yan. Semantics na lang po yung nilalaro nila dyan. Salamat.
Well, ang mabuti naman doon, kasi we always look at the bright side. No? Even if these are things that came out from the social media na medyo pabiro, isa lang ibig sabihin yan, nakatutok ang taong bayan at nakikinig sila. And that is what important, the important thing that we need to realize here. No? Pero sinabi nga kanina ni Attorney Jay, huwag niyong isisirok sa mga pera niyo tapos bumili kayo ng mga supermarket na hindi tatanggapin yan. Kasi fake yan, fake monetary yan. Minsan, nakita niyo po sa mga cashier, nakapaskil dyan yung mga peke na pera, baka naman mahuli pa kayo. So huwag niyo hong gagawin yan, ha? So, pangalawa, kaya nga po tayo dito sa prosecution panel, apart from presenting the evidence in the open court, gumagawa ho tayo ng conference or press briefing tulad nito. Dahil importante po ang importante po yung participation ng media dito sa ating bansa. Lalong-lalo na po itong impeachment trial. Dahil ang media po ang nagbibigay impormasyon para bigyang kasagutan yung mga tanong ng ating taong bayan as we move along with this trial, no? Isa po ito sa mga paraan kung paano na ho natin na papaliwanag sa kanila kung ano pa yung napapakinggan nila doon sa actual trial na ito. Pero alam mo, nagpapasalamat po ako sa kanila. Dahil maski pabiro po ito, ibig sabihin ay interesado sila na makinig at subaybayan ang ating trial. Pero ang sa legal naman, na-explain na po yan ni Attorney Jay, ito po yung sa korte, ito po yung sinasabi na paano i-presenta yung mga ebidensya mo na kung hindi siya true copy, at least photocopy siya, i-attest naman yun ng korte. Huwag niyo gagawin yan kasi inaalaw lang ho yan sa actual na trial. Pag bumibili ho kayo ng shampoo, hindi ho actual trial yon. Pagbibili po yun ng inyong mga grocery items. Huwag niyo ho yung gagawin yan dahil baka hulihin ho kayo ng security guard ng shopping mall.
Kaya maraming salamat po sa mga great philosophers, sa mga nagko-comment, sa mga trolls, sa mga bashers. Kasi, alala nyo, ewan ko, naalala po ng House Media. Salamat po dahil nananatiling buhay ang usapan ng impeachment. Pero nandito na tayo ngayon, nag-umpisa na yung trial. Dati kasi parang papasok pa lang tayo doon. So, salamat. Thank you.
Joy?
Hindi, maliwanag naman ho yan na ang impeachment proceedings, no, ay hindi ho criminal in nature, no. Kaya ho ang tinatawag sa Vice President dito ay hindi ho accused kung hindi ho respondent, no. So hindi ho nag-a-apply yung quantum of evidence na required ho dyan, no. And hindi din ho nakalagay sa Constitution o kung saan mang rule kung ano ho ang i-apply na quantum of evidence dyan, no. Although I think it was, if I remember correctly, it was mentioned by the presiding officer that he would want to apply, no, the requirement of clear and convincing evidence. If I remember correctly, no, that we'll have to check that. But at the end of the day, tingin ho namin, ang pinakamaliwanag na batayan dito ay kung hindi ho yung maghusga base sa ebidensya na linatag ng magkabilang partido.
Idadagdag ko lang po, yung penalty if ever po na conviction ang ma-arrive ng korte, wala naman pong jail time ito. Ang magiging penalty po ay removal from office and perpetual disqualification from holding an office. Kaya hindi po siya tulad ng, and then Attorney Jay can correct me on this, hindi po siya tulad ng regular criminal proceedings na beyond reasonable doubt yung dapat na ma-prove ng prosecution. Dito po is kung may papakita po na meron talagang paglabag sa Constitution at sabi nga po ng ating presiding officer, yun naman talaga yung quantum of evidence required in the impeachment trial, maaari po natin masabi na the conviction is obtainable.
Okay, thank you, Joy. Yes.
Mahilig siya sa blood. Yun yung napansin ko. Baka pati yung order sa bar, Bloody Mary. So, parang yun lang yung... Kasi one-liner lang eh. Tapos, nag-move out na. So, it's open to interpretation. So, interpretative dance. So, umalis na. So, again, sabi ko nga, alam ko talaga na medyo hindi siya mag-a-attend talaga ng hearings eh. So, siguro nag-ano lang siya. Nagparamdam. Parang clickbait nga. Pagka-click mo ay, iba naman pala yung nangyari, iba yung laman. So, yun lang. Mahilig siya sa blood.
But matagal naman po natin sinasabi ang House Prosecution Panel that this is the perfect venue for the respondent to clear her name. If the defense truly believe that she has that, they have that, they have the answers in order for the public or for the respondent to clear her name. This is the perfect opportunity to do so. At hindi naman ho namin yan sinasabi na kami lang yung nananawagan. Sila ho mismo, sinabi ho nila in the previous months, no? Na ready na ho sila, they will answer the allegation. But be that as it may, again, the answering the allegation is answering directly whether or not she has ordered the way by the utilization of the confidential funds, which according to COA is outside of their joint circular. So therefore, there's a violation on the utilization of funds. We have not heard her deny that, no? So these are the questions that the people want to hear from her, no? Kasi siya po this is her trial eh. Pero yung mga quotations po taken out from a popular poem, pero sa akin po, parang it appeared and it sounded like a Game of Thrones inspired punchline, ay hindi po yun ang kasagutan at hindi po yun ang inaasahan ng mga tao na yun yung sinasabi nilang handa silang sumagot sa proper forum. Unfortunately, the public also is yet again disappointed.
Okay, we'll entertain last two questions kasi po may schedule pa sila after this. Okay, go ahead.
Let's see. That's a matter of strategy, that of course you would understand. We cannot discuss with you, but let's wait and see for it.
But sir, right now, just a follow-up, do you see any challenge to subpoena or to compel the Vice President to take the witness stand? Kasi ngayon pa nga po, hindi po natin siya, hindi siya dumadalo ng trial. So, how challenging would it be for the prosecution to compel to take the witness?
Okay. Well, as I've mentioned a while ago, this is not a criminal case. In a criminal case, because of the right against self-incrimination, the prosecution cannot call into the stand the accused herself as witness. But again, the respondent's not an accused here, she's a respondent. So when that time comes, if and when we file a request for issuance of subpoena directed to the respondent herself, let's see how the impeachment court will act on it.
All right, thank you. Rosalie, for final but not...
Mag-pound lang po ako dan. Sufficient evidence na po yung videos ni VP Duterte making grave threats against the Vice President. Why there's a need to present her as a hostile witness?
Again, let's not preempt the issue. And if we will call her as a witness, that's not necessarily mean that it will be confined to the articles relating to grave threats. So, but siguro for now, hintayin muna natin. Baka it's too early to talk about it. Let's go about it in detail when the prosecution actually files a request already for issuance of subpoena.
Dadagdag ko lang, Ross. The beauty about the trial is every day, nagkakaroon ng clarity as to the procedure and what is acceptable to the court. Si Attorney Kapunan intimated that before the court because of the 5-day ruling. At least it's very clear that the clarification of Attorney Kapunan was entered into the record for the court also to contemplate on the possibility of allowing such presentation of witness. It's either material or hostile witness. So yun po yung ginawa ni Attorney Kapunan, para clarity for both the prosecution and the defense vis-a-vis the 5-day ruling of presenting a potential evidence, subject to the 5-day ruling that you have to inform the court and as well as the opposing side. So that is just a manifestation that Attorney Kapunan raised before the open court, so that for the purpose of clarity.
Pero hindi nyo naman po ini-intend na pagsabaying i-present or pagsunuring i-present si Attorney Zuleika Lopez and the Vice President. For example, next week, because you have already filed a motion for subpoena for Attorney Zuleika Lopez.
Tignan ho natin, matters like that or matters of trial strategy that fall upon the exclusive discretion of the prosecution. So let's wait and see.
Very last na lang po, sir. Some observers, including po Representative Antonio Tino, said ang defense team, ang strategy nila magbato ng objections and delaying tactics. Do you agree with this observation po?
Well, ayaw naman nating mag-ascribe ng any ill intentions dun sa other party, But we're all of us. So what happened yesterday, and we can make our own judgments about it.
You're happy with the...
Dadagdag ko lang kasi we observe that also. Again, it's the right and the strategy of the defense, both sides. We also expect that the prosecution will also be raising objections pag time po ng cross-examination. And that's the regular occurrence in an actual trial. What is important is napakita po ng House Prosecution how ready we are, how, the prosecution panel, yung pag-examine sa witness, did a very stellar job. Naipresenta sa korte, pati na rin sa publiko. And no matter the strategy or the yung sa defense, hindi na butasan yung ebidensya. At napakita natin na meron siyang expertise at credible siya para maging witness na matest niya itong mga videos na to ay hindi doctored at kinolekta nila to, pinreserve nila ito. So yun ang very important na nangyari kahapon.
Very last follow-up. So do you see their strategy failing po?
Well, it's too early to make any judgments about this, But what we can say is, despite the repeated attempts to block us from presenting evidence, we were able to do that yesterday. Rod, before I end it, even though Red already left, I think it's just proper that we give Kong Zia the opportunity to address the question because it was directed to him a while ago. Although we responded to it, baka mas maganda siya makapagbigay ng kaliwanagan.
Yes, Kong. Sinabi mo na you secured panalo kahapon.
And we explained na you were not talking about it as a whole and you were just yesterday.
Okay.
But
So
baka, to be fair, maganda
okay,
ho,
let me clarify. When all of us witnessed what happened yesterday. When I say we claim victory, I do not refer to the actual specific day that we have presented our case. That would definitely dictate, for example, the outcome of this whole trial. What I'm trying to prove to the public is that for the longest time, the House of Representatives has been doing, the House Prosecution Panel has been doing, all the efforts that we exerted for the trial to proceed. Because we believe that this is about accountability mechanism of the Constitution. This is upholding and preserving and promoting the Constitution. And for that premise, we are victorious because the purpose of this impeachment is to serve the Filipino public. And whatever is the way and means by which to serve the Filipino public is victory to the Filipino people.
Ang sinabi ko, kinilig ka lang eh. Na-excite ka. Oh.
I would not deny. Lahat naman talagang masaya din sa nangyari. Masaya sa nangyari.
All right.
Okay, so where's Red?
All right, on that note, sana masaya tayo lahat for this press conference and we want to see you again. We welcome you again tomorrow for another press
Thank you again, everyone. Thank you.
Have a bloody good afternoon, guys.
ng Metro Manila. Ayon sa MMDA, tiniyak nila na lahat ng 73 pumping stations nila ay gumagana at may sapat na supply ng petrolyo at kuryente. Habang may mga tauhan na rin ang ahensya na nakatalaga sa mga flood-prone area upang linisin ang mga bara sa mga daluyan ng tubig na siyang nagdudulot rin ng mga pagbaha. Nanawagan naman si Mayor Zamora, presidente ng Metro Manila Council o MMC, sa mga LGU na ngayon pa lang ay putulin na rin ang mga sanga ng puno na posibleng bumagsak dahil sa sama ng panahon. Gayon din ang pagtatalaga ng mga emergency response equipment at food pack, partikular na sa mga low-lying areas sa kani-kanilang mga jurisdiction. Pinauubaya naman ng Metro Manila Council sa mga lokal na pamahalaan sa Metro Manila ang pag-aanunsyo ng suspensyon ng mga klase sa mga eskwelahan, lalo pa yan sa Biyernes. Mula dito sa Pasig City, balik sa iyo, Ella.
Maraming salamat, Asher Kadapan Jr.
Isinailalim na sa Blue Alert status ang buong lalawigan ng Aurora simula ngayong araw. Ayon sa Provincial Disaster Risk Reduction and Management Council, 24/7 na sa ilalim ng Blue Alert ang monitoring at full interagency coordination sa Emergency Operations Center sa Barangay Suklayin, Baler. Kasama sa mga hakbang ang mahigpit na pagbabantay ng response clusters, pagtitiyak sa relief supplies, medical resources, emergency communications at deployment ng heavy equipment. Ipapatupad din ang no fishing, no sailing at no water activities policy sa buong lalawigan bilang preventive measure.
Habang patuloy na binabantayan ang antas ng tubig sa mga dam, dumaraing naman ang mga magsasaka sa San Jose, Nueva Ecija dahil sa kakulangan ng patubig. Ang iba ay gumagamit ng water pumps para lamang mapatubigan ang kanilang mga palayan. Alamin natin ang balitang yan ni Grace Doctolero live. Grace, ano ang sitwasyon ng mga magsasaka sa San Jose, Nueva Ecija?
Yes, Ella, bagamat may mga patubig pa ring dumadaloy sa ilang sakahan, may mga magsasaka nang umaasa sa water pump upang may pagpatuloy ang kanilang pagtatanim dahil dito lumalaki rin ang kanilang gastusin sa gitna ng mataas na presyo ng mga input sa pagsasaka. Nanganganib na malugi at mabaon sa utang ang mga magsasaka sa San Jose, Nueva Ecija kapag hindi naging sapat ang patubig sa mga susunod na buwan. Anila, hindi sapat ang paglalagay ng mga abono kung kulang naman ang tubig dahil tiyak na maapektuhan pa rin ang kanilang ani.
May bibitin po kami sa patubig at ang epekto po niyan sa aming palayan, siyempre hindi po masyadong aani ng marami yan, hindi masyadong kakapal, hindi masyadong tataas. Kahit lagyan mo ng maraming fertilizer kung kulang naman sa tubig, maapektuhan po yung ani.
Bukod sa pangamba sa ani, may mga magsasaka ring umaasa na lamang sa water pump para mapatubigan ang kanilang mga palayan. Dahil dito, nadaragdagan ang kanilang gastusin sa pagsasaka habang nananatiling mataas ang halaga ng mga pataba at iba pang kailang gamitin sa bukid.
Tapos ang pinakamahirap talaga, pataba. Yun ang dinadaing ng mga magsasaka, pataba. Pero kung marami kang ipapataba at tinamangan ka ng kalamidad, doon ka malulubog sa utang. Yun ang pinakamahirap.
Umapila naman ang mga magsasaka sa pamahalaan na mas mapalakas pa ang mga proyekto sa patubig at may pagpatuloy ang mga programang makatutulong sa pagkaiwas ng gastusin sa pagsasaka, lalo na sa gitna ng banta ng Super El Nino. Patuloy namang umaasa ang mga magsasaka na mananatiling sapat ang supply ng tubig sa mga susunod na buwan upang maiwasan ang malaking pagkalugi sa kanilang mga sakahan. Yan muna ang balita. Balik sa iyo, Ella.
Maraming salamat, Grace Doctolero.
Sinimula na ngayong araw ang kauna-unahang simultaneous national kick-off school-based feeding program and milk feeding activity ng Department of Education. Programa ito ng pamahalaan upang mapakain ng libre ang mga grade school student, lalo na ang mga malnourished na mga bata. Mula sa Pulilan, Bulacan, may ulat si Nestor Torres live. Nestor, gaano naman katagal itong universal feeding program sa mga estudyante at ilang araw ba sila papakainin sa mga paaralan sa bansa?
Magandang tanghali, Aga. Ang nasabing school-based feeding program sa mga paaralan ay tatagal ito ng 180 days. Malaking tulong ito lalo na sa mga estudyante na kadalasan ay pumapasok na walang baon sa paaralan. Dati ay mga estudyante na kulang sa timbang at malnourished ang nakikinabang sa feeding program ng pamahalaan. Pero ngayon, sa kauna-unahang pagkakataon, ay sinimulan na ni Pangulong Ferdinand Marcos Jr. ang simultaneous universal school-based feeding program sa mga kindergarten at grade 1 sa mga school sa bansa hanggang grade 6. Sa launching ng programa, nagtungo si Pangulong Marcos sa mga estudyante sa paaralan ng Pulilan Central School sa bayan ng Pulilan, Bulacan. Pinangunahan ng Pangulo ang National School-Based Feeding Program at namigay rin ng gatas sa mga bata.
Ay dati namimili tayo kung sino ang bibigyan. Dahil namimili tayo kung sino yung mga undernourished, sino yung mga kulang ang pagkain sa bahay. Ngunit ngayon ay ginawa namin para mas madali ay lahat na lang na pumapasok ay papakainin namin. Kaya para tiyak na lahat ng ating mga kabataan ay handa na mag-aral, handa na pumasok, makapag-aral na mabuti at hindi inaalala ang kanilang kakainin.
Katuwang naman ng pamahalaan sa programa ang Department of Education, Department of Agriculture at Local Government Unit. Ayon sa Pangulo, tatagal ang pagpapakain nila sa loob ng 180 days. Kabilang sa mga libreng pagkain ay mga hot meals, iron fortified rice at may luto pang ulam. And enhanced Nutriban at milk nutrition food sa naipapakain sa mga kinder at grade 1 student at maging sa hanggang grade 6 undernourished, severe wasted at wasted na mga malnourished na mga bata na below normal ang timbang at height. Samantala, may nakalaang budget naman ng pamahalaan sa nasabing programa.
School cycle. Ibig sabihin yung buong school year, 180 days minimum, papakainin yung mga bata. Tapos yung sa grade 2 sa grade 6, tulad ng dati, yun yung malnourished at undernourished, yun ang papakainin. So, yun naman, year to year ang budgeting natin. So, kami aapela muli sa ating opisyales at syempre sa legislatura na pondohan ito, napakagandang programa.
Para kay Pangulong Marcos, mahalaga sa kanya ang ganitong school-based feeding program para sa kalusugan ng mga estudyante na makakain sila ng masustansya at ligtas na pagkain. Karamihan naman sa mga pagkain na inaangkat nila ay mula sa local products at sa mga probinsya. Kabilang na nga yung mga gulay, mga dairy, milk products na galing sa mga magsasaka. At yan muna ang ating latest live mula dito sa Bulacan. Balik sa iyo. Aga?
Maraming salamat, Nestor Torres.
Nakataas ngayon ang signal number 1 sa ilang lalawigan sa Luzon dahil sa posibleng epekto ng Super Typhoon Inday. Kagabi nang pumasok sa loob ng Philippine Area of Responsibility ang malakas na bagyo. Alamin natin ang iba pang detalye ng ulat panahon mula kay Engineer Chris Perez, ang Assistant Weather Services Chief ng Pag-asa.
So sa latest satellite imagery animated ngayong umaga, mapapansin po natin offshore pa rin or malayo pa rin sa kalupaan ng ating bansa ang bagyong si Super Typhoon Inday. Pero mapapansin natin na patuloy itong kumikilos. Yung mga outer cloud bands nito, bagamat manipis dito sa portion, ay nahagip na ilang bahagi ng ating bansa. At kanina alas 10 ng umaga, ang Super Typhoon na si Inday ay tinatayang nasa layang 1,270 kilometers ang layo east of Northern Luzon. Taglay nito ang lakas ng hangin na umabot hanggang 195 kilometers per hour. Malapit sa gitna at ang pagbugso, abot hanggang 240 kilometers per hour. Kumikilos naman sa direksyong west-northwest sa bilis na 20 kilometers per hour. So mapapansin natin, napakalawak ng kaulapan nito at meron pang mga ulap dito sa may bandang central at southern part ng ating bansa. Yan naman po yung pinag-ibayong habagat or southwest monsoon. Pero uunahin nating himayin yung mga wind signal, associated hazard, dahil sa super typhoon na si Inday, susunod naman kung ano inaasahan natin pag-ulan, dala ng pinag-ibayong habagat. Sa patuloy na paglapit ng super typhoon na si Inday sa kalupaan nating bansa, nakataas po ang Tropical Cyclone Wind Signal number 1 sa mga lalawigan na naka-highlight ng light blue dito sa ating mapa. Sa lalawigan ng Batanes, Cagayan kasama ang Babuyan Island, Apayao, Kalinga, Isabela, northern portion ng Aurora, dito sa northern at central portion ng Catanduanes, northeastern portion ng Quirino, eastern portion ng Ifugao, Ilocos Norte, eastern portion ng Mountain Province at northern portion ng Abra. Pag may wind signal po, number 1 po tayo, ibig sabihin, posibleng maranasan natin yung lakas ng hangin mula 39 hanggang 61 kilometers per hour with a lead time of at least 36 hours. So, it doesn't necessarily mean na may epekto agad sa mga oras ito. Binibigyan po tayo ng konting palugit, 36 hours or less, para mapaganda natin yung actual na lakas ng hangin na posible nating maranasan sa ating locality. Kaya sana po, wag magtakay mga kababayan natin na sasabihin nila naka-wind signal number 1 tayo, pero generally good weather po sa kanilang lugar. Paunang abiso po ito para sa paparating na hazard or lakas ng hangin na pwede nyong maranasan in 36 hours or less. Ngayon, sa pinaka-latest forecast track ng Pag-asa, base sa ating Tropical Cyclone Bulletin, mapapansin po natin ang current location ng super typhoon na si Inday at sa susunod na 4 na araw. Bukas nga ng umaga, inaasang nasa 875 kilometers silangan ng Northern Luzon. Sa darating naman na Biyernes ay nandito sa 515 kilometers silangan ng Itbay at Batanes. At sa darating na Sabado ng umaga, halos nandito na sa northern boundary ng ating air responsibility. 470 kilometers north-northeast ng Itbay at Batanes. At sa darating naman na Linggo ng umaga, totally nasa labas na ng PAR sa layong 915 kilometers north-northwest of extreme northern Luzon. So, muli balikan natin yung forecast track. Ito pong pinakikita ang mga forecast location, yun yung posibleng maging movement ng sentro ng bagyo nitong super typhoon na si Inday. It doesn't necessarily mean na ito po yung bagyo. Iyan lang po yung movement ng sentro. At pansinin din natin yung parang apa or cone-like feature na nakapalob itong center track natin. Ang area of probability, pinakikita po kung saan pa pwede yung maging aktual na pagkilos. Maaring ang forecast natin is 875 kilometers ng Northern Luzon over the next 24 hours. Pero yung maging actual ay maaring pahilaga or more on the southern portion nitong point forecast natin ito. So that is why sa mga kababayan natin, kung titingnan po natin yung ating forecast track at yung area probability, may tendency pa pala na mas maging malapit ang sentro dito sa may bandang dulong hilagang Luzon. Kaya patuloy po tayong magbibigay ng 6-hourly update patungkol nga sa super typhoon na si Inday. All throughout its course, sa loob ng ating air responsibility, inaasahan po natin na super typhoon ito and then by Friday ay posibleng maging typhoon category na lamang. Pero malakas pa rin po yun, no? Super typhoon and typhoon category inside the PAR, sigurado yung epekto, possibly sa extreme northern Luzon area, bukod pa sa pagpapaybayan ng habagat.
At sa ating pong iiwang mga salita ng Diyos na ating sandigan mula sa aklat ng Ecclesiastes, Kapitulo 8, versikulo 11 na nagsasabi, sapagkat ang hatol laban sa masamang gawa ay hindi isinasagawa agad, kaya't ang puso ng mga anak ng mga tao ay lubos na nangalalagak sa paggawa ng kasamaan.
At yan ang mga balitang aming tinutukan at inaksyonan dahil sa aming pagbabalita. Una, ang pagkalinga sa kapwa.
UNTV C News, may balita saan bang panig ng daigdig. At dito sa UNTV, Diyos ang aming sandigan, serbisyo publiko ang aming pinahahalagahan. Magandang tanghali.
that documentary evidence happens when the documents are formally offered in evidence. We are just in the process, Your Honor, please, of presenting this evidence. So therefore, the defense may object thereto when we formally offer the exhibits, Your Honor, please, and that's not happening yet.
Your Honor,
As a last point, Counsel for Respondent,
Thank you,
before
Your
the Chair makes a ruling.
Your Honor, true that photocopies are now considered originals. However, the photocopy must be an accurate and exact reproduction of that original or that printout. This, Your Honor, may I read it for the record? The bottom left-hand copy, it says, certified true copy, NBI-cybercrime, signed Safira T, date 4/10/26. Is counsel for the prosecution telling us now that this marking came from Meta, the email of Meta, of Facebook?
Again,
Kindly respond, Counsel, before the Chair makes a ruling. I'm interested to hear your response as well.
I'm so sorry. Could you repeat the question, please?
It was rhetorical, Your Honor. He need not answer.
He was basically questioning the fact that if it indeed came from Meta and is a computer printout, why the need for someone to certify it as a true copy?
I do recall, Your Honor, please, that was submitted to the Committee on Justice. Along the way, there was a need to certify that, Your Honor, please. But be that as it may, certification of a printout of an electronic document is not even necessary, Your Honor, please.
The objection of the Counsel for Respondent is overruled. With the Counsel may proceed.
Thank you so much,
He
Your Honor,
may
please.
raise his objection at the proper time when formal offer is made of documentary evidence, and any correction may be made thereafter, or rather before that, by the Counsel for the prosecutors.
All right.
Please proceed.
Thank you so much. Mr. Witness, you mentioned that Meta, you said, acknowledged the preservation requests. Sorry, Your Honor, please. I recall the last question. I have to proceed to presentation of the documents. Now, Mr. Witness, if this printout of the screenshot of Meta's reply is shown to you, will you be able to identify the same?
Yes, sir.
Now, what relation, if any, does that document have with the printout that you mentioned earlier?
This is the printout that I submitted, sir.
Now, Mr. Witness, Your Honor, please, again, as previously manifested, the documents identified by the witness has been previously marked as Exhibit P-4-8 for the prosecution. Okay, how faithful, if at all, is this printout from the actual screenshot?
The printout accurately reflects the screenshot, sir.
And how do you know that this printout accurately reflects the screenshot?
I compared the screenshot with the printout and the email confirmation of Meta and found that the contents are identical, sir.
Okay. Now, Mr. Witness, you Meta quotes acknowledged, unquote, the preservation requests. Now, based on your experience, and if you know, ano ba ang ibig sabihin kung yung Meta nag-a-acknowledge ng isang preservation requests?
Objection, Your Honor. He would be incompetent to say that.
Your Honor, please.
Counsel for the prosecution, what do you say?
Your Honor, please. This is an NBI agent that has been practicing digital forensics for 2 years, appearing in court for 30 times, and underwent training for 2 weeks. No other person in this room is more competent to answer the question than this witness. Let the witness answer.
Nevertheless, Your Honor, he's incompetent. He is not from Meta. He doesn't know Meta procedures. The mere fact that he's an NBA agent doesn't make him competent.
Can I reply to that, Your Honor, please?
Overruled. Chair will allow it. If the witness knows, he may reply. If he does not know, he should so admit also. Witness may answer.
It means that Meta have taken necessary action to preserve the evidence, sir, and assign a case number on it.
So took reasonable steps to preserve and assigned a case number. Now, yung question now is, after receiving this acknowledgement from Meta, ano ba yung ginawa mo kung meron man, in relation to the investigation you conducted on the statements of the Vice President?
I further preserve the video and authenticate the same, sir.
All right, so you said you...
With the permission of the counsel for the prosecutors, Mr. Witness, what do you mean by Meta assigned a case number to it? What does that exactly mean?
It means that yun po, they have taken reasonable action. Yung case number po is for monitoring namin kasi multiple multiple requests po from different investigation. Yung case number na yun for specific request po.
So pag may request kayo sa Metang i-preserve ang isang digital footprint o data, lalagyan nila ng case number?
Yes po.
Lahat ngayon na magre-request na i-preserve yon, ilalagay sa ilalim ng case number na yan yung mga request?
Hindi po. Per request po yung case number.
So each request will have a separate case number from Meta?
Yes, Your Honor.
And the case number for this one would be what?
916154, Your Honor.
Saan po nakasulat yon?
Your case number is 91, nasa upper part po, Your Honor. 91.
Ayun, 911654?
Yes, Your Honor.
You may proceed, counsel. Thank you.
Thank you so much. Mr. Witness, you said that you proceeded to further preserve and authenticate the subject video. Now, let's go to that proceeded to further evidence. What does it entail, if any, and if you know?
It means that I further preserve it using a screen recording, open source broadcast software studio, OBS. I screen record what appears on my screen, the video, the online live stream November 23, 2024, from beginning to end, including its URL.
Okay, now, what about authenticating the video? Ano bang ibig sabihin yan kung alam mo?
After screen recording, there's an output video. I compared the output video with the November 23, 2024 video and ensured that the contents are identical. After ensuring that the contents are identical, I now generated a hash value calculation on the video to ensure that the video won't be tampered until presented in court, sir.
Mr. Witness, ano ba yung pruweba mo kung meron man that you authenticated the subject video?
I have executed an affidavit of authentication of digital evidence dated January 30, 2025, sir.
Okay, now, kung yung affidavit of authentication of digital evidence dated January 30, 2025, ipapakita sa iyo, will you be able to identify the same?
Yes, sir.
Now, in the process or the prosecution is in the process of confronting the witness with a document that is previously marked as Exhibit P-Roman numeral 4-9 and series, constituting of 29 pages, including the attachments. Your Honor, please, the defense is invited to peruse the documents.
Your Honor, we object to the introduction of this affidavit of authentication. This is not an original copy of his affidavit. This is not electronic evidence. And if you look at the affidavit, even the appendages, which supposedly consist of USBs and CD, there's no USB, there's no CD, and even the signatures are not wet signatures, Your Honor.
What does counsel for the
Your Honor,
prosecution
please,
say?
We will not comment to that, subject to the proper response to that when the time comes in the formal offer of exhibit, Your Honor, please.
Your Honor,
The objection of the counsel for respondent is noted as to the admissibility of the offered document. However, as correctly pointed out by counsel for the prosecution, the proper time to object to the same and for the court to rule on it would be during formal offer, once the prosecution has already rested its case. So ordered.
Thank you so much, Your Honor, please. Mr. Witness, what relation, if any, does that document have with the affidavit that you mentioned?
Your Honor, may I just make a quick manifestation?
Counsel for the respondent. Yes, you may, sir. Please
Your
proceed.
Honor, during pretrial, the parties got together and agreed that originals of the documents that were to be marked will be presented during trial. We agreed to expedite the proceedings. And now, what is happening is photocopies of documents that we want to peruse and see are being presented. So we object to this, Your Honor.
If I may, can I
The
reply? Sorry, I'm so sorry.
The
Your Honor, please.
manifestation of the counsel for respondent is duly noted.
Thank you so much, Your Honor.
Please proceed, counsel for the prosecution.
On page 3 of the Affidavit of Authentication of Digital Evidence, may makikita dyan yung isang pirma sa ibabaw ng pangalang John Mark Calilong. Do you see it?
Yes, sir.
Yung tanong now is, whose signature is that if you know?
This is my signature, sir.
Your Honor, at this juncture, Your Honor, please, despite the prosecution's understanding that a photocopy is now the original, is now considered as an original. But to address the concerns of the defense, Your Honor, please, I move that we be allowed to present the original of the documents that was confronted, that the witness was confronted with. Sorry, it's a certified true copy of the Affidavit of Authentication, Your Honor, please.
Counsel may proceed.
Okay. Now, you mentioned, so I will go back. Now, Mr.
Without prejudice to the counsel for respondent viewing the same
Yes.
with respect to its certification.
Affidavit of Authentication of Digital Evidence dated January 30, 2025. Now, so that it's a certified true copy, correct? Now, we are confronting you now with a certified true copy of the same document. After perusing the same, you have to tell us what relation, if any, do the documents before you have with the documents, affidavit of authentication of digital evidence that you mentioned.
Your Honor,
Yes, Counsel for Respondent.
we'll finish perusing, Your Honor.
The one 20 November 23. Sorry. Not found. Yeah, I will. That's that. Yes. Yeah. Yeah, I know. Stephen, can I ask somebody else? Can you mention? Can you hold down? Huh? Yeah.
Your Honor, for...
Yes, Counsel for the Respondent.
Thank you, Your Honor.
You may proceed, sir. For your comments.
Sir, for Your Honor, for P-I, P-4-9H. Your Honor, there is a CD in the original. Oh. 9-4, Ben. 9-4.
Careful. 9-4. Just look at the original.
Counsel, what are you referring to again? P-4-9 what?
Before that. Yeah.
P-
Before that. Attorney, may natanggal lang yung ano nyo. Is this the same ano? Sequence. Sige, punta ka sa scene mo na. Hanapin mo yung scene. Hindi to. Hindi ito bro. Okay, next page.
Iyan.
Hindi. Okay, next page. Next page. Okay, next page. Okay, yeah. So, spot the difference.
Your Honor, for P-4-9H, in the original, there's a marking, November 23. And in the photocopy, it is only a photocopy of the CD, Your Honor. So there's a difference.
Noted.
You can reply to that, Your Honor, please.
Counsel, let's get all of his comments first.
The page after is already a USB.
Your Honor, the page after in the original is a USB, which is Annex E-1 with markings October 18, 2024 video, CL PPS 182. However, in the photocopy, there is no such photocopy, the marked photocopy, there's no such thing.
So the order is no longer the same moving forward.
So the order is no longer the same moving forward, Your Honor.
Yeah, that's it.
Even in that very same one, which I assume is P-4-9K, does not have any date marking, Your Honor.
It's not the
So
same document. The conclusion.
It is not the same document. It's not faithful reproduction of anything, Your Honor.
The photocopy is not a faithful reproduction of the certified true copy. That's what you're stating.
Yes, Your Honor.
What does the counsel for the prosecution say?
Your Honor, counter manifestation that the documents that the defense are perusing have been identified by the very person who authenticated and who executed that exhibit. So, Your Honor, please, we move that the comments of the defense be noted, Your Honor, please.
Your Honor, that's irrelevant. What we're saying is that this is not the copy mark. It is not the same as the original, which he says it's the same thing which is identified. What he's saying is off tangent. What he identified earlier, which is the marked copy, which is the copy marked during pretrial, is not the same document as they are passing on as an original. Your Honor, this is the
Counsel
issue
for
here.
respondent, that is a proper subject matter too for your cross to point, if at all, the distinction and difference between the two copies, which counsel for the prosecution can use as a subject matter for his redirect.
Thank you, Your Honor.
Because you can confront the witness with respect to the certified true copy that is different from what he identified earlier, impugning,
Your
if
Honor.
at all, his credibility as a witness in this case.
Thank you so much, Your
So
Honor,
we
please.
note the comments and observations of the counsel for the respondent. I got lost. So it's being reviewed and has not yet been given to the witness, right?
Your Honor, may I just register our continuing objection?
So noted and so registered.
Thank you so much. Can we proceed?
Before we proceed, the presiding officer was not there during pretrial. As manifested by the counsel for respondent, was there indeed such an agreement that the originals will be presented during the trial
Yes, Your Honor.
by both parties? Can the counsel for the prosecutors also confirm that?
Your Honor, please, we do not confirm. I conferred with my team, the team who actually participated in the marking for Article 4. Your Honor, please. Be that as it may, Your Honor, please, we would like to put into record certain realities of the law. A photocopy is now considered as an original. 2019 amendments in the Rules and Evidence. Number 2, Your Honor, please. This is the person who authenticated the documents. So there's no other person who is competent to testify as to the veracity of those documents other than the witness.
Your Honor,
please.
that's only a
So you do not
conclusion, Your Honor.
confirm?
No,
You
Your
do
Honor,
not
please.
confirm such an agreement during pretrial?
We do not confirm that, Your Honor, please.
So, Chair would like to advise the parties. The court understands the exceptions to the original document rule and will so implement the rules in that regard. However, if it does not fall under the original document rule exceptions, then to save on the court's time, the party presenting the document should present the original during trial to obviate what we are seeing now. Perhaps in the next time you present a witness, counsel
Yes,
for the
Your Honor, please.
prosecutors and counsel for respondents.
Who will, Your Honor?
We appreciate that, Your Honor, please. We understand that would be for the next presentation.
For the next one. Please
Thank
proceed.
you so much. Are we done now? We move, Your Honor, please, that
Your Honor, may
sorry.
I request that he not also address me directly?
So ordered, so instructed. Kindly address all of your queries and statements to the presiding officer and use the third person when referring to your fellow counsel for the other party.
Much obliged, Your Honor, please. We move, Your Honor, please, that the marking in the affidavit of authentication of digital evidence that was previously identified by the witness, a photocopy, the markings of the same be transposed, Your Honor, please, to the documents that this witness is being confronted with at present, Your Honor, please.
We object to this, Your Honor. This is precisely our earlier objection. They're marking a new document. That's why they're asking that it be marked again, which defeats the very purpose of our pretrial.
If I may reply, Your Honor, please.
Your Honor,
Can I continue?
Kindly
I wasn't
allow
done.
the counsel for the prosecution to speak.
So the hearing will proceed, Your Honor, please. I will withdraw that motion. We will stand by the presentation, the photocopy allowed by the rules and identified by the witness who actually executed the affidavit. May proceed, Your Honor, please.
I hope this satisfies counsel for respondent. You may proceed, sir.
Thank you so much, Your Honor. Now, Mr. Witness, on page 3, sa pahinang number 3 of the Affidavit of Authentication of Digital Evidence, may makikitang isang pirma sa ibabaw ng pangalang Agent John Mark Calilong. Now, yung tanong, kaninong pirma ba ito kung alam mo?
Pirma ko po, sir.
Now, sa page 4 ng nasabing Affidavit of Authentication of Digital Evidence, may makikita din na isang pirma, okay, sa ibabaw ng pangalang Attorney Jeremy C. Lotok. Now, kaninong pirma ito kung alam mo?
Pirma po ni Attorney Lotok.
Now, how do you know that it is the signature of Attorney Lotok?
Nakita ko pong pinirmahan niya yung document. At may mga document po ko na nakita at enacted upon na bearing his signature, kaya familiar po ako.
Thank you so much. Your Honor, please, we proceed. Mr. Witness, now, what action did you perform, if any, after you authenticated the subject video in relation to the investigation you conducted on the statements of the Vice Presidents?
I first saved the video on my laptop and saved a copy of the video on a DVD and a flash drive.
Okay, now, you mentioned that you saved a copy in a flash drive. Mr. Witness, kung yung flash drive ipapakita sa iyo, will you be able to identify the same?
Objection,
Yes,
Your
sir.
Honor. We object.
What is the objection of the counsel for
The
respondent?
document identified by the by the witness was the photocopy, and the appended there's no flash drive, CD, or anything appended upon that. So there's nothing, no foundation for this question.
I have to reply to that, Your Honor, please. This is
And
a
reply, counsel for the prosecution.
This is a non-issue. I asked the witness, what did he do after saving the video? And he said he saved it in a flash drive without referring to any document attached to the affidavit of authentication. Basis is laid, Your Honor, please. This is a non-issue. We may proceed, Your Honor, please.
Your
Besides,
Honor,
counsel,
may I
counsel
respond?
for the respondent. This is not a surprise. This was flash drives. Several flash drives were pre-marked during the pre-trial.
Your Honor, may I reply first before?
I believe 7 on the part of the prosecution and several on the part of the respondent too. But you may proceed, sir.
Your
Please.
Honor, that is not my objection. My objection is the very basis upon which the witness introduced this flash drive was the affidavit. The affidavit. And there was no affidavit upon the, there was no attachment upon the affidavit which they introduced. So the very questions that he has do not have any foundation.
No. Can I
Counsel for the prosecution,
Your Honor,
before the court,
please.
the presiding officer makes a ruling.
Ako yung magiging parang sirang I just said that this witness said that he saved a copy of that video in a flash drive. So the logical question now is to ask him if this flash drive is presented to him, is he able to explain and or identify the same? I don't see any proper basis for an objection to that, Your Honor, please.
Presiding officer will make a ruling. Objection is overruled. The prosecution, counsel for the prosecution, is trying to comply with the requirements enunciated by the Supreme Court insofar as such pieces of evidence is concerned. Number 1, establishing its origin. Number 2, to trace the chain of custody insofar as the transfer to a storage device is concerned. And finally, how it reached this court. So the objection is overruled.
Thank you so
Witness may
much,
answer.
Your Honor, please. Now, Mr. Witness, Attorney Bagalion, please confront the witness with the flash drive. Mr. Witness, I'm now showing a flash drive that is previously marked as Exhibit P-Roman numeral 4-10A, containing the subject video that is previously marked as Exhibit P-4-10 for the prosecution. Question: what relation, if any, does this flash drive have with the one you mentioned?
May I know if this was appended upon any
Counsel
document?
for respondent is recognized.
Thank you, Your Honor. Your Honor, may I know if this was appended upon any document?
Your Honor, please.
Counsel for the prosecution will please reply.
Your Honor, please.
The answer is no, I presume.
No.
The basis, if at all, counsel for the respondent is the testimony of the witness. When asked, again, to establish not only the origin, but also how he transferred it to a storage device, and if at all, how it reached this court. So, chair replies, and if that is an objection, overrules the same. Witness may answer.
Permission to unseal the flash drive.
You may do so, sir.
Thank you, Your Honor.
Your Honor, the witness manifestation is now in the process of unsealing the object evidence.
Witness will please answer.
This is the flash drive where I saved the recording, sir.
Now, Your Honor, please, at this juncture, we are about to confront the witness with the video contained in the flash drive.
Your Honor.
And,
Kindly let the counsel for the prosecution finish.
Yes, Your Honor.
thank you so much. And in the interest of time, Your Honor, please, we move that we allow Attorney Magallon to transport himself to the technical booth to facilitate, Your Honor, please, the playing of the video when the time comes.
Counsel for respondent.
Your Honor, may we know how long the video is?
We will arrive to that, Your Honor, please.
No, I'm also curious. How long
All right,
is
now.
this for us to know? How long is this particular video? Namely, Exhibit P, Roman numeral number 4, 10A.
Your
How
Honor,
many
please.
minutes or seconds would this be?
Exactly, the video is 2 hours and 26 minutes and 10 seconds. But wait, Your Honor, please. We will aid the court in this regard. We will not be showing the entire 2-hour video, Your Honor, please. We will be presenting the relevant portions of the video, Your Honor, please, sanctioned by the rules and subject to the defense doing whatever they want with the remainder of the video, Your Honor, please.
Your Honor.
So, what will you play exactly, counsel?
Your
How
Honor,
many
please.
minutes or seconds?
We counted, it's 2 minutes and exactly 18 seconds, Your Honor, please. 2 minutes and 18 seconds of a 2-hour, 26-minute and 10-second video, Your Honor, please.
Your
What does
Honor,
counsel for respondent say?
we object. Based on Your Honor, based on the rules, part of a video documentary must be presented, Your Honor.
Come again?
I'm sorry, counsel?
Yeah.
Hold on, Your Honor.
I'm sorry, counsel? I did not get what you
Hold
said.
on, Your Honor. Your Honor, under Rule 132, when part of a transaction, writing, or record given in evidence, the remainder must be shown. When part of an act, declaration, conversation, writing, or record is given in evidence by one party, the whole of the same subject may be inquired into. And when a detached act, declaration, conversation, writing, or record is given in evidence, any other act, declaration, conversation, or record necessary to its understanding must be given into evidence. Your Honor, we request that the entire video be played.
Your Honor, can I respond to that, Your Honor, please? Can I respond to that?
What does the counsel for the prosecution say before the chair makes a ruling?
Your Honor, please, we don't want to put the defense on the spot, but that is a misreading of the rules. Your Honor, please, counsel cited Rule 132, Section 17. With all respect to the defense, that doesn't serve your interest. It serves the interest of the prosecution. May I explain? Reason. If we read Section 17 of Rule 132, it says, when part of transaction, writing, or record given in evidence, the remainder is admissible. When parts of an act's declaration, conversation, writing a record, when part is given by one party, and in this case, that is the prosecution, the whole of the same may be inquired into by the other side. Meaning, it's simple. This rule, Section 17, Rule 132, allows exactly the prosecution to present a 2-minute portion of a 2-hour video subject to the defense, the presentation of the remainder of the same. Be that as may, Your Honor, please, the rules are clear. Number 2, we invoke, Your Honor, please, the ruling that it is for the prosecution to decide what to present, when to present, how to present, and whether to present at all. Be that as it may, Your Honor, please, the defense will not be prejudiced exactly because when the time comes for the defense to present their evidence, they can present the remainder of that 2-hour video. What we are saying, Your Honor, please, for the interest of time, for the prosecution's presentation of evidence, we deem that's only a 2-minute portion of that 2-hour video is relevant at this point in time, Your Honor, please. We move for a ruling.
Your Honor, if I may respond.
As the last response,
Your Honor,
counsel for the respondent.
The prosecution cannot be allowed to present a truncated part of a whole 2-hour, 26-minute video. That will not provide the context necessary for the understanding of what occurred during that night on November 23, and also not allow the proper identification by this witness.
Your Honor, sorry, I will not even reply to that, Your Honor, please.
Chair would like to ask, who did the edit? From the, how many hours? 2 hours?
No. Your Honor, please, if I may, can I reply to that?
From the total, who did the edit? Was the witness the one who did the edit, or was it already the prosecution?
Your Honor, there's no editing done. There's no editing done.
Who got that shorter portion?
No, Your Honor, please. What we are presenting are portions of the entire 2-hour video. And this witness, I think, will be able to identify the specific timestamps of that preserved, not edited portion. If I may repeat, Your Honor, please, we are not presenting any edited portions, but only snippets, portions of that 2-hour video. And this witness, I suppose, will be able to identify which specific portions that he would like the court to view at this point.
So when it is shown, the witness will testify and attest to the portion of the entire video that it was found insofar as the timestamp is concerned.
Yes, Your Honor, please.
But as evidence at the proper time, you will be offering this entire
yes,
2-hour or so video.
Yes, Your Honor, please.
And simply highlighting the 2 or so minutes. Would that be correct?
That is a very keen observation. Agree 100%, Your Honor, please.
Your Honor, the prosecution cannot be allowed to do this because the entire video will show the context on which the utterances were made.
That is a matter for the counsel for respondent to do and present during their time, because I believe the counsel for respondent also identified and marked, if I'm not mistaken, the same video for over 2.5 hours. It can do so during its time to present its evidence in chief.
Thank you so much.
The objection is overruled. Counsel is instructed to go to the booth accompanied by a counsel from the respondent in order to make sure that indeed the USB identified by the witness is the same USB that will be played in the tech booth of the Senate.
Okay. While they're doing that, may I propound the next question, Your Honor, please?
Yes, counsel, you may proceed.
Mr. Witness, John Mark, listen. Now, you mentioned kanina that you authenticated the subject video by recording the same through sinasabi mong open broadcaster software, OBS, and then you compared the contents of the recording and the subject video. That's one. And you also said that you investigated certain statements made by the Vice President on November 23, 2024. Yung tanong, no? What particular statements of the Vice President did the NBI deem proper to investigate?
The statement of the Vice President where she uttered that she already talked to someone to kill the President, the First Lady, and the former Speaker of the House if something's happened to her.
Okay, now, the next question now, Mr. Witness, is in what particular portion of the subject video? In what particular portion of the subject video did the respondent utter that she already contracted a person to kill?
Objection, Your Honor.
Oh, wait.
Allow the counsel to finish his
I'm not
question.
yet done. Relax. To kill the President, the First Lady, and the former Speaker of the House.
Objection, Your Honor.
What?
What is the objection of counsel for respondent?
Your Honor, no basis for the question, Your Honor.
Wow.
Overruled. Witness may answer.
May I refer, sir, to my notes to identify the specific timestamp, sir?
Okay,
The
so
witness may do so if it is available to him. You may refer to your notes. While he's doing that, while the witness
Honor,
is
may
doing
re-
that, Senator Judge Alan Cayetano is recognized. You may proceed, sir.
Your Honor, may I question what notes he is referring
Counsel
to?
for respondent,
Apologies,
the
Your Honor.
presiding officer recognized Senator Judge Alan Cayetano. You may proceed, sir.
Just some thoughts, Presiding Officer. This is not yet an appeal from your ruling and maybe a question to the counsel of the defense. Just to refresh our memory, Rule 132, Section 17, when part of a transaction, writing, or record given in evidence, the remainder admissible. When part of our act, declaration, conversation, writing, or record is given in evidence by one party, the whole of the same subject may be inquired into by the other. And when a detached act, declaration, conversation, writing, or record is given in evidence, any act, declaration, conversation, writing, or record necessary to its understanding may also be given in evidence. So I'm not appealing yet. I see the logic of the ruling of the presiding officer. Ito lang po ang tanong ko. Is the defense going to ask later on for the showing of the whole video? Because if they are, why don't we just watch the whole of it? Because we're going to have to assess the context. If it was really a threat, what did she say before or after? And I don't really want to go home today believing one thing based on a 2-minute clip and then come back next week to watch the 2-hour clip. I think most of us saw parts of the clip. Of course, I don't also feel like watching the 2-hour, I don't even watch 2.5-hour movies, much less this. But I'm just putting this at the feet of the presiding officer and my colleagues na kung gagawin din naman natin eventually yung 2.5 hours, mas gusto ba natin putulin muna ngayon at may iniisip tayo and then later on the 2 hours? Or can the two parties agree of the 2.5 hours, which one yung may context? So I'm not criticizing the prosecution's motion. I see what you mean. May I ask that one question to the defense, if they're going to ask, presiding officer?
Precisely.
For the presiding officer, we cannot dictate nor predict what either counsel for the prosecution or respondent will do during the presentation of their evidence in chief. Even if they say yes to us now,
yes,
actually they have every right to change their mind and
yes, I agree, Your Honor,
not do so anymore.
But if they do answer now that they want it shown, may we consider, I mean, if I'm the only one who wants to see it as a whole, then I will submit to everyone else. But if everyone else is saying we will eventually watch the whole of it, we might as well get it over and see the context of the whole video. Unless the two parties can agree that they only want to look at 30 minutes or 1 hour. I don't know what context they're talking about. I'm just trying to expedite
Both
presiding
parties,
officer.
Senator Judge Alan Cayetano, marked the same video.
Yes. May I ask
which is over 2 hours.
May I just ask the defense, do they plan to ask us to watch the whole?
Counsel for Defense will please reply to the question of
Yes, Your
Senator Judge Cayetano.
First, Your Honor, precisely why we're asking to watch the video is because we don't know what the contents of that video is. We don't know if it's any different or the same with our video. And to answer the question of the Honorable Senator, yes, we will be asking the entire 2-hour, 26-minute video to be presented and watched later on during our cross.
So on that point, Mr. President and Presiding Officer, hindi naman nakalagay sa Section 17 when. And usually, at least for myself, if I have to watch 30 minutes and then may emphasize na 30 seconds, 2 minutes, 1 minute, pinapanood muna yung buo and then saka papanoorin yung maikli na ine-emphasize para walang prejudgment. Kasi pag nauna yung portions na maliliit and then saka mo lang sasabihin later on, eto pala context nito. Medyo umiiba. But again, no, I'm only one of the 24, so I leave it to my colleagues. If we're going to have to watch it anyway, may I ask the presiding officer what the pleasure is? But since the rule doesn't say, personally, I'd rather watch the whole thing and get it over with, then allow the prosecution to pick out the portions that quickly say, that goes into the center of the controversy or what they want to prove.
Without disagreeing with Senator Judge Cayetano, for the presiding officer, it's just that I don't think the court should impose or dictate upon either party how they will present their evidence in chief. Although it would save the court some time if they, but we can also waste a lot of time arguing about this instead of watching the 2-minute video.
Mr. Presiding Officer, I'm not saying we dictate because there was an objection, you ruled. You can change your ruling or we can appeal. But I'm saying I'm just one. So if everyone agrees na portion muna, I will submit to that. But if everyone else thinks na panoorin na yung buo, then baka I can appeal your ruling without voting. So I'm just bringing up this issue for expediency, but I leave it up to what everyone else thinks about it.
You know, Your Honor, if I may, we also move for the reconsideration of the earlier ruling of the Honorable Court.
Counsel cannot move for reconsideration of the ruling of the chair. Only a senator judge
Your Honor,
can do
may
so,
we
Counsel.
manifest that we intend to present the whole during cross-examination, Your Honor.
Presiding officer declares a brief recess.
Thank you so much, Your Honor. Can I go?
Trial is resumed. During the break, the presiding officer had a discussion with the senator judges, including Senator Cayetano. The presiding officer would therefore like to make of record the following. Number one, should the counsel for the respondent rather, decide as it has manifested to present the entire video, this court shall allow it during the time for the respondent to present its evidence in chief. We will not interfere with how each party or either party presents their case, with a caveat. A portion of an entire video being presented is not only to save on time, but also to be able to support the allegations from the point of view of the prosecution insofar as their articles of impeachment is concerned. No need to say that the counsel for the respondent will also present the evidence that they deem best that will prove the innocence of the respondent in this case. Senator Judge Cayetano. The mic, please, of Senator Judge Cayetano.
Mr. Presiding Officer, I submit and I think there's a consensus. May I ask just one question about authentication?
You may
just want to
proceed,
be
sir.
clarified with my indulgence to the prosecution and defense. Just to the witness, please correct me kasi hindi ako techie talaga dyan. So sabi mo, pag ino-authenticate mo, you get the video tapos may hash.
Yes, Your Honor.
So you get the hash tapos you download the video. Tama po ba?
No, Your Honor. The video was screen recorded, Your Honor.
Okay, so screen recorded, then yung hash na nakuha mo.
Yung hash value po is kinalculate from the recorded po.
Okay, then you have to compare that with the original one, right?
Yes, Your Honor.
So, the original one, yung hash niyan, nasa Facebook. Tama ba?
Yung hash po, hindi po kinalculate yung hash from the Facebook. Kasi ang purpose po ng hash value is to calculate po yung value ng mismong video na ni-record ko. Dahil hindi po siya yung for authentication purpose, but for the integrity of the video that I screen recorded na if matampered siya during the time na sinubmit siya until presented in court, makikita po na iba po yung hash value.
So, is there a possibility na iba yung hash ng Facebook for the same video sa hash nung sayo?
Magkaiba po talaga yun.
Magkaiba. But how do you know it's, when you authenticated, how do you know it's the same video?
I manually compared, Your Honor.
Manually compared?
Yes, Your Honor.
But we don't know that unless we also manually compare.
Yes, Your Honor.
Yeah. Thank you. I just want to clarify that and think about it more.
Noted and entered into the records. What is the pleasure of Senator Judge Villanueva?
Mr. Presiding Officer, in relation to what Senator Judge Alan Cayetano mentioned, may I just be allowed to ask a clarificatory question in relation to that particular matter?
Senator Judge Villanueva may do so. He has 2 minutes.
Thank you. Mr. Witness, I was listening attentively earlier and you made mention that the live stream video was recorded using Open Broadcaster Software or OBS. Just for the benefit of the court, could you briefly explain what OBS is and how it was used in the course of your investigation?
It's open source na software na pwede po i-access ng kahit sino.
So it's generally available to the public?
Po. And ang purpose po niya is may 2 functions siya, is live stream and screen recording po.
And stream recording?
Screen recording, Your Honor.
Could you explain the capabilities nitong OBS as well as any considerations that investigators take into account pag ginagamit po itong recordings generated through this particular software as part of your investigation?
Yung OBS po, capable po siya i-screen record kung ano po yung nakikita sa screen. After po nun, makakapag-generate po siya ng output. Yung output po na yun, yung minamanually compared ko with the live stream video, Your Honor.
To authenticate?
Yes po.
Thank you. Thank you, Mr. Presiding Officer. Thank you, Sir Witness.
Thank you, Your Honor.
Noted and entered into the records. What is the pleasure of Senator Judge Raffy Tulfo?
Thank you.
Mr. Presiding Judge, just a statement.
The gentleman may proceed.
In Rule 132, Section 17, it is not mandated that the whole record be shown to the court. The video being shown in open court and it being in evidence is completely different. That's all, Mr. Presiding Officer.
Noted and entered into the records. What is the pleasure of Senator Judge Pangilinan?
Yes, Mr. President, just one or two quick questions to the...
The gentleman may
witness.
proceed. Witness will please answer the questions of Senator Judge Pangilinan. He has 2 minutes.
Yes, Mr. Calilong, ikaw nabanggit mo kanina na nag-training ka, no?
Yes, Your Honor.
Hindi lang dalawang linggong training lamang ang nakuha mo, tama ba yun?
2 linggo on the start, pero during the tinitrain po ako ng chief ko. During the process.
So continuing training?
Yes po, kasi nagpe-present po ako sa
At saan yung training? Na sinabi mong 2 linggo, nabanggit mo ba?
Sa office namin siya ginawa, pero ang nag-handle is MaxCore po.
Ano yung MaxCore?
MaxCore Interventures.
Ano nga yun?
Provider po namin ng forensic softwares.
At kumpanya siya?
Yes po.
Ng computer...
Ng mga pang-forensic po.
Forensic. Okay.
Yes, Your Honor.
Thank you.
No Counsel for Prosecutor will please proceed.
Your Honor, may I be allowed to speak in Cebuano a bit? Mahimo ba kita magpadayon? In Tagalog it means, in English, can we proceed?
Counsel may proceed.
Thank you so much, Mr. Witness. Now, in what particular portion of the subject video Did the respondent utter that she already contracted a person
Hello, good afternoon. Maraming salamat po. Since we were pressed for time, I'll just take your questions para po ano naman.
Post-examination, ready na po ba si Attorney Narvaza po ba ang mag-cross-examine today? And ano po yung intention niya going into the cross-examination? Will we play the 2-hour response?
Yes, si Attorney Narvaza yung magko-cross-examine today as he was on the rostrum yesterday. He'll also be in the rostrum today. We're expecting good cross for today. Attorney Narvaza is prepared. And pagdating naman dun sa 2-hour video, tingnan mo din. We will need to play that or kung we don't have to play the entire thing but is able to at least prove our point. No? So right now, hindi pa kami titingnan muna natin yung takbo ng cross-examination later.
Attorney, sabi ng prosecution kanina na there could be a chance na quote-unquote basagin yung credibility ng witness. Ganun po bang gagawin niyo ngayon later sa cross-examination?
Well, usually naman, yan naman talaga ang purpose ng cross. No? That's one of the purposes. No? Not the only purpose, but one of the purposes. But We just want to ferret out, what our position is. We feel is really the truth. Ayoko naman gamitin yung witness. I'm sure the witness is just doing his job also. So sa atin, we're just there to cross-examine, test the testimony of the witness, and ferret out the truth.
Sir, ano po yung naging reaction ni VP Sara dun sa nangyari po kahapon? Did she monitor?
Yesterday, magkausap kami kagabi. Wala naman siyang naging any bad reaction or anything to that, no. In fact, she just always keeps on thanking the defense team for doing our job. Alam niyo, abogado rin kasi ang ating vice presidente, so I guess naiintindihan niya lalo na yung mga court proceedings. So wala naman po siyang naging naging issues.
First, susundan ko lang po yung tanong ni Ate Camille. Kahapon din po kasi si Attorney Lauren Kapunan raised possibility that the Vice President, they will move to subpoena the Vice President. Napag-usapan mo po ba ito ng vice? Ano po yung reaction sa possibility niya may subpoena request?
To be honest, kagabi hindi namin napag-usapan yan. I think medyo nawala na rin sa so hindi ko natanong sa kanya yan. But that's something for the defense to really take care of. And ako naman, in fairness to the prosecution, as I always say, it's within their prerogative to call whoever witness they want to call for as long as it is allowed by law and within the bounds of the law and the rules. So sa atin, kung sakali man na magkaroon ng motion na ganyan, then we will have to give our position on the matter, specifically because there are constitutional issues, meaning there are fundamental rights that are protected under the Constitution, especially when it comes to the respondent.
Attorney, naghain po ng petisyon si Senator Lady and 8 others laban po sa pagsilbi ni Senator Jesus Codero bilang presiding officer. Alam po ba to ni Vice President Sara Duterte? May kinalaman po ba ang kampo ng defense team?
Opo. First, dun sa kung alam ng Vice President, hindi ko alam, but I would suppose hindi niya alam dahil hindi namin napag-usapan at all yung paghain ng petition. In fact, I only found out about the petition this morning when I was in an interview, at nabanggit. So, to be honest, kasi dahil nandito tayo buong araw, I wasn't able to monitor. Hindi ko po nabalitaan yung petition. Pagdating naman sa defense team, ako po categorically masasabi ko na hindi namin alam na magkakaroon ng petisyon or may plano mang magkaroon ng petisyon. Hindi ko nga alam na naihain na yung petisyon. Attorney Torion and I know each other. I think we're acquaintances but we're not in communication, and especially with this petition, hindi po kami nagkausap tungkol dito.
Do you support the petition?
No, the defense would like to just focus on the impeachment trial. Yung petition, I haven't read the petition at all, so I don't know what it says. So I'm not in any position to support or not support any petition.
Are you satisfied with the performance of the presiding officer sa pagkakaelect niya doon sa proseso na ginawa?
Well, sa akin naman po, naging orderly naman yung conduct ng trial for the past 2 days, and yesterday, nung may first witness na talaga na na-present. So, there's nothing I can say against the presiding officer. It would be inappropriate for me to comment against senator judges also.
Sir, nakarating na po ba kay VP Sara yung request din ng prosecution na ipasubpoena yung kanyang chief of staff na si Attorney Araneta-Marcos, and how did she respond to it?
Yes, nakarating nabanggit ko sa kanya yon, and well, she knows, na gano'n naman talaga ang mangyari because sa pre-trial brief pa lang nakalista naman. In fact, even ako nakalista doon, di ba? And that's okay. Sa akin nga, sinasabi ko parate, ulitin ko lang, prerogatiba ng ng prosecution. So sa atin naman, when the witness is there, they're given the chance to direct the witness and we're given the chance to cross-examine. So, naman po tayo, talagang normal sa proceedings. I don't think there's anything wrong with that.
Hindi kinonsult ni Vice President Sara?
I cannot speak for the Vice President kung nagkausap sila, but as far as I know, wala namang nabanggit sa akin ng Vice Presidente na alam niya to or may nagkausap sila. So, as far as I know, walang ganon. But kami sa defense, I can only speak for the defense, And for the defense, hindi talaga kami nag-usap at all.
Base sa paghahanda ng defense attorney, same length ba ng oras ang ibubugo ninyo sa cross-examination kay Camilo today?
Hindi natin masasabi. Hopefully naman, syempre kami, ang gusto namin, and even the prosecution for sure, ang gusto naman namin mapabilis lahat ng proceedings. Kahapon, in fairness to the prosecution, kinakailangan lang talaga yung ganong oras because, you need the witness to identify, authenticate all these documents, paano niya in-extract, etc. So, just to be fair to the prosecution, kung kami man yun, siguro ganun din kahaba because you really need the witness to do that, no? Sa amin, sa course examination, we're hoping naman na hindi ganun kahaba. But tingnan natin kasi it will really depend, no, sa takbo ng questions.
Attorney, strategy nyo ba sa defense na mag-object parate dun sa mga inihahain ng prosecution? Talaga bang ganun ang strategiya ng defense?
Opo, hindi po, Sir Ian, hindi po strategy yun. Actually, it's really something that lawyers do every day in court. Bakit? Kasi under the rules, there are questions that are objectionable and there are questions that are allowed. And if questions are objectionable, syempre, trabaho rin po ng abogado, whether it be defense or the prosecution, to object. No? And the rule is that in terms of testimony being given by a witness, that we have to object as soon as the ground is apparent. No? Ibig sabihin, pag lumabas na at napansin mo na, no, objectionable yung question ng tablang panig, dapat mag-object ka na agad. Kasi kung hindi ka object, that will consider, no, on our... As to strategy, hindi naman po ganun ka, babaw yung strategy namin na object lang ng object. Pa.
Sir, based on sa... So, yung support na touch mo ng defense team, are you also considering to call on Vice President Sara Duterte?
Right now, wala kaming nalagay na ganyan sa aming pre-trial brief. No? Yung hostile witness, ang hostile witnesses po, dapat po kina-qualify po muna yan. Meaning, pag pinatawag mo sa stand, kailangan mo ipakita sa korte na talagang hostile ang magiging testimony ng isang witness and they will have to ask for the court to declare the witness as a hostile witness. No? Ano ba ang pagkakaibahan nun? Pag hostile witness po kasi, para lang sa kalaman ng ating mga kababayan, kung ako ang nagde-direct, meaning usually hindi ako pwede magtanong ng leading questions or questions answerable by yes or no. Pero pag ang isang witness ay mula sa pagiging ordinary witness ay naging hostile witness, pwede na po siyang tanungin na nagde-direct sa kanya ng yes and no questions answerable by yes and no. So, yun naman po yung usual nuances pagdating sa hostile witness. But to answer your question, sa amin, wala naman po sa listahan namin. But ang parati namin sinasabi is, kung darating ang oras na sa pananaw namin ay kinakailangan, then syempre we will consult our client regarding the matter.
Pwede kaya si VP Sara kung dumating ang time na yun?
Never naman siya nagpakita ng any objection, no? But I guess it will have to really depend on kung ano yung takbo ng trial talaga.
Sir, just a matter of clarification. If the court should and if the court orders her appearance, may legal ways ba siya pwedeng gawin para hindi masunod sa dito? Or is she really required to face?
Well, we'll see. Of course, there will always be remedies, no? Especially if the issue is a fundamental right under the Constitution. So, tingnan po muna natin. I don't also want to preempt the presiding officer, si Senator Cheese Escudero, and also the senator judges. So, tingnan po muna natin. And then, pag dumating tayo doon, definitely magbibigay naman ako ng panayam kung ano pong magiging posisyon namin.
Attorney, sir, pagka po pinasabi na siya as hostile witness, i-assert po ba ng defense yung kanyang right against self-incrimination?
Isa yan sa mga bagay na available to us. Of course, I know kahit kahapon nabanggit ng presiding officer that these things might be debatable, diba? So tingnan po muna natin, no? But kasi ang hirap magsalita habang wala pa naman yung motion ng prosecution. So tingnan lang po natin, but definitely we're aware of the remedies available to us. And then, syempre, it will be done in consultation also with the Vice President.
Attorney, according to prosecution, there's still a possibility for them to question yung 16 threshold to convict the Vice President. What's the reaction?
I think naman that in fact, nasabi yun, I think doon sa proceedings natin, that any party has the right to raise an issue before the appropriate forum, whether it be the Supreme Court, no, to question yung ganung current standing or position ng impeachment court that it has to be 16 to convict. It's well within their rights, but of course, if they file, I'm sure the Supreme Court or whatever appropriate forum they file that in will ask us to give our comment also.
Pero hindi ba magiging pangamba sa defense team kung bababa yung threshold?
Hindi pa namin iniisip kasi nga nung tinatanong niyo ako 2 weeks ago, ang sabi ko is wala pa namang categorical pronouncement. Ngayon, nagkaroon ng categorical pronouncement na 16. So, pag dumating man sa panahon na gustong i-question yon, we will just submit our comments then. No? But sa amin, isa lang naman ang posisyon ng defense dyan sa threshold. The Constitution is clear for us. Thank you.
16.
Thank you. Yun na lang siguro, Sir Ian. We'll just leave it as that. No, the Constitution is clear. All members of the Senate.
Sir, magiging regular ba yung pag-visit ni Vice President?
Wala kaming schedule. Yung kahapon po talaga, kaya nga ayokong bigyan ng laman sana yun kasi yung kahapon biglaan lang that we asked for a meeting, she was available, and she also wanted to see us, and she also wanted to thank everyone in the defense team in person. So napag-usapan na dadaan siya kahapon. Pero kung kailan siya pupunta next, hindi pa po namin napag-uusapan.
Sir, habol lang, baka nasabi ni VP, ano po yung napag-usapan nila ni Senator Marcoleta nung binisita niyo dun sa PNP General Hospital?
Ay, hindi namin napag-usapan, ma'am. Kasi,
Was planned,
but
planning to visit?
I don't know. I'm not from OVP anymore. So I'm only her lawyer. So I wouldn't know her schedule. But hindi namin napag-usapan kung ano yung ano. And I think that's something private to them. So she's not the type also to naikwento kung ano yung mga napag-usapan.
Sugan ko lang po yun. Can this affect the case? Kasi as we all know, Senator Marcoleta can still go. And at this point, sabi nila, may posibilidad pa rin na pwede siyang pabotohin doon sa kaso ni VP Sara. So yung meeting po ba nila ay mapaling maka-apekto doon sa kaso?
I don't know. I think well, I don't want to speculate, to be honest, but she always visits naman people who consider her friends and give her support, 'di ba? Syempre lalo na mahirap yung katayuan ni Senator Marcoleta. So, but will it affect the case? Nababanggit na naman sa impeachment court, 'di ba, na if hindi ka makapag-participate one way or the other, then that's actually in favor of the defense because abstain ang mangyayari, hindi ba? Or no vote. So, yung mga ganyang bagay. Medyo masalimuot. I don't want to, we're just talking here, no, as on a theoretical sense. So, I don't want to get into the merits. Hintayin na lang natin kung may maghain ng petisyon, dahil sabi naman, baka may maghain, and we will comment. Thank you. Thank you.
Clickbait daw po yung pagbisita ni Vice President.
Sabi ng defense? Sabi ng prosecution.
Yung Ortega daw po nagsabi na clickbait daw yun.
Well, he's entitled to think whatever he wants to think about it. I respect Representative Ortega. But sa amin, sinabi ko lang sa inyo kung ano yung totoo. In fact, when I came in here, ayoko nang mag-expect kayo. So sinabi ko na kaagad, no, na she's only here for a meeting with us. Thank you. Thank you. I have to go na kasi magto 2 p.m. na po. Maraming salamat. Maraming salamat.
hereby called to order. We shall be led in prayer by Senator Pia Cayetano. The clerk of court will now call the roll.
Roll call of members.
Senator Judge Aquino.
Senator Judge Aquino.
Senator Judge Cayetano.
Senator Judge Cayetano Alan.
Senator Judge Cayetano.
Senator Judge Cayetano Pia. Senator Judge De La Rosa. Senator Judge Ejercito. Senator Judge Estrada. Senator Judge Go. Senator Judge Ontiveros. Senator Judge Lacson. Senator Judge Lapid. Senator Judge Legarda. Senator Judge Marcoleta. Senator Judge Marcos. Senator Judge Padilla. Senator Judge Pangilinan. Senator Judge Soto III. Senator Judge Tulfo Erwin. Senator Judge Tulfo Rafi. Senator Judge Villanueva. Senator Judge Villar Camilo. Senator Judge Villar Mark. Senator Judge Zubiri. The presiding officer, Senator Judge Escudero. Senate President Gatchalian.
With 20 senators present, the chair declares the presence of a quorum. We recognize the presiding officers, Senator Chis Escudero.
Thank you, Mr. Senate President. The presiding officer dispenses with the reading of the journal, and if there are unless there are objections, considers the journal of July 7, 2026 as approved. The clerk of court will please call the case before the impeachment court.
Case number 004-2026 in the matter of impeachment trial of Vice President Sara Duterte.
Appearances of the parties. Tech, kindly turn on the mic.
Good afternoon, Your Honors. Same appearance for the prosecution. We are ready, Your Honor. We are ready, Your Honor.
Appearances for the respondent.
Good afternoon, Your Honors. Same appearance for the Vice President.
Clerk of court is instructed to kindly bring the witness that was testifying yesterday. I believe Mr. Calilong.
Your Honor, the prosecution is ready for the continuation of the presentation of our first witness, NBI Agent Calilong. And with that, Your Honor, we would like to request that Attorney Virgil Ligutan, Attorney Amado Ligutan be recognized, Your Honor.
For the record, Attorney Ligutan will be representing the Counsel for Prosecutors, and on the part of the respondent, it will be Attorney Narvasa. That will be correct? By the way, while we're waiting for the witness, Attorney Narvasa, if you recall yesterday, Attorney Ligutan, in response to a question by a senator judge, gave a discussion a peroration, if you will. But yesterday I said we will be giving counsel the same opportunity. I cleared it earlier with Senator Pia Cayetano who wanted the statements deleted from the record. However, since this is a televised proceeding, nakita na eh, napakinggan na eh. So, i-erase ko man sa record, baliwala na lang. The fairest thing to do is to give you an opportunity as well. Attorney Ligutan spent 5 minutes and 18 seconds delivering his discussion. The court will give you the same time after your cross-examination
Your
with a
Honor.
warning. With a warning and reminder from the presiding officer that the presiding officer will not tolerate such perorations again by either party, even if it is in response to a question of a senator judge, and the presiding officer will try to remind as best we can senator judges to let the witnesses present the evidence of both parties instead of the counsels presenting both facts and law through their statements. Senator Judge Cayetano. Alan.
I'd like to thank the presiding officer for prudence, for wisdom in trying to resolve this issue. And I do understand that we are 24 people, all elected by the people, all wanting justice, all wanting a fair trial. Having said that, prudence dictates that we stop ourselves from asking certain questions that can prejudice the whole trial, whether or not our intention is to do so. So the problem is well stated by the presiding officer that if we simply delete from the record, mapapanood nyo na rin naman sa YouTube yung magandang discussion ng prosecution. So, on one sense, it is fair to give the defense a chance to answer. But on another sense, it's unfair. Why? Because whoever phrases the question, lamang na eh. Kasi yung question nga is, why is this an impeachable offense? So for example, if I was the one who stood up yesterday and I asked the prosecution, why is this a political vendetta? And why is the House not investigating the flood control instead of investigating the Vice President? That would be unfair. That would be unfair to the House. That would be unfair to everyone. So simply giving the prosecution the chance to answer that question I asked would be unfair to everyone. So I do not know the solution. I accept the solution of the presiding officer. Now, let's not tolerate any more questions like that. I agree with Senator P. I don't like being called out. But that's the role of the presiding officer and the Senate President. No. So, sana yun lang, no, na one, when we ask the questions, we'll make sure it doesn't prejudice the whole trial. Whatever we say here, may ma-accuse na lawyering for the prosecution or defense. Okay lang yun. Okay lang yun. Sa prayer nga kahapon, di ba? Basta't justice, bahala na magalit. Okay. But my last point, Mr. President, let's give the defense a little latitude in not only answering that question, but what you want to say. Because nga, the question is unfair. So if you're simply going to answer that question, then it won't solve the problem na nakapagsalita sila 5 minutes, kayo nakapagsalita. So we'll consider, personally, I'll consider the very eloquent answer yesterday as a sort of a closing. So same, personally lang, Mr. Presiding Officer, give the latitude to the defense na parang closing din, whatever. Because they have affirmative defenses. And they did not push us to hear that. They went straight to trial. So dun din sa mga nagsasabi na delay sa dami ng objection, that's unfair. No? Let's give everyone latitude here. The same thing, I think, may konting ano sa internet na photocopies are not original and the counsel was simply citing, tama ba? A Supreme Court decision, no?
And the rules of court.
And the rules
Your
of
Honor.
court. So I'm just saying it's an emotional issue. So all of us will be hit, badgered, whatever. I think trabaho naman nung witness natin, bantayan yung internet. So as long as hindi foul, hindi threat. But having said that, Mr. President, let's give each other leeway, but only to the point that the trial will not disintegrate, di ba, into a political fiasco or circus. Thank you, Mr. President.
The remarks of Senator Judge Alan Cayetano are noted. Senator Judge Pia Cayetano.
Thank you, Mr. President. This will be brief. First of all, I'd just like to confirm that I acknowledge what the presiding officer said, that I agreed. Basically, I'm withdrawing my motion in the interest of fairness, because the delivery of justice is about fairness. So kung nakapagsalita nga ang prosecution with their closing statement, di pwede rin dapat mag-closing statement ang defense, no? So I am amenable to that. But very, very, very briefly, Mr. President, I'd like to put on record, why are we being strict about the rules? Why do I have to bother standing up? Well, because nothing in this world will run well without the rules. Now, my colleagues, the Senate is a basketball-loving Senate. Dami dito, hilig mag-basketball. Kung ako volleyball player, colleagues ko basketball. I'll use basketball as an example. Will you have a decent basketball game if there's no rules? No, there's rules. That's why we stand up. And then sometimes there are also opportunities to question the rules. That's also fine. But that's why we have to stand up and call the attention of the presiding officer when we feel that the rules are being violated. And we will continue to do so when we believe it is necessary in the interest of justice. Thank you, Mr. President.
The remarks of the lady are noted. Since we are discussing housekeeping chores and matters, let the presiding officer continue with the same. The presiding officer will call for a break midway through in order to afford the parties 15 minutes to relax, go over their notes, and do their thing. In regard to senator judges or counsels for the parties who are not on deck, you're free to answer the call of nature in the least disruptive manner possible and return afterwards outside of the 15 minutes that we will be doing halfway through the proceedings. And finally, a request has been brought to the presiding officer to request as well the senator judges to lower the tone of conversational voices because I think where you're seated is an echo chamber. Naririnig sa iba't ibang sulok ng plenaryong ito yung mga sinasabi din ninyo at hindi rin nakakapag-concentrate yung ilan sa ating mga kasama na nakaupo sa paligiran ninyo. Just a reminder, and one last reminder before I recognize counsel for the respondent, Mr. Calilong, you will be testifying once again and will be undergoing cross-examination under the same oath
Yes, Your
that you
Honor.
took yesterday. Do you understand that?
Yes, Your Honor.
Thank you, counsel for respondent. Attorney Narvasa, if you're ready, you may proceed with your cross-examination.
Your Honor, may I be allowed to approach a witness?
You may do so.
Thank you,
counsel.
Your Honor. Good afternoon, Mr. Calilong.
Good afternoon, sir.
During your direct examination, you testified that you were trained on photo and video authentication.
Yes, sir.
You said that you were trained for 2 weeks?
Specific for photo and video, sir.
Sir, my questions are answerable by yes or a no. Can
Yes, sir.
you please constrain yourself to these questions, unless I tell you, okay?
Objection to that, Your Honor, please.
And you got this training
Your Honor,
from
can I object to that? I have to
Before
make an
counsel for
objection.
respondent proceeds, counsel for the prosecutor to let the presiding officer
Your Honor.
recognize you first. You are so recognized, sir. What is your objection?
Thank you so much. Inasmuch as I would like to accommodate the defense that in asking the question that the witness is to be limited to a yes or no question, Your Honor, please. Unfortunately, Your Honor, please, that's not sanctioned in the rules. There's nothing in our rules that would allow a defense to constrain a witness, even on cross-examination, to answer the questions by a yes or no answer. It's not in the rules. So, Your Honor, please, we cannot constrain a witness to answering either a yes or a no. The witness should be able to qualify. The usual answer by the defense is that it could be handled by the prosecution on redirect. But that is not the case, Your Honor, please. So long as there is nothing in the rules that would allow the defense to constrain the witness to answer yes or no, the prosecution will vehemently object to that, Your Honor,
The
please.
presiding officer
May I, Your
overrules
Honor?
the presiding officer overrules the objection. The counsel for prosecutors can make a continuing objection regarding this matter, but it is the position of the presiding officer that the witness is seasoned enough. According to his testimony yesterday, he has attended over, if I recall correctly, 30 hearings already. So he would know how to respond and to explain if the need would arise. And it's up for counsel for the respondent, if at all, to strike out whatever answers that are not responsive to his question. Counsel for respondent may proceed.
Thank
We
you.
would abide, Your Honor. We would abide.
Thank you, counsel for the prosecutors.
And you testified that you got this training from MaxCore Interventures.
Yes, sir.
And you said that the training you got from MaxCore Interventures was in digital forensics.
Yes, sir.
I have with me in Articles of Partnership of MaxCore Interventures Co. You see that it states that it is the Articles of Partnership of MaxCore Interventures Co.
Your Honor, may we allow Attorney Stephen Magallon to also approach the witness stand to peruse the document. And of course, at this juncture, Your Honor, please, I have to object.
I have no question yet, Your Honor.
Yeah, I am objecting to the witness being shown an articles of incorporation. A partnership of a partnership, Your Honor, please. Anyways, since the question has not been asked, I will.
Let us wait for the question, counsel. In the meantime, the presiding officer allows counsel for the prosecutors to examine the document being presented to the witness.
And Your Honor, for the reference of the senators, we are flashing this Articles of Partnership on the screens. Sir, please take a look at page 2 of these articles. Page 2, sir. That's here. Page 1, page 2. Let's read it together, okay? Primary purpose, to engage in the business of trading both import and export of goods on wholesale, retail basis. Do you see that, sir?
Yes, sir.
Now on page, the same very same page 2. The secondary purpose. Let's read it together again. Own, use, improve, develop, subdivide, sell, exchange, lease of all kinds, including buildings, houses, apartments, and other structures. Do you see that, sir?
Yes, sir.
After that, in the same page 2, the secondary purpose is to print, publish, distribute, buy, sell, acquire rights to and generally deal in all kinds of software packages, books, periodicals, newspapers, magazines, journals, and other publications dealing in or having to do with subjects of all kinds, character, and all acts of things as may time to time be deemed needful, necessary, or required. You see that, sir?
Yes, sir.
Thank you, sir. Now I'm showing you a screenshot of the website of this MaxCore Interventures Co. It states under About Us. I am also flashing this on the screen, Your Honors, for the ease of the senator judges.
Your Honor, at this juncture, the prosecution will now manifest that there was no question propounded as to the presentation of the Articles of Partnership. And the counsel is now moving forward to the presentation of an alleged website. Therefore, it seems that the defense counsel is the one presenting the documents without propounding any question to this witness. Highly improper, Your Honor, please. Highly improper. The counsel should be asking questions and not presenting document. You will have your turn when the defense team is allowed to present your evidence. 2 documents, no question yet. Highly improper, Your Honor, please. Again, I don't want to put the lawyer on the spot. But that is highly improper. Ask questions.
Your Honor, I did ask questions.
No, there was no question.
Counsel, can we ask that the transcript be read back?
Counsel, kindly proceed.
Thank you.
Counsel for the prosecutors, with the understanding that Mr. Calilong is not testifying as to the truth of whatever counsel asked him or what he read, because clearly he's not competent
Agreed,
to
Your Honor.
testify as to the truth of what is contained in the Articles of Partnership. However, as to the fact that he read it and saw it, up to that extent, and the senator judges are so advised as well. So ordered. You may proceed, sir.
Thank you, sir. And I am on cross, Your Honor. Thank you. Sir, under the words about us, it says MaxScore Interventures has been established as a one-stop source of different products and services intended for both government and private institutions. Its company tagline, Innovation Without Boundaries, stands true testament to provide customers with quality merchandise, from the simplest to the most sophisticated ones at very affordable prices. The company places a long-term business relationship through customer satisfaction on top of its priority list, with integrity and honesty as the foundation of the company. It envisions to evolve into excellence amidst the competitive pace of information technology. You see that, sir?
Yes, sir.
Sir, now I'm showing you another screenshot of the website of this MaxScore Interventures Co. You confirm that I'm also flashing this for the ease of the court. Sir,
At this point, Your Honor, please, allowed. The prosecution is allowed.
Counsel for the prosecutor is recognized.
Your Honor, not by way of an objection, but a manifestation, Your Honor, please.
Your Honor,
wait. I'm not
before
done.
that, I would like to object to your manifestation. Your Honor, there's no objection. Why is the
Your Honor,
prosecutor allowed to manifest during my cross-examination?
Counsel for respondent, kindly wait for the presiding officer to recognize you.
Thank you, Your Honor.
What is the desire of the counsel for the prosecutors to
I
make
would like to put into record the simple fact, Your Honor, please, that basis has not yet been laid as to the presentation of these documents. He presented an articles of partnership and screenshots of websites without saying who took these screenshots or who, from where did the defense get the articles of partnership. That is only by way of manifestation. No need for the court to rule on that, Your Honor, please.
Noted. Earlier ruling of the presiding officer stands. Counsel may proceed.
Your Honor, may I respond?
No need, counsel. It was not an objection. Please proceed with your cross.
Thank you, Your Honor. May I also state the manifestation, Your Honor? Your Honor, the basis of the defense was laid.
For the record, the chair will allow it just this once, please.
The basis of the defense was laid when we asked him whether he testified that he got his training as an expert witness from MaxScore Ventures. That's basis.
Counsel, please proceed.
Thank you, Your Honor. Sir, could you take a look at this? Under the words "our products," the products seen there are office supplies and equipment, ICT equipment, software and hardware, investigative equipment, hardware and software, emergency response software, and CCTVs. Do you see that?
Yes.
Thank you. Mr. Calilong, are you a lawyer?
No, sir.
Yesterday, you testified that you signed the affidavit of investigation dated February 10, 2025.
Yes, sir.
Your Honor, may I request a copy from the prosecution? I think it is Exhibit P-4-3 in series.
P-4-3
series.
Your Honor, please, manifestation. The witness, number one, mentioned the affidavit of investigation, but that the witness did not identify the documents. So for the record, Your Honor, please, that document is not yet presented in courts as the documentary evidence, Your Honor, please. So highly improper for the defense to elicit that document through this witness precisely because this witness did not yet identify the affidavit of investigation, Your Honor, please.
Which exhibit is this? I believe he did, Counsel, but which exhibit is this?
Exhibit P-4-3 to Exhibit P-4-3BB, Your Honor.
Your Honor, please, if I may, it was not yet identified, but it's pre-marked, Your Honor, please, to be presented by our next witness, Attorney Jeremy Lotok. So highly improper in as much as we want to accommodate the defense.
So who is the signatory in that document? Is it
Your Honor, Mr. Kalilong is a signatory to that document.
is one of the signatories?
Yes.
Is one of the signatories. But the counsel for prosecutor is correct. This document has not yet been identified by any of the witness for the counsel for the prosecutors.
Yes.
You will get your chance, counsel for the respondent, when Attorney Lotok testifies later, which I believe this is the only exhibit that he will be testifying to.
All right, Your Honor.
Kindly proceed, counsel.
You mentioned a affidavit of investigation, correct?
Yes, sir.
And this affidavit of investigation, you sent a copy to the House of Representatives Committee on Justice.
Yes, sir.
You identified it during the House Committee hearings on April 29, 2025.
Yes, sir.
I'm showing you now an affidavit of investigation. This is marked as Exhibit D-4-46 and series, Your Honor.
D-4-46 and series. Is there a counterpart marking from the counsel for prosecutors?
Yes, Your Honor. This is P-4-3 to P-4-3BB.
Thank you. For the record.
This annex of this affidavit of investigation has appendages, correct? Annexes.
Yes, sir.
And it forms a whole, correct?
Yes, sir.
Okay. Sir, do you confirm that you signed this?
I'm one of the signatories, sir.
Do you want me to have him identify signature? Okay. Your Honor, do you have here, sir? Kaso lang, sir, yung sinumpit remote po, I withdraw, Your Honor. Apart from this affidavit of investigation, dated February 10, are you aware if there is another affidavit of investigation executed by the NBI represented by the Cybercrime Division in relation to this case?
This is the only one that is submitted, sir.
No, executed, signed.
Your Honor,
My question is
the defense
executed.
cannot argue with the witness, Your Honor, please.
The witness would know how to respond, counsel. If he is not responsive to your question, do not argue with the witness.
Yes, Your
Kindly
Honor.
rephrase.
Apart from this affidavit of investigation, are you aware if there is any other affidavit of investigation signed by the NBI represented by the cybercrime?
Okay, at that juncture, I have to object. Vague, Your Honor, affidavit of investigation signed by
Related
the
to this
NBI.
case,
There
Your
could be thousands
Related
of
to this
documents.
case.
If the witness knows, witness may answer. Is there any other affidavit of investigation executed by the NBI cybercrime in relation to this case, witness?
As far as I remember, sir, this is the final affidavit of investigation, sir.
Final affidavit. Are you sure, Agent? Let me remind you that you are under oath.
Yes, sir.
I have with me a certification, a DOJ certification executed by J.V. Lawrence B. Bandung, Senior Assistant State Prosecutor J.V. Bandung. For the record, Your Honor, this is Exhibit D-4-29 for the defense. Do you see this, sir?
Yes, sir.
This certification dated February 5, 2025, states, and I quote, the complaint referral does not contain all the necessary evidence to prove the essential elements of the crime. Therefore, it is recommended that the same be first referred for case buildup. Do you see that?
Yes, sir.
Now below that, in the second page, below that, under the word notes, number 1, therefore, states, and I quote, that there is no... May I have this flashed on the screen, please? For the ease of the court. So the Honorable Court can follow. Under notes again, sir. For the record, Your Honor, we are flashing the certification on the screen. Under notes, sir, number 1 therefore states, and I quote, there is no affidavit of the persons who recorded the video entitled VP November 23 Press Con at Batasan through open broadcast software OBS and in turn stored it in a digital video disc. Do you see that, sir?
Yes, sir.
Let's go to page 2. On paragraph 7, it states, and I quote, one of the elements of the crime of grave threats is that the offender threatens another with infliction upon the latter's person, honor, or property, or upon that of the latter's family of any wrong amounting to any crime. In the instant complaint, only the NBI executed an affidavit and there was no participation on the part of the offended parties, as it appears. NBI is not the offended party for the crime of grave threats. Do you see that?
Yes, sir.
Above this, in paragraph 6, it states that, and I quote, only the minutes of the meeting with several personalities and representatives from various media outfits were submitted. And although the minutes were signed, there was no individual affidavit executed regarding the contents of said minutes. Do you see that, sir?
Yes, sir.
On paragraph 5, it states that, and I quote, the affidavit of one Patria Morales mentioned that she stored these footages in a USB and submitted it to the NBI. However, there was no USB attached to the complaint, only a DVD was attached. There was no detail regarding the contents of this DVD. Do you see that, sir?
Yes, sir.
On paragraph 4, it states, and I quote, Annex L did not indicate who made such TSN. There was also no affidavit of the person who made the TSN. Do you see that?
Yes, sir.
On paragraph 3, it states that, and I quote, Annexes I and K -CNN-C-2412-43-6-2 and NBI-CCN-C-24-12-436-2, close parenthesis, were not accompanied by an affidavit of the record and TSN, also affidavit of the one who will execute the TSN.
Yes, sir.
On paragraph 2, it states, and I quote, the press briefing conducted on October 18 was not recorded and or stored in a DVD, no video submitted, and there was no TSN of the said briefing and the necessary affidavit of the person taking the CSN. Now, you are aware, sir, so now, is your memory refreshed, sir? Did the DOJ send back the original affidavit of investigation to the NBI?
Yes, sir. As far as
Thank you. Now, you are aware that on February 11, 2025, the NBI, through its then director, retired Judge Jaime B. Santiago, wrote to the Office of the Prosecutor General submitting a revised affidavit of investigation.
Yes, sir.
This is your affidavit of investigation dated February 10, right? February 10, 2025.
So,
Yes, sir.
wait. So, objection, Your Honor. The defense said that this is your affidavit, dated February 10, without showing any document to
I'm
the
asking,
witness.
sir,
How could the witness answer to a question that is not accompanied with a document? That should be the basis for the question and the
and
answer,
this
Your
is
Honors.
your affidavit. I will reform, Your Honor.
Kindly reform, Counsel.
Thank you, Your Honor. This is your affidavit dated February 10, 2024, correct? Please check. Sorry, sir.
Your Honor, can I make a manifestation, Your Honor, please?
Your Honor, can we object again to this manifestation?
Manifestation. I will not even object. I'm being generous. Your Honor,
Counsel,
wit-
let's wait for the witness to review it. It's a voluminous document.
Ano,
The signature is on the last page. You can make the corresponding objection to
signature.
the style, manner, or cross-examination of the counsel for responding at the proper time.
Ayan po. Is this the amended affidavit of investigation?
This is a photocopy of the
Yes, sir.
affidavit, sir.
This is the amended one.
Yes, sir. The photocopy, sir.
Thank you.
With the permission of counsel, Mr. Calilong, what was the date of the first affidavit you submitted that was returned by the DOJ to the NBI?
As far as I remember, January 30. And was, when the certification was issued, we complied with the requirements and submitted it on February 10. That's why there's a
Have you
revision.
identified that affidavit of investigation dated January 30 in yesterday's proceedings? No. Yes or no?
Sir?
Have you identified the January 30?
The one that I identified, Your Honor, is the authentication, Your Honor.
Not the affidavit of investigation. So you have not done so.
Yes, sir.
This one, you have not done so too.
Yes, Your Honor.
For the record, counsel, you may proceed.
I'm showing you now a letter dated January 30 from the former NBI Director Jaime Santiago.
Now, I have to object, Your Honor, please. You know, the defense has been confronting this witness with documents, even without marking and identifying the source of these documents.
Your
It's
Honor,
like
that's-
plucking out of thin air a document, presenting them the document to the witness, and withdrawing the document.
Your Honor, that's up
Without
to the...
even introducing this piece of evidence, this piece of exhibits into evidence. So my question is, through the presiding officer, is the defense not entering these documents into evidence, Your Honor, please?
They can do so at the proper time, counsel, but insofar as the witness is concerned, I think the basis was laid when he said that he executed only one affidavit of investigation in connection with this case. Now it seems that there are two affidavits.
I would like to make
both of which have not yet been presented. One will be presented, I think, by Attorney Lotok.
Your Honor, for
But
the
first
record-
one, we're not aware of it. Is that correct, Counsel for the respondent?
Your Honor, he just identified a copy of the affidavit of investigation.
Dated January 30?
April 10, 2025.
April
February
February
10.
10.
Sorry, Your Honor. February 10.
February 10, Your Honor, please.
What about the first affidavit? The witness said he had the first affidavit.
Yes, Your Honor. Not yet.
Not yet.
Yes.
You only cited a January 30 letter of
Yes,
the
Your Honor.
former NBI
I cited, Your Honor, a
Director.
certification by the DOJ returning an affidavit.
And that is now the problem, Your Honor. In fact, even I am confused because the documents are not introduced into evidence by the defense.
Counsel, please proceed and kindly help the court to be clarified
you.
regarding this matter.
You mentioned that that you were aware that the then director, retired Judge B. Santiago, wrote to the office of the Prosecutor General submitting affidavit of investigation on February 11, 2025. I'm showing you now that letter dated February 11, 2025. For the record, this is Exhibit D-4-43 for the defense.
Up for the defense, you mean pre-marked, I
Pre-marked.
suppose. Because when you say marked as evidence for the
Pre-marked.
defense, it's not yet. Your turn has, you have yet to present your exhibit, so it should be pre-marked, Your Honor, please.
No, it's pre-marked, and I believe both the defense and the respondent and the prosecution also have common pieces of evidence which you decided during pre-trial. This is not one of them, which you decided during pre-trial to be marked
It's
separately.
not one of those few common pieces of evidence.
Yes, there are a few.
Sir?
Please proceed, counsel, for the respondent. Witness the answer.
There is a signature above the name Judge Jaime B. Santiago. Whose signature is that?
Your Honor, now I would like to object to the relevance. A letter is being, the witness is being confronted with a letter coming from the former NBI Director, Judge Jaime B. Santiago, and this witness is now being asked to identify whose signature is that. That's obvious.
I'll allow it conditionally if you can show the relevance
Your Honor.
insofar as your ability to test the credibility and the accuracy of the witness is concerned. In the meantime, I'll allow it. Kindly show the connection, counsel.
Thank you. Sir, whose signature is this?
As far as I remember, signature of Director Santiago, sir.
Thank you. On the last line of the letter, on the fourth page, sir, please take a look. Last line. It says, and I quote, "To support our recommendations attached herein is the revised affidavit of investigation, including its attachments." Did you see that, Agent?
Yes, sir.
Thank you. And you confirm that the former NBI Director, Jaime Santiago, wrote to the Prosecutor General, Richard Anthony D. Fadolion, a letter dated January 30, 2025. This is one of the documents that you submitted to the Committee on Justice, correct? Okay, I will show you now. May I have this flashed on the screen? Do you recall this document?
Yes, sir.
Yes. January 30, 2025 is a date earlier than February 10, 2025, correct?
Yes.
Your Honor.
Hasn't answered,
for the
Your Honor.
prosecutor.
Your Honor, the witness being asked which
Your Honor,
date,
asked and
came
answered.
first. I mean, relevance, Your Honor. Relevance.
Counsel, if the witness knows and the counsel for respondent will be given the latitude to test the credibility, accuracy, and completeness of the testimony of the witness. But we note your continuing objection because you already sound frustrated, counsel, in regard to this line of questioning by the
I'm very
counsel for the
patient, Your Honor,
respondent.
please. I'm very patient.
The counsel for respondent may proceed. Witness
Thank
may
you.
answer.
He already answered, Your Honor. Thank you. You earlier confirmed that there was actually a certification dated February 5, 2025. You
Objection, misleading. I don't
I have no
remember
question,
this
Your Honor.
witness
Let
stating
the
that there
counsel
was...
finish with this question, counsel.
He even read it, Your Honor. You likewise confirmed that in that said certification, dated February 5, 2025, the earlier affidavit of investigation were subject to 7 recommendations. And you confirmed that you read that.
Objection. Misleading, Your Honor,
objection?
please. Now the counsel mentioned 7 grounds. 7 grounds. And I don't remember this witness uttering the term 7 grounds. What I do remember, Your Honor, please, is that this witness was confronted with a certification, a letter, whatever, but now the counsel is now asking this witness to confirm the contents of those certifications or letters. Misleading.
No,
That's
Your-
not allowed during cross. The counsel is now assuming facts that have yet to be established. Can I repeat that? This witness was only confronted with certifications, letters, dated this, dated that. And now, the counsel now asking,
Your
do you
Honor, please.
confirm?
He's
Do you
now
confirm,
testifying.
right? Wait, let me finish. Now he is asking this witness to confirm that in that letter there are 7 grounds, as if this witness uttered those words. The ground is misleading, definition. This counsel is assuming facts that have yet to be established through this witness, Your Honor, please.
Counsel, again, the witness is not a newbie. I think he can handle himself and would know how to answer if indeed he is familiar or not with what is being presented to him. And thus far, he has responded based on his knowledge of these documents. Chair will allow it. Witness may answer.
Sir?
Can you repeat the question, counsel?
You confirmed that there was a certification dated February 5, 2025. You likewise confirmed that in said certification,
Your Honor, compound question.
there's no question.
Wait.
Kindly wait for the presiding officer to recognize you before answering.
Yes, Your Honor.
Yes.
Much
Please,
obliged, Your Honor,
counsel
please.
for the prosecutors, please finish with your objection.
Thank you so much. Can I?
Yes,
Your
please
Honor,
proceed, counsel.
Compound questions. The witness is now being confronted with 2 successive questions without allowing this witness to answer the first question. What makes a compound question?
No need to lecture, counsel. Counsel for respondent, please reform.
Your Honor, I had no question. I had no question yet.
Kindly proceed with your question.
Thank you, Your Honor. The earlier affidavit of investigation was subject to 7 recommendations from the DOJ
Vague, Your Honor,
for
please.
case build-up.
Objection, vague. The earlier investigation, which investigation is the counsel referring to?
We already
Objection, vague.
We already established, Your Honor, there was an earlier one. This is
Overruled. Again, the witness is competent enough to testify. Overruled. Witness, kindly proceed with your question, counsel.
Yes. In the revised affidavit of investigation dated February 10, 2025, that you identified, despite DOJ's recommendation number 6 that you earlier read.
Objection, Your Honor, objection.
Sir, Your Honor, I'm not
If
yet
the
finished.
ground is
Can we
already-
wait for the counsel to finish with this question, counsel, please?
Okay, Your Honor.
The question. Sir, there were still no affidavits of the journalists from the media outlets in your affidavit of investigation dated February 10.
Witness, not answer first. Objection, Your Honor, please. Misleading.
Why is it misleading, counsel?
The counsel said the earlier affidavit of investigation. In fact, Your Honor, please, he referred to the February 10 investigation. That's not the earlier investigation. That is the final affidavit investigation submitted to the DOJ. Misleading. Misleading, Your Honor.
Your Honor,
The presiding officer will ask the question. Mr. Witness, did you attach the affidavits of the two witnesses that viewed the video of the Vice President in the February 10 affidavit?
Yes, sir. Let me qualify my answer in number 6, sir.
You may do so.
In number 6, sir, the DOJ requested an affidavit to be executed regarding the contents of the minutes. I executed an affidavit attesting to those minutes, sir, which I'm part of the interview, sir.
But was it attached to the February 10 affidavit?
Yes, sir.
Counsel for the respondent, your witness.
thank you. Sir, but there are no affidavits of the journalists from the media outlets, correct? My question is not found there, Your Honor.
Oh, Your Honor, please.
My question is
I mean,
not
Your
found
Honor,
there.
okay, wait. The counsel is confronting the witness with a document, and he propounded questions,
was
and then
not-
he asked another question, and he took the document away. What's
Your
the
Honor,
purpose of that?
I was
Objection,
not-
Your Honor, please.
My question is plain, Your Honor.
Let the
Do you-
witness peruse the document you presented him with. Let him answer that through a document.
My question is plain, Your Honor.
Your Honor, a witness should be allowed to peruse the document
I am
that he
not-
was confronted with.
Counsels, please. Witness, I think the witness understood the question. Mr. Calilong, you may answer if you understand the question.
I will repeat the question, Your
Kindly
Honor.
repeat, counsel.
Thank you, Your Honor. There is still no affidavits of the journalists from media outlets appended on your revised affidavit of investigation, sir.
May I qualify my answer, sir?
No, sir.
Oh.
Just answer yes or no.
Kindly look at the document presented to you. On redirect, counsel can make you explain the disparity, if any. The question is simple. Are the affidavits attached to the affidavit of investigation?
May I see the question number 6?
Your Honor, my question does not relate to question number 6.
Kindly show the witness, counsel.
I will.
If it will enable him to give an intelligent answer
Can we
to your
please
question.
slash certification and put it to paragraph number 6?
The paragraph number 6 states that only the minutes of meeting with several personalities and representatives from various media outfits were submitted. Although the minutes were signed, there were no individual affidavit executed regarding to the content of the minutes. On this,
Okay, sir. I have no
So the
question.
answer is the affidavits are not attached.
I have executed an affidavit, sir.
No, the
Sir,
affidavits of the two journalists are not attached. I think that's the only question of
Yes, sir.
counsel for the respondent.
Thank you, Your Honor. Instead, sir, as you confirmed, what you appended to the affidavit of investigation are affidavits of NBI agents, correct?
Yes, sir.
Not the journalists who were present
The one who
during the
interviewed.
November 23, 2024 press conference.
The one who interviewed, sir.
Yeah, the one into interview. Not the journalists.
Yes, sir.
Ask and answer, Your Honor.
Sir, in the revised affidavit of investigation dated February 10, 2025 that you identified, despite DOJ's recommendation number 7, can we show again DOJ recommendation number 7? In the certification dated February 5, 2025, it is still the NBI Cybercrime Division that is the complainant?
I believe this is answered on the letter of the director, sir.
Sir, my answer is answerable by yes and no. The complainant is still the NBI Cybercrime Division.
Yes, sir.
Thank you. The supposed offended parties in this case would be President Bongbong Marcos,
Yes, sir.
the First Lady Liza Marcos,
Yes, sir.
the former Speaker of the House Martin Romualdez.
Yes, sir.
Did President Marcos appear before the NBI during its investigation?
No, sir.
Did the First Lady Liza Marcos appear before the NBI during its investigation?
No, sir.
Did the former Speaker Martin Romualdez appear before the NBI during its investigation?
No, sir.
Sir, I'm showing you again for the record the affidavit of investigation. Sir, did you attach to that affidavit of investigation dated February 10, 2025, an affidavit of the President Marcos?
Only the responses, sir.
Sir, listen to my question.
That's
Did
the
you-
answer.
Your Honor, he did not answer, so I am entitled to
That's
ask
his
again.
answer.
Not responsive. The question was, Mr. Witness, did you attach the affidavit of President Marcos to the February 10 affidavit?
No, sir.
Did you attach an affidavit of the First Lady Liza Marcos on your affidavit?
No, sir.
Did you attach an affidavit of former Speaker Martin Romualdez on your affidavit of investigation?
No, sir.
To your knowledge, if you know, sir, did President Marcos file any criminal complaint against Vice President Sara Duterte as a result of the November 23, 2024 online press conference?
He made a statement,
No, sir. My question is, if you know, did the President file any criminal complaint against the Vice President?
I have no personal knowledge, sir.
Did the First Lady Liza Araneta-Marcos file any criminal complaint against VP Sara?
I have no personal knowledge.
How about the Speaker Martin Romualdez? Did he file any criminal complaint against VP Sara as a result of the November 23, 2024 online press conference?
I have no personal knowledge.
Did you really investigate this case?
Oh, Your
Withdrawn,
Honor,
Your Honor.
argumentative,
Withdrawn.
Your Honor, please.
Withdrawn.
Did you really investigate this?
How about
Question
the
has been
Speaker
withdrawn.
Martin Romualdez? In other words, sir, the alleged offended parties were not included as complainants in the case you filed with the Department of Justice.
Yes, sir.
Thank you.
Based-
Thank you. And despite the fact that the NBI Cybercrime Division did not comply with recommendations number 6 and number 7 in the certification date February 5, 2026, it nevertheless filed the revised affidavit of investigation dated February 10, 2025 that you identified today.
Can I qualify my answer, sir?
No, sir. Just answer with a yes or no.
Witness may be allowed to answer according to how he wishes to explain.
Oh.
You may proceed, Mr. Witness, to answer.
Yes, sir. Thank you, Your Honor. For this case po, we complied with the requirements of the DOJ. That's why we secured a second certification wherein our documents is enough for preliminary investigation, sir.
Okay. Thank you. And this certification is a certification dated February 5, 2025, correct?
Kindly show the witness the
This is not the new certification, sir.
Oh, sorry, sir. So, apologies, Your Honor. February 11.
Yes, sir.
This was also executed by Senior Assistant State Prosecutor J.V. Lawrence B. Bandong, correct?
Yes, sir.
Now let's discuss the nature of the investigation you conducted. You claimed in your affidavit, sir, affidavit of investigation, that the NBI began its investigation into the VP's remarks because it was directed by the DOJ to do so.
Motu proprio and directed, sir.
Okay. Do you understand what you just said, sir?
Oh,
yes, sir.
Oh. Can I
I'm
object to
asking,
that,
sir.
Your Honor, please? That's
I'm asking, sir, it
argumentative.
makes sense, Your Honor.
Argumentative, counsel. Move on.
Mutuo proprio, sir, means...
Oh, no, objection. You cannot lecture, counsel. This is
Sir, what does
cross-examination.
you mentioned mutuo proprio. What does it mean?
Even without a complainant, we started the investigation, sir.
Are you sure, sir?
Oh, argumentative. Are you sure, sir?
Move on, counsel.
Are you sure,
move on.
sir?
How... How about direct investigation? What does that mean?
Your Honor. Okay, never mind. Your Honor.
Directed investigation. What does that mean?
There is instruction from above, sir.
From?
Above. From
Above.
upper.
What does above mean?
It may be the DOJ or the higher.
Higher. What's higher than the DOJ?
Based on that, it's only the DOJ, sir.
Based on... You said above the DOJ, sir.
No, sir. Above the
Sir,
NBI, sir.
you said above... May I ask for a
Argumentative,
reading?
Your Honor.
Counsel,
Argumentative.
counsel, again, I would have to sustain the objection. It is argumentative. I heard
All
the
right,
answer, and he meant as a general term above, but referring apparently to only the DOJ in this particular instance.
We submit, Your Honor.
Please proceed.
You confirmed that the NBI Cybercrime Division is the complainant in the case against the Vice President, and that the DOJ filed this with the NBI filed this with the DOJ.
Objection. Compound,
No,
Your Honor. That's a
no
compound
question, Your Honor. That was just a statement.
Counsel,
Oh,
kindly
exactly. Your Honor, a
Is laying
statement.
the basis for a question. Go to your question, counsel.
Sir, the NBI, of course you're from the NBI, is under the Department of Justice.
Yes, sir.
Your Honor, we can take judicial notice of that.
Your Honor, if I'm on cross, Your Honor.
I know, but
I'm on cross.
there are things that
No.
need not be
Your Honor,
discussed.
please.
Can I, Your Honor?
Your Honor, please.
Counsel, let's give him some latitude.
Much obliged, Your Honor, much
Although we
obliged.
can't take judicial notice of that, it's part of his cross-examination.
Yes, thank you, Your Honor.
Mr. Witness?
The Secretary of Justice exercises control and supervision over the NBI. Yes or no?
We are under, sir. But we're independent.
So you do not know.
Oh, Your Honor, that's argumentative. So
Sir,
you
are
do
you-
not know?
All right, Your Honor. Are you aware of Book 4, Chapter 8, Supervision and Control of the Admin Code?
Your
Section
Honor.
39. Your Honor,
Yeah,
I have
Your
no
Honor.
question yet.
Yeah.
Please.
Yeah.
Section
Counsel for
39.
the prosecutor, let the counsel for respondent finish his question.
Yes, Your Honor.
Section 39 thereof, Secretary's authority. The Secretary shall have the supervision and control over the bureaus, offices, and agencies under him. Supervision and control. Sir, my question is this. Is the NBI, the National Bureau of Investigation, under a bureau under the Department of Justice?
Yes, sir.
Thank you. And, sir, the President has control over all executive departments, correct?
I believe so, sir.
The DOJ is one of those executive departments, correct?
Yes, sir.
And the current President is Ferdinand Marcos Jr., correct?
We agree to that. That's judicial notice.
Your Honor, please. Yes
There's
or
no
no?
other president. We
Oh,
only
he
have one
answered already, Your Honor.
president.
Already asked and answered.
The head of the executive branch is President Ferdinand Marcos Jr., correct?
Yes, sir.
The very same Ferdinand Marcos Jr., who you said was an offended party in the case against Vice President Duterte.
Yes, sir.
So, in other words, the NBI investigated and filed the complaint. The DOJ directed the investigation and will determine whether the case should proceed to court. And the alleged offended party, President Marcos, is the constitutional head of the executive branch,
Objection.
exercising control over both the DOJ and the NBI. I
Your Honor,
withdraw, Your
objection
Honor. I
to that.
withdraw. I withdraw, Your Honor.
The ground is,
I withdraw.
It's, oh, Your Honor. It's even more compound question,
Nothing to
asking
object to.
several
Withdraw,
subject
Your Honor.
matters.
Withdraw.
Counsel, move on.
Withdrawn.
Sir, you testified earlier that you investigated the Vice President in relation to the press briefing that she conducted on November 23, 2024.
Yes, sir.
This investigation by the NBI Cybercrime Division was started after the conduct of the November 23, 2024 press briefing of the Vice President, correct?
Yes, sir.
So basically, to put it simply, the investigation was done after the supposed incident on November 23, 2024.
The same day, sir.
The same day, but after.
Oh, Your Honor, the same day, then after.
Same,
How
not
could it be the
responsive,
same
Your
day
Honor.
then after?
Clarify your question.
The investigation was done after, later than, the supposed incident on November 23, 2024.
Yes, sir.
Thank you.
You mean to say later that day?
Yes, Your Honor.
Because how can you investigate something that hasn't happened yet?
Correct.
Yes, Your Honor.
Please proceed.
Sir, you're not one of the participants of the press conference on November 23, 2025, correct?
Yes, sir.
So you do not have personal knowledge about what transpired during that press briefing, correct?
It was live streamed, sir.
You did not watch that live stream, correct? In
It was-
real time.
Yes, sir.
You only acquired knowledge about it when you started investigating later that day.
Yes, sir.
You also do not have personal knowledge of the alleged threats made by the Vice President during that press conference. Press briefing, sorry.
After the press briefing, sir.
You only acquired knowledge about it when you started investigating.
Yes, sir.
You also do not have personal knowledge of the alleged assassin that was allegedly hired by the Vice President.
It came to my knowledge upon...
Personal knowledge, sir.
No, sir.
Now, during your testimony yesterday, you mentioned that during your investigation on the November 23, 2024 press briefing conducted by the Vice President, you preserved a copy of said press briefing through open source investigation, correct?
Preserve a copy through open broadcast software studio.
Okay, thank you for that correction. One of the videos that you were able to preserve in relation to your investigation is the screen recording of the November 23, 2024 press briefing conducted by the Vice President, right?
Yes, sir.
Your Honor, may I move that the very same USB be unsealed and shown by the prosecutor's Exhibit P-4-10 be unsealed and shown the witness.
Counsel for the prosecutor so instructed.
Thank you, Your Honor. Okay ka lang po.
November 20.
This is Exhibit P-4-10, I believe. Your Honor, may I request that he unseal the USB and that it be allowed to be played?
Which part, Counsel?
Your Honor, we will play various parts of the, not the whole, for the, as the...
That's what I was worried about.
Yes, Your Honor. We understood by the faces of the honorable members of the court. So
you will...
we will just...
play parts.
Yes, Your Honor.
Of it. And you identified, I presume, the time stamp.
Yes, we have, Your Honor. I will get to that.
Witness may open the seal.
Thank you, Your Honor.
And counsel for the prosecutors is instructed to accompany one of the counsels for the respondent in the tech booth to make sure that it's the same USB being presented.
For the record, Your Honor, the witness is opening the prosecution's Exhibit P-4-10, Your Honor. This is the video dated November 23, 2024.
I have unsealed the flash drive, sir.
Counsel this with understanding, okay, very much like yesterday, that this USB will again be sealed and signed by both parties.
Yes, Your Honor. Your Honor, may request that this be played. Here, brother. Sorry.
Counsel for the prosecutors, kindly accompany a representative from the counsel of the respondent to the tech booth to make sure the same USB to be played. kindly just guide us through, Counsel, Attorney Narvaez, as regards to timestamps.
Thank you, Your Honor. I will.
Please don't forget your promise that it's not going to be the whole 2 hours.
Yes, Your Honor.
Waiting.
Senator Judge Pia Cayetano, what is your pleasure, ma'am?
Yes. If it's possible, Mr. President, if our Secretariat can install a monitor here because magkaka-stiff neck na po ako watching this. And it really doesn't look nice that I'm slouched there looking this way. So, and then this one here is a little bit, not for videos, but for the copies of affidavit, it's quite difficult. So if they can put one here,
Secretariat,
the others want another, but I can speak for those in the front row we would like to request. Thank you.
the clerk of court, rather, is instructed to kindly install a TV monitor in front of the tables of the counsel for the parties instead of at the witness stand. Both sides. Underneath the table of the counsel for the parties, Senator Judge Pia. Counsel, for the record and for reference, kindly identify the timestamp that you will be playing. I presume in chronological order.
Your Honor, for the record, we are showing the witness a part of the video marked as the prosecution's Exhibit P-4-10. First video, the timestamp around 0001:27 to 0002:20 of the November 23, 2023 press briefing as contained in the video that you identified yesterday, sir. Your Honor, may we ask that the video be played at those specific timestamps?
I did an apology. And then, ang sabi po nila, I just have to do an MR. And I did an MR, but they did not rule on it. And then suddenly they have an order transferring me. When ang nauna naman na order ng final ng lawyers namin was an MR to lift that order of contempt. Because they said that was the procedure. If they were not able to rule on that, how were they able to come up with an order, to transfer me to the Women's Correctional in the dead of the night? I mean, bakit ganun? Wala na bang rights yung mga tao? They just keep your room and then just get... Wala, bakit ganun? I don't understand.
Your Honor, may I ask that the video be stopped? Sir, do you know who that is in the screen in the video that you identified?
Attorney Zulaika, as far as I remember, sir.
And Attorney Zulaika, as far as you remember, Attorney Zulaika is who in relation to the Vice President? You may answer not a yes or no question.
As far as I remember, she is the COS.
COS meaning Chief of Staff,
Chief
right?
of Staff.
And she is there in that video because she was cited in contempt by the House of Representatives, correct? If you are aware, you're the investigator.
Prior to the...
Sir, my question again.
The witness
Let
is
the
about to
witness
answer.
Witness was in the process of answering.
Prior to the scene, I have no personal knowledge, but based on her statement during the video, I think it was mentioned.
So you didn't investigate the things that happened prior to the scene, correct? Sir, yes or no?
We have investigated, sir.
You didn't investigate.
Oh,
I did, sir. That's why there's an October 18, sir.
So what happened before that? If you investigated,
I
what
only
happened?
say I don't have personal knowledge, sir, because I'm not present during that time, sir.
Witness is not responsive. The question was, what happened prior to this video, this particular clip of the video, if you know, given that you investigated the incident, as you said?
As far as I remember, there is a hearing in the House of Representatives.
What committee, sir?
I can't remember the committee, sir.
What happened, sir?
COS was cited in contempt, sir.
By who, sir?
I can't remember the exact, sir.
But you investigated. I withdraw, Your Honor. Can we play, let me show you timestamps around 002832 to 002933. This is the same prosecution's exhibit P-4-10. That is the video you identified yesterday. Your Honor, may we request that that video be played?
Pero hindi ako lalabas. Hindi ako lalabas.
Please, pwede yung tanong. And, sorry, just Jason, if I can. Sorry. Go on. So after you push back attorney, they left the room, no? Tama ba? Did they appreciate that detail accurately?
Oh, because I think alam din naman nila na mali yung ginagawa nila. You don't fool people in the dead of the night. What is that? It's your, di ba, official business hour. Because hindi naman po ako criminal eh. I am not a criminal. I am already here in their facility. I have assured them already that I will attend their hearing on Monday. So why will they treat me like that? So that's why I said I want my lawyer. I want my lawyer.
Stop, please. Sir, did you consider this in making your evaluation in the revised affidavit of investigation dated February 10, 2025?
Yes, sir.
Thank you. Now let me show you timestamps around 003305 to 003432 of the November 23, 2023 press briefing as contained in the video that you identified yesterday, the prosecution's exhibit P-4-10. Your Honor, may we request that the video be played?
Sorry. I would not have pushed that bed by myself if I did not feel that I was being threatened. My life is being threatened. And I'm sure you saw in the hearing that my back hurts. I cannot lift everything. I cannot. But dahil natakot ako, I feared for my life. I really pushed that myself. Because it isn't for harassment. This is really a threat to my life. They gang up on you in the middle of the night. Huh? How is that bad? This is not a threat to my life. Alam nila that I'm sick. I have said that repeatedly when the doctor came here.
Stop. Thank you. Sir, did you investigate the threats to Attorney Zulaika's life?
We need a complaint for this one. That's why
Yes or no, sir? Did you investigate?
we did not, because there's no
You
there's
did
no
not.
complaint.
Okay, thank you.
The motto pro.
No question, sir.
If the witness may be allowed to answer, Your Honor?
I had no question.
Already answered.
Did you consider this part in making your evaluation in the revised affidavit?
Asked and answered. He said
This is
yes
a different
earlier.
part, Your Honor. This is a
This is a
different
different
part. Did you
Witness may
consider
answer.
this part in your evaluation in the revised affidavit of investigation dated February 10, 2025?
Yes, sir.
Okay, so despite considering these parts of the aforesaid videos, the NBI still recommended the filing of complaints for grave threats and inciting to sedition only against the Vice President. Yes?
May I qualify my answer, sir?
No, sir. Yes or no?
There's a reason why
Sir, your counsel may ask you questions. This is my turn.
Proper
Sir?
subject matter for redirect.
So, despite
Counsel,
considering these parts of the videos shown to you, the NBI still recommended the filing of complaints for grave threats and inciting to sedition against only the Vice President.
Yes, sir.
Now, in the revised affidavit of investigation dated February 10, 2025, in page 15, paragraph 40 thereof, it is stated there, and I quote, "We unanimously believe that Vice President Duterte may be held liable for grave threats defined and penalized under Article 282 of the Revised Penal Code and inciting to sedition defined and penalized under Article 142 of the Revised Penal Code in relation to RA 10175 or the Cybercrime Prevention Act of 2012. You see that, sir, right?
Yes, sir.
This conclusion was reached by you together with other affiants of the revised affidavit of investigation dated February 10, 2025, correct?
Yes, sir.
Now, sir, you mentioned that you're not a lawyer, right?
Ask and answered.
Asked and answered.
To date,
Go on,
we are
Counsel.
aware, are you aware if any court has convicted the Vice President for grave threats over what transpired on November 23, 2024?
As far as I know, not yet, sir.
Not yet.
As far as you
Your Honor,
know, Mr. Witness, as far as you know, no.
No, sir.
Proceed, Counsel.
To date, thank you, Your Honor. To date, are you aware if any court has convicted the Vice President for inciting to sedition over what transpired on November 23, 2024?
No, on my personal knowledge, sir.
Thank you. But you're the complainant, right?
Argumentative, Your Honor.
I was just asking.
Sustained. Move
Ask
on.
and answered. Argumentative. Then you withdraw your question. Improper.
Attached to the revised affidavit of investigation, which you identified and submitted to the DOJ and the Committee on Justice, is your affidavit of transcription of the press conference on November 23, 2024. I am showing you this now. For the record, sir, Your Honor, I will show the... Can you check? Sir, please take a look. Can you please say it in for the record? This is your affidavit of transcription.
Yes, sir. This is a photocopy of my affidavit of transcription, sir.
This refers to the press conference on November 23, 2024.
Yes, sir.
You signed this on December 20, 2024.
Yes, sir.
Sir, please take a look at your paragraph 2. Let's read it together. In relation to the ongoing investigation, the undersigned was tasked to transcribe the screen-recorded video of the press conference of Vice President Sara Duterte on 23 November 2024, which was saved on a DVD. You read that, sir?
Yes, sir.
On paragraph 3 thereof, let's read it together. The undersigned transcribed the video mentioned above which resulted in a CCD transcript hereto attached.
Yes, sir.
You read that, sir? And 4, I hereby certify that the above-mentioned digital evidence has been faithfully transcribed and that has not been edited, altered, or changed in any way. Did you read that, sir?
Yes, sir.
And I am, on number 5, paragraph 5, I am executing this affidavit to attest to the truth of the foregoing facts and circumstances and for whatever legal intent and purpose it may serve.
Yes,
Did
sir.
you read that, sir?
Yes, sir.
These statements of yours, this affidavit of yours, these were all done under oath, correct?
Yes, sir.
And you were offered as an expert in digital forensic examination with a whopping 2 weeks of training. Do you confirm that that transcription of the screen-recorded video of the press conference of VP Sara Duterte on the 23 November 2024 has been faithfully transcribed?
I don't remember that I was introduced as expert, but a competent witness.
Okay, sir. My question is, the press conference of VP Sara Duterte, the transcription of the screen-recorded video of the press conference of VP Sara Duterte on 23 November 2024 was faithfully transcribed by you?
Yes, sir.
Sir, attached to this affidavit is the transcript, correct? Can you please take a look?
Yes, sir.
And, Your Honor, may I ask again that the video, parts of the video be played of the press conference on November 23, 2024. Let's go through it together, sir. Where's the timestamps? First, let's go to around timestamp 00446. Your Honor, may I request that the video be played? Sir, please.
Steps after this order, are you going to file? Are you going to trigger the that file?
I am not leaving this room. I am here in the House of Representatives detention facility for 5 days until the hearing on Monday. Come in here and demand to transfer me in the middle of the night. I have my rights. Any crime. I am not leaving this room.
Stop. You heard that, sir? Do you want to repeat it?
I heard it, sir.
You heard it. Sir, in the first, you see also where that part is? Can you see it?
Start with the question with Red Mendoza, sir.
Okay, after the Zuleika Lopez. Did you hear that?
Yes, sir.
Okay.
Mr. Witness, kindly speak to the mic.
Yes, sir. Yes, Your Honor.
You heard, she said, I am not leaving this room. I am a detainee here in the House of Representatives detention facility for 5 days until the hearing on Monday. That is the first sentence, sir. My question is this. Does your transcript have the words a detainee?
Can you repeat the video, sir?
Okay, let's do it. Please repeat. Please play for the video again, please.
Instructed to kindly play the video timestamp identified by counsel for respondent.
Are you going to trigger the that file?
I am not leaving this room. I am here in the House of Representatives detention facility for 5 days.
That part that the detainee is inaudible, the only I heard. That's
You
why.
heard the, correct?
Yes.
Are the words or the sounds there? Here.
Yes.
Here. Okay. Please play. How about the last part of the paragraph? She said, I have my rights. I am not accused of any crime. I am not leaving this room. Does your paragraph in your transcript have the word accused after not?
Can you play the video, sir?
Please play the video again.
Speak to the microphone.
Thank you, sir. Instructed to play the video. Witness is instructed to speak to the mic.
Demand to transfer me in the middle of the night. I have my rights. I am not accused of any crime. I am not leaving this room.
More. Play, please.
Okay po, ganyan po ma'am. Thank you po ma'am.
Wait. Back.
Any other question?
0446.
I'm sorry ma'am kasi I understand ma'am. Ma'am, this is my last question and I'm very much sorry po. I'm triggered po ba ng that file?
I am not leaving this room. I am here in the House of Representatives detention facility for 5 days until the hearing on Monday. Nobody can just come in here and demand to transfer me in the middle of the night. I have my rights. I of any crime. I am not leaving this room.
Stop. Is the word accused in your transcript?
What I heard is root, sir,
The root.
of any crime.
The root of any crime.
Yes, sir.
Let's play 001238. Can you please go to 001238?
Correctional.
Sinabi nila sa iyo, dapat pakakalimutan yung contempt. Diba? Sinabi nila sa iyo, isip namin yung contempt kung i-propose mo yung apat.
Sabi nila sa akin, if you notice if you're in the hearing, sinuspend po ng chairman Chua yung...
Wait, stop, please.
Your Honor, please. Now, I am now registering my objection as to the relevance, Your Honor, please. If I may explain, Your Honor, of this line of questioning, Your Honor, please, if I may.
Counsel may explain his objection.
Your Honor, please. This witness already identified the video containing the contents of that press conference on November 23, 2024. And the counsel is now confronting this witness whether there are minuscule portions of the 2-hour video, like detainee, accused, whether this appear in the transcription. Now the question, the basis for the objection is irrelevant. How can it be relevant? How can it be relevant, assuming but not conceding that these two minuscule words, detainee and accused, are not reflected in the transcript, when in fact this witness said he investigated not only on the basis of the transcript, but on the basis of the video that he himself viewed? What's the relevance?
Overruled, part of cross to test the accuracy and the truthfulness of the witness insofar as his transcription of the video is concerned.
Thank you.
Counsel may proceed.
Thank you. Please play again 001238.
Sinabi nila sa iyo, dapat pakakalimutan yung contempt. Diba? Sinabi nila sa iyo, isip namin yung contempt kung i-propose mo yung apat.
Sabi nila sa akin, if you notice if you're in the hearing, di ba? Sinuspend po ng chairman Chua yung session. Tapos, sinayin po ako ni Congressman Castro in contempt. But after that, nag-rule sila. Tapos, then sinuspend niya. Tapos, lumapit po sila. Nag-hadol sila. And then, they called my lawyer. And then, tuloy po kausapin ko. So, lumapit ako. And I really apologize. I said, you know, that letter to the Commission on Audit was really a position of the agency. It is our stand. Like all, di ba? Like, meron kang points na gusto mo i-raise. We respectfully parang raised our points to the Commission on Audit. Alam ko, hindi naman po yung mali kasi that was our right as an agency. Because there was an ongoing audit investigation. Pero hindi naman namin kinukuha.
Narinig mo ba? Narinig mo? Did you hear the Vice President speaking?
I don't hear.
Can you please play again?
Mr. Calilong, you're reminded, please answer
I don't hear,
through
sir.
the microphone.
Can you please play it again?
MR, we let you go. So we filed our MR, they did not rule on it, but suddenly they were able to come out with an order ruling to transfer me to the Women's Correctional.
Sinabi nila sa iyo, dapat pakakalimutan yung contempt. Diba? Sinabi nila.
There. Did you hear that?
There are sounds, but I can't distinguish the words.
Can you play it again?
Your Honor, ask and answered. What's the point?
Okay, withdrawn, Your Honor. No further questions.
No further question
are
for
we
this
done?
witness. On cross, counsel, do you have redirect?
Of course, Your Honor, please, for the utter failure
I
of
was hoping you won't. But yes.
for the
please
utter
continue.
failure of the respondent to
Counsel,
debate.
before I recognize counsel for the prosecutor,
Your Honor,
Senator Judge Tulfo Rafi is recognized.
Your Honor, sorry, may I move to strike that statement of the
prosecutor.
How can it be, Your Honor? That's my manifestation. I'm about to answer the question of the presiding officer.
We will review the journal tomorrow. I did not even hear anything
Yes.
that is strikeable, counsel, but we will review the journal tomorrow.
Your Honor, he said for the utter failure of the respondent.
Yes, Your Honor,
We take
I said
exception
for
to
the
that.
utter failure of the respondent to debunk the material points testified to by the witness yesterday.
Your Honor,
I'm
he
not
is
yet
testifying.
done.
I'm not done either. He is
I'm about to
still
answer the
testifying.
question. I'm not yet done with the answer.
Counsels, please. The presiding officer has not recognized either of you.
Thank you.
Thank you.
Kindly settle down. Senator Judge Rafi Tulfo is recognized.
Thank you, Mr. Presiding
Sir, you may
Officer.
proceed.
Clarification naman po ito, Mr. Presiding Officer. Mr. Witness, what is your experience with regards to social media analytics?
I have training, sir.
What kind of training?
I have cybercrime investigation training, sir.
Okay. Are you familiar with Facebook, or do you have SOCMED accounts that would make you a little bit knowledgeable when it comes to SOCMED?
Yes, sir.
What is your account? What is your social media account? If
I have
any?
an account in Facebook, in Instagram,
Okay.
in X.
X. So that means pretty much you're a little bit familiar with Facebook, right?
Yes, Your Honor.
Okay. There were concerns, Mr. Witness, whether the videos presented yesterday are AI generated or authentic. So are you experienced enough analyzing whether a video is AI generated or authentic?
Yes, Your Honor.
What makes you say that?
Based on my experience, Your Honor, and the video itself, it's a 2 hours long. Normally, an AI-generated video will only last a short second, sir.
So the video that was presented yesterday, where we saw the VP was saying something or talking to that effect, did you do something, or what kind of system did you observe or follow to ensure whether that video was AI generated or authentic?
Based on personal observation, sir.
Personal observation.
Yes, Your Honor.
Okay, a few more questions. Therefore, will you be able to say that the video presented yesterday were AI generated or authentic?
The video presented today is what it is being seen on the Facebook, sir.
Okay. So, based on your affidavit, you mentioned that the NBI subpoenaed some members of the media who are participants of the online press con on November 23, 2024, right?
Yes, Your Honor.
And subsequently, you said that you questioned and investigated these persons regarding the conduct of that press con. So, based on what you gathered from your investigation, so I have a few questions, right?
Yes, Your Honor.
Who set up the press conference?
Based on our interview, sir, it is the Office of the Vice President, sir.
So it wasn't spur of the moment? Press con?
I can't confirm, sir, but it's the response of the media personnel that we interviewed.
Okay, who invited the participants?
If my memory serves me right, it's JC Kahinhinan, sir.
Okay. Who is JC?
Staff of the Office of the Vice President, sir.
Okay. Who are the participants? And how many participants were there, if you can remember?
As far as I remember, it's at least 40.
40. Okay. Were there mainstream media or anybody from the broadsheets at that time?
There are, sir.
There were?
Yes, sir.
Do you know how many? Approximately, give or take?
We have the one that we have issued subpoena, sir. At least 6, sir.
6. Okay. What was the reach of the video on that very day? Like how many views on that very day, and then a few days later? Were you able to observe that?
I can't remember, sir.
You can't remember. Okay. How did it spread? O paano kumalat sa SOCMED yung videos that was presented yesterday, as far as you know, when you did an investigation?
It became trending, sir.
It became trending. And my last question is, kasi in-establish dito is inciting to sedition on top of yung sa sinasabing grave threat. Ano yung mga comments na napansin mo doon sa video? Can you give us an example?
One of the comments, because on the video, November 23, there were mentioned about people power when asked a question by Princess Maui. And the Vice President agreed, and ang laban ay wala sa EDSA, nasa Malacanang, and there are responses from the comments, but it's not documented. That is agreeing, sir.
No further question, Mr. Presiding Officer.
Thank you, Senator Judge Tulfo. Senator Judge Aquino, thereafter Senator Judge Pangilinan. Senator Judge Aquino has 2 minutes. You may proceed, sir.
Maraming salamat, Mr. Presiding Officer. Mr. Kalilong, kanina may nabanggit na 2 affidavit, isang January at isang February. Yung January ay binalik sa inyo, tama po ba?
Yes, Your Honor.
And there were 7 grounds why it was returned to you, is that correct?
7 points.
Can you narrate what are these 7 points that you addressed? Is that the correct term, that you addressed in the second affidavit?
Yes, Your Honor.
Can you name them, please?
May I have the certificate, sir?
The certification, was it counsel for the respondent?
Your Honor, may I
Yes, you may approach
Thank
and
you,
show
Your
him the document being alluded to by Senator Judge Aquino.
Note 1. There is no affidavit of the person who recorded the video entitled BP November 23 Press Con at Batasan through open broadcast Super Studio and in turn stored in the DVD. Number 2. The press briefing conducted on October 18, 2024 was not recorded and or stored in DVD, and there was no TSN of the said briefing and the necessary affidavit of the person taking the TSN. Number 3, Annex I and K DVD with markings NBI-CCN-C-24-12436-2 and NBI-CCN-C-24-12436-2 were not accompanied by an affidavit of the recorder and the TSN. Number 4, Annex L did not indicate who made the TSN. There was also no affidavit of the person who made the TSN. Number 5, the affidavit of Juan Patricia Morales mentioned that she stored the footage in a USB and submitted to the NBI. However, there was no USB attached to the complaint. Only DVD was attached. There was no detail regarding the content of this DVD. Number 6, only the minutes of meeting with several personalities and representatives from various media outfits were submitted. Although the minutes were signed, there was no individual affidavit executed regarding to the contents of the said minutes. Number 7, one of the elements of crime of grave threat is that the offender threatens another with the infliction upon the latter's person, honor, and property, or upon that of the latter's family, or if the wrong amounting into a crime. In the instant complaint, only the NBI executed an affidavit and there was no participation on the part of the offended party, as it appears in the NBI is not the offended party of the crime of grave threat.
Okay, so nakuha mo yung nag-submit kayo, yan yung binalik sa inyo, and then you did your best to correct all those items, is that correct?
Yes, Your Honor.
Okay, the first 6 are technical, no?
Yes, Your
Yung
Honor.
panghuli is a matter of who is the offended party.
Yes, Your Honor.
Hindi nyo na-correct yan? Or nung binalik ninyo, it was accepted already by the DOJ? Is that correct?
There is an explanation, Your Honor, that was included in the letter of the former director, Judge Jaime Santiago, sir.
Okay.
Wherein,
go ahead.
in the filing for preliminary investigation, it is not required for the victim to execute an complaint affidavit.
Yan yung
sir.
sagot ng NBI?
Yes, Your Honor.
And once you submitted, it was accepted by the DOJ?
Yes, Your Honor, and we received a certification, Your Honor, that our evidence is enough for preliminary investigation, sir.
Okay, yun na yung second response to the second affidavit that you provided?
Yes, Your Honor.
Okay. May mga nabanggit dun sa mga statements tungkol sa hitman. No? Sa totoo lang, yung presensya ng hitman, mabigat yon. So let me ask, are you the one who investigated just the video or did you also investigate the presence of the hitman that was being mentioned in the videos of the Vice President?
I was only tasked for the video, sir.
Okay, may I direct this to the prosecution? Will you be presenting other witnesses that will pertain to this alleged hitman?
As to the alleged hitman, Your Honor, please, yes.
Yes. So kayo, Mr. Kalilong, hindi kayo nag-imbestiga niyan. Wala kayong alam tungkol dun sa presensya ng hitman.
Yes, Your Honor.
Okay. Mr. President, I will refrain from my questions and wait for the witness pertaining to the hitman. Maraming salamat.
Noted and entered into records, Senator Judge Pangilinan, thereafter Senator Judge Ontiveros, and then Senator Judge Villanueva.
Thank you, thank you.
You have 2 minutes.
Thank you, Mr. Presiding Officer. The question is to the witness. Kanina tinanong sa iyo ng Defense Counsel or Counsel for the Respondents na kung ikaw ay abogado. Ang sagot mo hindi.
Yes, sir.
Ikaw ba degree holder?
Yes, Your Honor.
Ano ang degree?
Bachelor of Science in Accountancy, Bachelor of Science in Accounting Technology, and I'm a certified public accountant, sir.
So you're a certified public accountant.
Yes, Your Honor.
Kahapon, tinanong ko sa iyo yung training. No? Kasi nabanggit mo, nagkaroon ka ng mga training. Ang nabanggit mo kahapon, 2 weeks ng training.
Yes,
Pero on what matter?
Only on photo and video authentication, sir.
Okay. Meron pa bang ibang training na ikaw ay you went through bilang expert or competent witness sa usapin ng digital technology, cybersecurity, online training? Meron ba?
Yes, Your Honor.
Anong mga ito?
I mentioned that I have a training in Certified Computer Hacking Forensic Investigator. I have a training in Computer Forensic, Mobile Forensic, and Photo and Video Authentication training. I have also training in Cybercrime Investigation. We also undergone a 480 hours training on cybersecurity. And a training before we start the Bureau, we have undergone the NBI Academy, which teach us all the aspects in investigation, sir.
Okay, and siguro last question. Ang training na ito, puro local ba o meron ding training sa ibang bansa?
I have an international, sir, recently.
Ano yan?
It's a training in Strasbourg.
Okay.
The name of the training is...
Saang lugar na lang, Mr. Witness?
Strasbourg, Germany? France?
Strasbourg, France, sir.
Oh.
It's a 5 days training, sir.
And meron pang ibang international seminars na inattendan mo?
International, sir, but it is conducted locally, the Interpol, sir.
Interpol?
Yes, Your Honor.
Okay. I have no further questions.
Thank you, Senator Judge
Salamat.
Pangilinan. Senator Judge Ontiveros is recognized. You may proceed, ma'am, and you have 2 minutes.
Salamat po, Mr. Presiding Officer. Para sa Counsel for the Defense, Mr. Presiding Officer, just for clarity, ano pong relevance nung video na ipinakita ni Attorney Zuleika Lopez? Sinasabi po ba ng depensa na yung mga alleged threats o alleged incitements ni VP Duterte ay prompted nung detention ni Attorney Lopez?
Yes, Your Honor. There was a systematic oppression made by the House of Representatives dating back from their even before their mini trial, Your Honor. The committee headed by Representative Joel Chua began investigating the Vice President and her people, even when Attorney Zuleika Lopez was being interviewed by the House Committee of Quadcom Committee, Your Honor. Even if she was answering the questions faithfully and to the best of her ability, she was cited in contempt, detained. Her lawyer was not allowed. Her lawyer was not allowed to be with her when they were trying to detain her in the women's correctional facility, Your Honor.
So, Mr. Presiding Officer, Counsel for the Defense, position po ba ng depensa na pwedeng palampasin ng alleged grave threats kung may masasabing lehitimong dahilan para magbanta?
Your Honor, that is not the point.
No. Mr. Presiding Officer, I am making a point through my question and I am asking the good counsel for the defense dahil sinabi nila there was a systematic oppression that yes, yan po ang nag-prompt nung alleged grave threats and alleged incitements ng Vice President na prompt po ng detention ni Attorney Lopez na kanyang inilarawan sa ipinakitang video kanina. Kaya itinatanong ko kung yan ba ang posisyon ng depensa na pwedeng okay lang or pwedeng tanggapin ang grave threats kung may masasabing lehitimong dahilan para magbanta.
Yes, Your Honor.
Before Counsel
Yes, Mr. Presiding
responded answers, although he already answered in the affirmative.
No, Your Honor. I was just referring to before.
Would like to remind the senator judges to be cautious in making counsels for either party make conclusions of law and fact instead of presenting evidence through a witness they will present or through direct, cross, redirect, or recross. Because if he answers Senator Judge Ontiveros, that would effectively place on record a conclusion of fact and law, not drawn from a witness, which they can very well do so during their closing remarks. And when I allow him to speak by way of repartee to the peroration yesterday and discussion yesterday by counsel for the prosecution. But other than that, as agreed with some of the senator judges, we would try to limit the answers of the counsels for the parties. With your indulgence, Senator Judge Ontiveros, please.
I submit, Mr. Presiding Officer, may I just in closing make of record that I also appreciated and also submitted to the ruling of the presiding officer yesterday because I appreciated that it partook of the history of impeachment proceedings in this court. Pinag-aralan ko rin po ng maigi ang mga nakaraang mga impeachment trials at di hamak na pati noon naging liberal ang pagpapahintulot nila sa mga katanungan ng mga senator judges para lang mas maliwanagan ang iba't ibang punto. So I again thank the good presiding officer and again reiterate my submission to his ruling and thank the good counsel for the defense for his response.
We thank Senator Ontiveros for her indulgence and understanding. Senator Villanueva. And thereafter, Senate President Gatchalian. You may proceed, sir. You have 2 minutes.
Thank you, Mr. President, Mr. Presiding Officer. May I just point out something to the witness? Mr. President, Your Honors, the witness mentioned yesterday that reported statements of the Vice President were referred to the Presidential Security Command and evaluated in coordination with the National Security Council. Just to assist the court in evaluating the relevance and weight of the government security response in determining whether the respondent's conduct constitutes an impeachable offense. May we know from the witness could the witness explain yung threats po ba, how threats against the president are ordinarily assessed by the government? Kasi dito yung lumalabas yung pag-weigh natin whether or not meron bang bigat yung threat o ito'y ordinaryong threat na nangyayari sa pang-araw-araw nating buhay. Specifically, Mr. Witness, what factors are taken into account in evaluating a reported threat and in determining appropriate measures?
I can't answer on the part of the NSC or TNO because I'm not part of the institution.
In your ano po, in your capacity as an
In my
agent?
capacity,
Yes.
one of the consideration, if it's a active threat, if it's the one giving the threat is capable of doing so.
Meaning,
If someone
high-ranking official, and if you say an
high-ranking and
official,
have a capability or power over to implement those such threat, it is considered, sir.
example, a mayor, perhaps? Would you say a high-ranking official? A congressman? Or yung basihan po ng kanyang threat. Kunyari, ang threat ko, dadalhin kita doon sa buwan. Wala naman akong space shuttle. So, wala din pong bearing yon. Is that the correct assumption?
Not only, sir, but also how it was delivered, sir. Like what was mentioned in that I mentioned previously, it was mentioned that no joke, no joke. It's a serious.
So that is the...
one of the considerations,
That's
sir.
the consideration. Thank you very much. And lastly, Mr. Witness, you made mention na submit mo sa DOJ noong January 30. Is it the same affidavit that you submitted to the HOR?
The one that submitted to the HOR is the affidavit dated February, sir.
So that's the latest.
Yes, sir, the one that complied with the requirements of the DOJ, sir.
Thank you very much for that clarification. Thank you, Mr. President.
Thank you, Senator Villanueva. Before I recognize Senate President Gatchalian and thereafter Senator Erwin Tulfo, may I remind Attorney Narvasa that your 5 minutes, you will be given your 5 minutes after the questions of the Senator judges and before we recognize the counsel for the prosecutor for his redirect. Senate President Gatchalian is recognized.
Thank you,
You may
Honor.
proceed, sir. You have 2 minutes.
Thank you, Mr.
May I be
Presiding
clarified?
Officer. I believe that we would do it after recross. So
You
it's-
want, I heard cross.
Sorry,
After
Your
we
Honor.
cross.
Yes, Your Honor. Thank you, Your Honor.
Better for us.
Yes, Your Honor.
Thank you, Mr. Presiding Officer. I just have a few questions, clarificatory questions. Narinig ko ho kanina ginong testigo na nasabi niyo may 40 media personalities doon sa press con. Tama po ba?
Yes, Your Honor.
Pero ang inyong inimbitahan, 6 lang.
Yes, Your Honor.
Bakit 6 lang?
The 40, we see the number of participants, but the number of person who asked the Vice President during that time, it's limited. And we consider who we sure that is present during that time, Your Honor.
Meron bang kayong criteria kung paano pipiliin itong mga media personalities or kung sino lang ang nagtanong? Kasi kahit hindi ka naman magtatanong, nandoon ka naman, naririnig mo yung mga diskusyon, meron ba kayong mga criteria kung paano pumipili ng media personalities?
Yung sure po namin na present during that time, kasi kapag hindi po kasi kayo nagtanong, hindi po magpa-pop up yung mukha nyo tsaka yung pangalan nyo.
Okay. At itong mga 6 na sinupinan ninyo, ano yung kanyang common statement na ibinigay?
Kinonfirm po nila na present sila during the November 23, 2024 press conference, and yung utterance po ni Vice President narinig po nila.
Okay, I believe ilan dito sa mga personalities ay ipapatawag rin. So tatalon ako sa ibang topic. Nakita ko kanina itong tungkol sa max score interventures at nakita ko kanina pinakita yung Articles of Incorporation, mukha siyang supplier ng equipment. Ngayon, nasabi rin na doon ka nag-training for 2 weeks. Sino nagbayad ng training?
Sir, the training is included in the procurement of digital forensic tools. In the procurement document, ni-require po si MaxCore na mag-provide po ng training included in the equipment, sir.
Yung paggamit ng equipment?
Tsaka yung yung process po ng digital forensic as a whole.
Yung kanya lang sila ba ay, di ba, sa mga IT, let's say, Oracle, alam natin, kilala yan pagdating sa IT. Si MaxCore ba ay kilala pagdating sa digital forensic training? Kasi pag nakita ko kanina, talagang supplier sila, but are they a well-known or internationally renowned training organization?
It's not the mock score itself, but it's the trainer that they provide, sir, that is capable in training us, sir.
Itong trainer na ito, certified siya in this type of technology?
Yes, sir. The trainer has a lot of certifications in relation to digital forensics, sir.
Can you name a few certification na meron itong trainer na ito?
I can't remember,
Let's
sir.
say Oracle or let's say Microsoft, di ba? May mga ganyan
No,
yan.
sir. CompTIA, sir. CompTIA training. I believe he also have a certified ethical hacking certification and a lot more, sir. When it was presented to us, sir.
Alright. So itong mga trainers nito ay certified trainers na pwedeng mag-train sa iyo at magiging certified ka rin.
Yes, sir. Initial na akong certificate, sir.
Lastly, Mr. Presiding Officer, after training, nakakuha ka ba ng certification na katulad sa kanila?
No, sir. But that certification that I was trained by them, sir.
Pero ikaw mismo, are you certified to do forensic examinations for your purpose and responsibility?
I have a certification, sir. I am a certified computer hacking forensic investigator, sir.
Itong forensic analysis, meron kang for this purpose, itong pinag-uusapan natin.
The computer, the authentication, sir, part? Or as a whole, sir?
As a whole.
I have a certification in computer hacking, sir, specific. But I have trainings in relation to the...
Iba yung hacking eh. Yung pinag-uusapan natin, forensic examination ng video, forensic examination ng mga ganitong bagay. Meron kang certification doon?
I have certificate, sir.
All right. Thank you, Mr. Presiding Officer.
Senator Judge Erwin Tulfo, thereafter Senator Judge Marcos. You may proceed, sir. You have 2 minutes.
Maraming salamat, Mr. Chair, Mr. Presiding Officer. Ang katanungan ko po ay para sa ating testigo. Batid ko po na sa ilalim ng Republic Act 10867, sa ilalim po ng Section 4, ang kapangyarihan po ng inyong ahensya na mag-imbestiga kapag ng mga krimen, partikular na tulad ng mga banta sa buhay ng Pangulo, ikalawang Pangulo, Senate President, Speaker of the House at Chief Justice. Tama po yun.
Yes, Your Honor.
Kahit na lalo pat pag ito ay may kaugnayan sa national security. Tama po?
Yes, Your Honor.
Pero ang tanong ko po, ang pagsasampa po ba ng kaso, nasa mandato rin po ba ng NBI na magsampa ng kaso doon sa mga tao na nagbanta sa buhay ng Pangulo, ikalawang Pangulo, Senate President, Speaker of the House, Chief Justice? Is it automatic or kailangan mag-request sila sa inyo? Matic ba yung pagsasampa ng kaso doon sa nagbanta? In this case, is it automatic or wala lang, kasama sa mandato niyo to file charges dahil binantaan mo Pangulo o si Vice Presidente kung sino mang yang 4 na matataas na opisyal natin or 5 matataas na opisyal natin?
Ang basis namin doon, Your Honor, is yung primary objective namin to investigate cases to the threat to the President, Vice President, Senate President, Supreme Court. And if we found that the evidence is enough that there is a crime committed, we will file a case because that's the output of our investigation, sir.
Kahit po ba na hindi yung biktima, in this case, yung Pangulo, biktima ng threat, kahit na hindi siya nagreklamo, automatic po yun? Kahit na hindi siya nagreklamo sa inyo?
Yes, Your Honor.
Okay. Hindi nyo na siya kailangan tanungin pa na, Sir, gusto nyo po bang kasuhan namin ito? Wala nang gano'n. You will never ask. Sabihin natin, hindi lang Pangulo, Vice Presidente. Nangyari din sa Vice Presidente o sa Speaker of the House, sa Senate President o sa Chief Justice. Hindi nyo naman lang siya afford to ask him like, Sir, will you go to the process? Kasi magpa-file ka po ng mga affidavit. This is a long process, etc. Kahit na Pangulo ka po, may pipirmahan ka mga affidavit. Is it automatic, Mr. Witness?
We submitted it, sir, even without a complaint in the for preliminary investigation, sir.
No further questions, Mr. President.
Thank you, Judge Erwin Tulfo. Senator Judge Marcos is recognized. You may proceed, ma'am, and you have 2 minutes.
Yes, maraming salamat. Mahal na namumuna. Hihingi lang po ako ng dokumento para mas madali nating sundan ang mga pangyayari. Nalilito lahat pagkat wala po kaming papel. At ang nabigay sa amin, eto, Annex FFFGGG. Nalilito po kami kung alin dito yung mga papel. Kung maaari kaming bigyan, unang-una, yung unang tinutukoy, the first affidavit of investigation dated January 30, alleging grave threats inciting to sedition ng NBI. Ikalawa, yung napasok na yata sa record, pero nais rin namin bilang Senator Judge na magkaroon ng kopya ng DOJ certification signed by Prosecutor Bandung February 5 na nagbigay ng 7 grounds na insufficient for preliminary investigation. Ikatlo, yung naibigay na. Ito klaro to, naibigay po ni Mavic at ng iba pang staff natin, yung February 10, yung ikalawang amended na ibinigay na revised affidavit of authentication, February 11. Ngunit sabi ni Testigo Kalilong na merong kasama ito na wala rito sa record natin at sana maibigay si Senator Judge, ito yung sulat kasama nung second revised affidavit of authentication. Ito naman yung sinasabing sulat ni Santiago K. Fadulyon ng DOJ na nagsasaad na hindi kailangan na may private complainant yung sina Presidente, ang First Lady at saka yung dating Speaker dahil base sa kaso ng Santos Concho versus DOJ na 2008, hindi daw kailangan yung private complainant. May we also have a copy of the same. Finally, may we urge that a copy also be given of February 14 certification of DOJ asserting that the revised affidavit of investigation was finally sufficient. Nais lang namin na makita yon at alamin yung investigation data, huling-huli, nung March 7, almost a month after the submission of the affidavit of authentication, kasi halos 1 buwan bago utusan na magkaroon ng investigation data form. Sana may kopya rin tayo noon.
To respond to Senator Judge Marcos, what the court has copies of are the pre-marked documents that the parties pre-marked during pre-trial, but not documents that have not yet been pre-marked. Most of the documents you mentioned that was discussed by counsel for respondent has not yet been pre-marked. They only used it to confront via cross-examination the witness of the prosecution. But the ones we have, we will furnish you with a reminder, of course, Senator Judge Marcos, that these documents have not yet been formally offered by either party. And we still have to await formal offer before the court rules on the admissibility, if at all, of these documents. But we will endeavor to furnish the good Senator Judge with whatever the clerk has.
Yes,
Your Honor, if I may.
if we could be provided with whatever the clerk has and adequately identified, not as GGGGG or FFFFF, at sana kung mabuo yung mga dokumentong sinasabi sa lalong madaling panahon. Maraming salamat.
We will endeavor to comply as best we can, Senator Judge Marcos.
Same
Senator
issue.
Judge Alan Cayetano,
Peram yung
what is your pleasure, sir?
Mr. President and Mr. Presiding Officer, before I ask to be allowed to ask a question, can I just follow up yung kay Senator Marcos, including the ruling yesterday? Just in the interest of all Senator judges being able to follow closely, especially kami sa first row kasi medyo nagkaka-stiff neck na kami. Mahirap tignan yung TV, so baka dun sa
Maglalagay
harap.
na po kami ng TV
Yes.
sa harap ng
And
lamesa
I
ng
don't know,
Counsel for Parties.
I think all of us own a iPad or a tablet. I don't know what the solution is, but if the Secretariat or the Clerk of Court, the Office of the Clerk of Court can work with our staff, just to give you an example for today, no? If you look at the impeachment complaint on page 19, for example, it says that the affidavit we're looking for kanina, footnote number 72, is this one, in the impeachment complaint, no? It's found on Annex G. Okay, so this is Annex G. If you look at Annex G, it is a certification, not an affidavit. Okay, so where do you find the affidavit mentioned in the impeachment complaint? You actually find it in Volume 14, Annex FFFFFFF-GGGGGGGG. So before I can even
not
say
dash,
that...
That's FFFFFF to GGGGGG.
Yes. So even before we finish saying that, Your Honor, Mr. Presiding Judge, medyo mahirap. To further complicate, the annexes when delivered to us was labeled annexes, and then when it was pre-marked, iba na yung marking.
That is correct.
Okay. So to clarify, I'm not asking both the prosecution and defense to give us any documents in advance that will prejudice their presentation or the rebuttal. I do understand that it has to be offered, but to speed things up and to make sure we understand, in the same manner that they're asking the witness to examine it, maybe we can be given a copy to examine at the same time, whether digital or actual copy. I don't want to impose upon them to print 24 copies, but again, anyway, it's Wednesday. We have Thursday, Friday, Saturday, Sunday for our staff and the clerk of court to meet.
I think we already have a solution for you, Senator Judge Cayetano, as well as for Senator Judge Marcos. We will be furnishing the parties either via soft copy to your respective iPads or laptops, or we will enter their official emails as well. Kayo na po mag-print ng hard copy. Ng list of evidences as marked, as pre-marked by the prosecution na ipe-present for Article 4. And we will do this by article. Okay. However, insofar as I said, the documents presented by the counsel for respondent, these have not yet been pre-marked. But I don't think there's anything wrong with asking for a copy from the counsel for respondent.
On that point,
for our guidance, whether or not the same will be offered without prejudice to respond to counsel for respondent, deciding on whether or not they will offer it at the appropriate time.
On that point, Mr. Presiding Officer, even if it's pre-marked, if it will prejudice their presentation, I don't mind it be given in real time. And same, no? If it's being used on cross or recross on rebuttal and hindi to na pre-mark, as long as real time, para lang we can process it. If not, we have to review afterwards and it messes up our preparation for the hearing the next day. No?
Is that possible for the parties once the roles are reversed? May I get a response from the counsel for respondent?
Your Honor, first we'll clarify everything that was showed today was pre-marked by the respondent.
That's not my understanding because the DOJ letter you pre-marked is different from the DOJ letter that we have pre-marked. But we'll verify. So everything was pre-marked?
Yes, Your Honor.
But you presented a document that was not pre-marked either by the prosecution or the defense. Walang marking eh.
I presented all that.
So if it was pre-marked, it's our lookout, then kindly, then there's no problem furnishing the senator judges with a copy of the same.
We have no problem with that, Your Honor.
Senator Judge Alan Cayetano's concern has no basis if it was all pre-marked. Yes. Apparently, it was our oversight.
Yes.
Counsel for the prosecutors, would that be possible?
Yes.
To furnish it? I think what counsel for respondent did earlier helped us out a lot. Plastering it on the screens, whatever affidavit you were presenting. I think counsel for the prosecutor should do the same.
Yes,
Hindi naman
Mr.
bawal
Presiding
magkopyahan dito eh. Okay lang. Senator Judge Cayetano?
Thank you. Yeah, and just to clarify, the 2 minutes is the question, not including the answer. No? So
you have 2 minutes if you want to start with asking questions.
Yes, if they ask to repeat the question, please don't count that. No, 2 minutes is long with short questions, but many of us want to get to the bottom of it, end up only asking 1 or 2 questions. So just a little bit liberality.
We will be lenient,
yes. Thank you.
Senator Judge
Thank you
Alan
very much.
Cayetano. You
Appreciate
may proceed,
it.
sir. You have 2 minutes.
A question for the witness, and maybe to put all of us in check, I don't mind if any of the counsel says na medyo hindi maayos yung question. I mean, given what happened yesterday and today, and there are questions that could prejudice the case either way. As long as we call each other out respectfully, to the both counsels, you cannot correct a senator judge, but I don't mind if you think it prejudices. That's your duty to your client.
Yes, sure.
So this isn't the start of the 2 minutes yet. Sa magandang hapon, Mr. Witness.
Good afternoon, Your Honor.
Medyo mahaba na yung pag-upo mo dyan, but allow me a few questions. No? Yung circumstance lang, so paano nagsimula yung investigasyon na na-involve ka? Were you from the start o hindi? At written instructions ba to? O sinabi, oy, may investigasyon tayo? Just konting clarity, paano na-umpisa yung specific investigation? And was it based on the November 3 video? Tama ba?
November 23, Your Honor.
Okay.
It all started, I received a phone call, sir, from my executive officer that there is a video wherein there is a statement given by the Vice President, which is classified as threat, and I was tasked and assigned to investigate the case, sir.
Okay. So basically, ganun yung pagkasabi, na I'm tasking you to look at the video, investigate.
Yes, Your Honor.
Were you working alone or with a group?
With a group, Your Honor.
NBI group?
Yes, Your Honor.
And was this, is there an interagency also or just purely NBI?
Don't have personal knowledge. Maybe our chief, sir, has the
Okay.
knowledge on that, sir.
Yes. No, that's all I asked for naman, yung personal knowledge.
Yes, Your Honor.
So, pakiulit mo yung sinabing, how exactly sinabi sa'yo na, tignan mo yung video, imbestigahan mo, or may statement? So,
to be specific, sir, as far as I remember, may statement si Vice President regarding the November 23 press conference na kung saan may pagbabanta na naganap,
Okay.
pakiimbestigahan.
pakiimbestigahan. So, ganun ka-general.
Yes
May
po.
pagbabantang naganap, pakiimbestigahan.
Yes po.
And you proceeded by watching the video.
Yes, Your Honor.
And when you watched the video, you got to the part na may pagbabanta.
No, Your Honor. I first don't know which part of that.
So you watched the whole video, of course.
First, the clippings, Your Honor.
Okay.
Then, I look for the whole video, Your Honor.
Then you watched the whole video.
Yes, Your Honor.
And thank you for your honesty. So after the clipping, tapos the whole video, what did you do next? You reported or you made your recommendations? I don't understand the process lang kasi.
Upon identifying the whole video, I informed my executive officer that I identified the video, Your Honor.
And then yung sinabi mo yesterday, then you started looking for patterns. That's why you looked at yung dating mga video ni Vice President.
Yes, Your Honor.
So you started investigating the threat against the President, the First Lady, and the former Speaker of the House.
Yes, Your Honor.
Did you investigate the threat against the Vice President?
We tried, Your Honor.
How did you try?
It is included in our letter to the Vice President, Your Honor. That's why we're inviting her to proceed to our office to investigate the threats to her life, Your Honor.
How about the vlogger who asked her about Oplan or whatever they call that Romanov? Did you invite them?
Yes, Your Honor.
And did they testify?
The Princess Maui did not appear, Your Honor.
Did not appear. Did you also look for previous videos that are threatening to the Vice President?
We look on the Romanov part, Your Honor.
Okay.
But we identify a different person who first mentioned the Romanov, Your Honor.
Did you coordinate with the PSG?
I have no personal knowledge, Your Honor.
You yourself?
Yes, Your Honor. Maybe our chief, Your Honor.
Yeah. But you are aware that the primary responsibility of protecting both the President and the Vice President is the PSG?
Yes, Your Honor.
So isn't it fair to say that any investigation against a threat to the first family, the President or the Vice President, you would normally ask the PSG if they received any threat?
I have no personal knowledge, Your Honor.
No, I'm asking, hindi ba normal sa investigation kung sino yung primary agency na taga-protekta na lumalaban dun sa threat ay tatanungin natin?
Yes, Your Honor.
So bakit hindi tinanong ng NBI ang PSG? Or in your case, why didn't you ask the PSG?
Maybe it can be answered by a chief, Your Honor.
No, I'm not. I will ask your chief also. I'm asking you, when they said, look at this, you looked at other videos, you tried to get Princess Maui, you tried to get the Vice President, but you didn't contact the PSG for the First Lady, for the President, and for all you know, the PSG will tell you right there and there, the threat is real, or the PSG will say, politika lang yan. Diba? Both the Vice President and the President are protected by the PSG. So why wasn't, so nakalimutan lang or wala sa procedure nyo, or...
Your Honor, there is already a statement from the National Security Council, Your Honor, that it is an active threat, Your Honor. That's why we start investigation.
Yes, and the primary group that will know if it's an active threat is the PSG. So if this was the United States, it will be the Secret Service. So whether the FBI or the CIA, state troopers, the federal marshals, kung sino man mag-iimbestiga, parati nilang tatanungin yung Secret Service. So I'm just curious why we did not ask the PSG input.
Kindly wind up, Senator Cayetano. Senator
Okay.
Judge Cayetano.
So, my last question is, how did you characterize the threat of the Vice President to the President? Given that ang exact words niya, huwag kang mag-alala, ma'am, sa security ko kasi may kinausap na akong tao, sinabi ko sa kanya, kapag pinatay ako. So that I'll be fair to you and not vague, no? Did that phrase, kapag pinatay ako, have any bearing in your investigation?
Yes, Your Honor.
And what was that bearing or thoughts in your mind?
First of all po, dun sa statement, may nakausap na po. It already took place before pa yung mangyari yung meeting. And nung condition...
Me, I'm not talking about yung may kinausap na para pumatay. Ang sinasabi ko, yung sinabi niya na pag pinatay ako.
Yes, Your Honor.
How did that affect your investigation?
There is a condition na kapag pinatay siya.
Yeah.
But as we can see, it's only applicable if there is only two parties. The statement make a loophole wherein a third party can use that na kapag namatay si BP, ma-execute ngayon yung statement ni BP na may nakausap na siya without the participation of the one mentioned, the President, the First Lady, and the Speaker of the House, Your Honor.
That's fair. But what I'm saying is that in your reports, did you characterize it as a conditional threat? Kasi kung hindi naman siya pinatay, the logical implication is that there's no threat against the... So I'm not saying it's not illegal, immoral to contract a killer. I'm just trying to follow the logic na pag sinabi kong pakukulong kita, Mr. Witness, pag nagsinungaling ka under oath, then it's actually not a threat. It's a legal... I'm just telling you the law, di ba? Pero pag sinabi kong pag hindi ka sumunod sa akin, ano yung kita. So that's my last question lang. So how did you characterize that? It wasn't a conditional in your mind because may kinausap na?
Even with or without, sir, it's still considered a threat as long as the person...
I have no doubt there. I'm just asking, is it a conditional threat?
Based on our affidavit, sir, I believe it's conditional, which...
Based in your affidavit?
Affidavit.
But your initial assessment, yung personal mo as an investigator, this is an investigation of the whole NBI, but yung personal mo?
The threat is absolute, sir.
Okay. Thank you, Mr. President. Thank you.
Thank you, Senator Judge Cayetano. We now proceed. Senator Judge Padilla is recognized.
Maraming salamat po.
Thereafter, Senator Judge Zubiri.
Maraming salamat
Senator Judge
po.
Padilla, you have 2 minutes.
Opo. Nais ko lamang po magtanong sa ating saksi. Ginoong saksi, kanina po kasi habang nagkakaroon ng pagdinig, ako po'y laging iistorbo dahil tuwing may itatanong, mag-u-object, medyo magulo po eh. Pwede po bang sagutin po ninyo ako dahil noong pong February 5, ang sabi po dito ay insufficient po yung na hindi dapat makarating na sa preliminary investigation. Tama po ba? February 5 po yun?
May certification, sir. Yes po.
Opo. Tapos, nung February 14, naging sufficient na for conduct of preliminary investigation. Nasagot po ba yung 7 na sinabi dito na para, ang sinasabi po kasi dito, nung February 5, merong 7 na kulang.
I believe so, sir. That's why we have received a certification, sir.
Ayun. Kasi po, parang narinig ko kanina, hindi po naibigay yung original copy nung sinagawang interview kay Vice President Sara Duterte. Yung original po, na kopya, kung sino po yung nag-record. Wala po kayong affidavit? Meron po ba kayong affidavit na nakuha nyo?
Yes, sir. Ako po yung ang inire-request po ng DOJ dyan is affidavit po nung nag-screen record, which is my affidavit, Your Honor.
Meron po siyang affidavit?
Ako, sir. Ako po yung nag-execute, sir.
Hindi po yung mismong tao?
Yes po. Ang hinihingi po kasi ni DOJ is kung sino yung nag-screen record through OBS, sir.
Hindi po yung mismong tao?
Yes, Your Honor.
Kayo lang po yung nag-affidavit?
Yes, Your Honor.
Pero meron po kayong pagkakataon ba na nakausap niyo yung tao at nagbigay siya ng affidavit?
May I clarify, Your Honor, if sinong tao yung tinutukoy?
Yung nag-record po?
Ako po yung nag-record through OBS, sir.
Hindi po. Yung mismong nag-record po kay Inday sa Vice President. Nakausap niyo po ba? Yung raw file po. Kasi napakahalaga po nun. Kasi doon po natin malalaman kung original ba o hindi.
The video itself, sir, is publicly available. That's why I performed the recording, sir.
Opo. Pakisagot na lang po, mahal na saksi, kung nakuha niyo po ba yung original. Yung original, hindi po yung galing sa internet.
The original, no, sir.
Yun lamang po. Maraming salamat po.
Thank you, Senator Judge Padilla. Senator Judge Zubiri, you are recognized, sir. You have 2 minutes.
Maraming salamat to our presiding officer. Magandang hapon po, Sir Witness.
Good afternoon, Your Honor.
Good afternoon. Gusto ko lang magtanong, clarificatory questions lang po ito. Dito ba sa ating bansa, dahil tinatanong ko po ito sa inyo, dahil kayo po investigating body, sa ating bansa, meron bang specific law pagdating sa mga banta sa Pangulo, Pangalawang Pangulo at kanyang mga successors? Or yan ba'y pasok lang sa grave threats, which is applied sa lahat? Applicable sa lahat ng tao?
Based on my personal knowledge, sir, it's only on the grave threat, Your Honor.
Which is applied to everyone, if I'm not mistaken. No? Kasi sa batas sa Amerika, sa Estados Unidos, meron po tinatawag na number 18 under the United States Code, Section 871. There is a specific law na pinagbabawal po itong mga threats to the President, Vice President, and its successors. May jail time po ito at may fine na malaki. As a matter of fact, dito sa panahon ni Pangulong Trump, marami na po silang kinasuhan at hinabla at napasok sa kulungan dahil sa paglabag nitong batas na ito. At Secret Service po ang sumasagawa ng investigasyon. Sa atin ba dito, ang NBI ba ang nabigyan po ng kapangyarihan para gawin itong investigasyon under your new NBI code?
Under our law, sir, the new NBI law, included po yung investigation to the threats to the life of the President, the Vice President, the Speaker, the Senate President, and the Supreme Court, sir.
So, klaro na kayo, nasa kapangyarihan ninyo. Kasi hindi pwede sa Presidential Security Group. Hindi katulad sa Estados Unidos, yung Secret Service ang talagang nanguhuli at nag-imbestiga. Sa atin dito sa Pilipinas, ang NBI po ang nangunguna sa investigasyon. Tama po ba yan o mali?
It is within our law, sir.
Okay. And this is just food for thought because not only are we senator judges, we're also legislators. It may be time that we also craft a law that will be specific on threats made to the President, Vice President, and its successors, meaning the Senate President, the Speaker of the House, and the Supreme Court Chief Justice. Sa Amerika kasi, sa batas po nila, and I'll just wrap up, the defendant to secure conviction, the defendant communicated a threat. The defendant understood and intended the statement as a true threat. Hindi po niya sinabi joke only in the end. And pangatlo, the defendant knowingly and willfully makes the threat. So just food for thought as legislators as well. So maraming salamat po, Mr. President.
Thank you, Senator Judge Zubiri. We now proceed to where we left off. I believe that was the redirect of the counsel for the prosecutor. Just out of curiosity, without any pressure, because I promised I would declare a break somewhere in between, depending on how long your direct and recross would be, I can call the break after the recross and the statement of the counsel for respondent, so that we break on a good point before we call on the last witness for today. Yes, counsel for the prosecutors.
As to the question, if the prosecution will do the direct examination.
The redirect. Kung mahaba-haba
Sorry,
pa
the
yung
redirect examination after the cross-examination of the defense. The prosecution decides not to conduct a redirect, Your Honor, please.
Thank you, counsel for the prosecutor. Counsel for the respondent, do you want to begin to utilize your time now?
Your Honor, I will turn over the mic to my co-counsel. He will also be the cross-examiner for the next witness.
But Your Honor, please, may I make a manifestation, Your Honor, please, before we proceed, Your Honor, please? A manifestation as to the statement.
In connection with what, counsel for the prosecutors?
As to the manifestation earlier that all the documents that were confronted, that were
Yes.
presented to the witness, I believe that the defense said that all those exhibits were pre-marked. But based on our records, Your Honor, please, and then I hope the defense will clarify this for the record, we perused the documents and we don't see that the articles of partnership and the screenshots of the websites that were presented earlier, based on our tally, based on our records, these were not pre-marked, contrary to what the defense manifested. So we would like to seek clarification from the defense.
That is correct, Your Honor. Those three documents were not
Noted
pre-marked.
and entered into the records.
Thank you so much.
Given that there is no redirect and recross, counsel, can you state for the record your name?
Good afternoon, Your Honors. I am Mark Sivin Luan for the Vice President.
Sir, you're aware of the situation. Time was given to the counsel for the prosecutors to make a discussion about whether or not Article 4, the acts alleged in Article 4 constitute an impeachable offense. You have the same time of 4 minutes and 26 minutes, which will round. Before I allow you to continue, kawawa naman si Mr. Calilong. Mr. Witness, Mr. Calilong, Senator Judge Lacson, before we excuse. Senator Judge Soto is recognized. Sir, what is your pleasure, sir?
Mr. President, Mr. Presiding Officer, are we going to dispense with the...
Unless you have questions to the witness. So not yet.
Well, it's a simple question.
The gentleman
You're
may
familiar.
proceed.
Thank you very much. You're familiar with the internet, of course.
Yes, Your Honor.
Have you noticed that lately all the AI-generated videos have a caption saying AI-generated?
Yes, Your Honor.
Kaya pag walang nakalagay na AI-generated, siguradong hindi AI-generated?
Yes, Your Honor. Today, Your Honor.
Yes, lately, no?
Lately, Your Honor.
Lahat nakalagay. Pag AI-generated, nakalagay AI-generated, and Meta does not allow it. Right?
They allowed it, but there is a AI info part.
Correct.
On the post.
There is a manifestation.
Yes, Your Honor.
AI
It is
generated.
explicitly mentioned that AI.
So you're aware of that?
Yes, Your Honor.
Thank you. That's it.
Senator Judge Lacson, you likewise have 2 minutes, sir. You may proceed.
Thank you, Mr. Presiding Officer, Mr. Senate President. I have questions para sa ating testigo. Since you are presented here as an expert witness, alam nyo, nagkusort din ako sa digital forensics expert para lang makonvince sa sarili ko. No, my first question is, in this day and age of artificial intelligence, no, will you agree with me na it is almost impossible to distinguish an AI-generated video from the original? Almost impossible.
Yes, Your Honor, it is hard, Your Honor.
Yeah, very hard, di ba? Very difficult. So, kasi ito, impeachment trial, ano? Kasi sa court, ginagamit talaga yung expert testimony ng digital or computer forensics expert. Now, you may or may not answer this question kung classified, ano? Gusto ko lang malaman, ano ba yung digital forensic tools na ginagamit din sa NBI?
Currently, I'm not familiar. But during the time na nandun po ako sa Digital Forensic Laboratory Division, meron kaming NCase Forensic, Celebrite, and AMPED Authenticate, sir. AMPED Authenticate, sir.
Ang balita ko, yung AMP5 or AMP Authenticate, di ba?
AMPED Authenticate, sir.
Ito yung ginagamit ninyo. Ito, capable ito na magsagawa ng reverse image, photo or video, di ba?
Yes, Your Honor.
Okay. Ito ba yung ginamit mo?
For this part, Your Honor, the OBS only, Your Honor.
Bakit hindi nyo ginamit ito?
The duration is too large, Your Honor, the 2 hours. And the AMPED Authenticate can only detect if there is a inconsistent FPS, Your Honor.
Yeah, kaya ko tinanong yon dahil una-una maraming para mag-adhere na magamit sa korte, no? Likewise sa impeachment court. May mga requirements, di ba? Sinabi mo kasi meron kayong open source, di ba?
Yes,
pero
Your Honor.
ang pinaka-importante yung chain of custody, of course, yung provenance.
Yes, Your Honor.
Yung original na pinanggalingan.
Yes, Your Honor.
Ang sabi mo, pinanggalingan lang Facebook.
The Facebook was captured, Your Honor.
So, hindi yun ang original, di ba?
The screen recording is the original itself as to my authentication, sir.
Yeah, and you can attest sa authenticity ng video.
Yes, Your Honor.
In spite of not being or not having originated from the original.
Yes, Your Honor. I compared the recorded with the original and ensured that the contents are identical, Your Honor.
Kasi nabanggit mo rin, ginamit mo yung manual comparison simultaneously ng dalawang videos.
Yes, Your Honor.
Pero again, I will insist na talagang hindi reliable yung manual. Ito yung sinabi sa akin ng digital forensics expert na nakausap ko. No? Ang mas importante, makuha mo yung original copy, yun nga, yung provenance, di ba? Para talagang, tapos masundan mo yung, sa analysis, gagamitan mo ng tools para malaman mo na talagang authentic yung video. Of course, I'm not here to question the authenticity. I just want to be assured. Dahil, sabi ko nga kanina, pagka sa artificial intelligence, napakahirap talaga. Almost impossible to distinguish it from the original video or yung source.
Yes, Your Honor.
And you are competent enough to ginagamit yung forensic tools o forensics tools at yung inyong yung competence mo through your training. You know?
And experience, Your Honor.
And experience. Kasi sabi mo nga, you've been with the NBI since 2021, di ba?
Yes, Your Honor.
And since then, you have appeared in some 20.
At least 30, Your Honor.
30.
Yes, Your
30 court hearings.
Yes, Your Honor.
So, thank you, Your Honor. Thank you, Mr. Presiding Officer.
Thank you, Your Honor.
Thank you, Senator Judge Lacson. Senator Judge Cayetano, what is your pleasure?
Just a clarification addressed to the presiding officer.
You may proceed, sir.
Apologies, I don't remember if it was one of the counsels or one of the senator judges who asked the witness a while ago whether he was an expert witness, and he said he was a competent witness.
That is correct.
And there's a difference
the presiding
between an
officer
expert
confirms that.
witness. So he's not an expert witness. He's an competent witness.
That is correct, sir.
So that will have bearing because whether or not an AI video can be produced without an AI has to be testified by an expert witness.
If I may.
Wait, yeah, go ahead. That doesn't mean, I don't think you'll disagree with my second statement. That doesn't mean that this witness is not competent to testify on that. Second point, I'd just like to clarify for the record, my understanding of watching the video is that it was on StreamYard, then a link was shared sa Facebook.
Yes, Your Honor.
So if that's the case, Mr. Presiding Officer, the original video is with StreamYard, not with Facebook, or are both original?
It's Zoom, Your Honor.
Zoom?
Yes, Your Honor.
I was informed StreamYard, but just for the record, so that later on when we review everything, someone testified to it.
Duly noted.
Yeah, thank you.
Duly noted and entered into records. Mr. Vinluan, you have your 4 minutes and 26 seconds, but we cannot use the seconds in our timer, so just look at the clock, sir, please.
Your Honor, please.
Before we... Yes, Mr. Kalilong, you are excused, sir.
Thank you, Your Honor.
And thank you for your time and cooperation with this impeachment court.
Thank you so
Thank you,
much,
Your Honor.
NBI Senior Agent John Mark Calilong. Thank you so much.
Hold on, Mr. Kalilong. Yes, Senator Judge Padilla, what is your pleasure, sir?
Ginoong tagapamahala ng hukumang ito, nais ko lamang po sana hingin ang mga credentials ng ating saksi, kung paano po lahat ng kanyang certification, lahat, upang mapatunayan po natin lahat na...
To it earlier, but kindly respond to the question of Senator Judge Padilla, Mr. Witness.
I have here, sir, my certifications during the time of my investigation, Your Honor.
Can you, mahaba ba?
I can read, Your Honor.
Mahaba ba, hindi?
Ibigay na lang po siguro sa atin.
Kindly just submit it to us, yes, please?
Opo,
Yes,
submit
Your
na lang po.
Thank you, Your Honor.
If that is okay with Senator Judge Padilla. Thank you, sir. Mr. Kalilong, you are excused, sir, and thank you for your time and cooperation with the impeachment court.
Thank you, Your Honor.
The presiding officer will just wait for the witness to leave the premises before recognizing Attorney Binon. Okay, Attorney Binon, you have 4 minutes and 26 seconds. You may proceed, sir. Thereafter, we will call for a 15-minute break.
In the discourse yesterday, talking about VP Sara's statements during the November 23, 2024 press con, Senator Judge Risa Ontiveros stated, and I quote, "None of these statements are proof that the Vice President actually contracted an assassin or hired one. She is absolutely right." She then asked the question, why are these acts impeachable? To this question, the prosecution responded, "We understand that these statements may not actually 100% prove that she in fact contracted an assassin, end of quote. Hence, the prosecution admitted that the video does not prove any fact other than its existence. In simple words, there is no proof of any contracting of an assassin. The prosecution's admission before this honorable court made the respondent's position clear. The prosecution has no other competent evidence to prove that VP Sara contracted an assassin. Ang testimonya ni Kalilong, gaya ng iba pang ebidensya kuno ng prosecution, ay hindi sapat para patunayan ang paratang na ito. Trying to prove this stretched narrative using a hodgepodge of materials is a waste of this honorable court's time and the Filipino people's money. Si VP Sara na mismo ang nagsabi na hindi assassin ang kinausap niya. This term only came from people who took her statements out of their proper context and tried to exaggerate them for what they really meant. The truth of the matter is this: she and her family were threatened, and while her response was unconventional, it was justified. What triggered her response was a question about Operation Romanov, which is the plot to eliminate VP Sara and her entire family. The NBI's own records prove this. In the minutes of the meeting of Dempsey Reyes' interview, he said, and I quote, "May press con kasi earlier than that," sabi niya, parang hindi lang niya sabi lang niya, gusto daw siyang patayin daw, according to her, ni Speaker. That was during a press conference the day before, November 2022. End of quote. During the virtual press con, Princess Maui mentioned Operation Romanov again, and even warned her about her safety. Reyes talked about it, Princess Maui reiterated it, but the NBI gaslighted it. When VP Sara uttered those words, she was not responding as Sara Duterte, the Vice President, but Sara Duterte, the wife, mother, daughter, and sister, who only sought to protect her own and her family members' lives. Operation Romanov is in place, and the threat against their lives is real. VP Sara became the target of unauthorized intelligence and surveillance operations by government operatives that exposed her family to high-level risks and security threats, thereby causing intense trauma and uncontrollable fear. Her homes in Davao and Manila were profiled, and this is proven by classified casing reports. Her trusted security personnel were removed. Her schedule of official functions, like the one in Naga, was leaked by intelligence agents, and her security was heavily compromised. In sum, the prosecution was right in using the term culmination. But the prosecution's interpretation is wrong. Rather, when VP Sara left the administration, she suffered various forms of threats and harassment for many months from the powers that be, and the culmination was her statement on that fateful early morning in November 2024. She didn't commit an impeachable offense. She drew the line in the sand and said, enough is enough. That is the meaning, and that is the context. Finally, as to the alleged grave threats and inciting to sedition, these are defined by their vice penal code and are punishable by prisión correccional. Thus, these fall under the jurisdiction of the MTC or first-level courts. These charges are not other high crimes as contemplated by the Constitution as grounds for impeachment and are therefore not impeachable. After all, VP Sara was fighting two important battles that day. One against the threat to her family's life, and another against the life of the ordinary Filipino, constantly suffocated by the immense weight of corruption, which she talked about during the press con. She never incited sedition. She merely echoed the voice of ordinary Filipinos. Her message that day only reflected what was already in their hearts and minds. There was no betrayal of public trust. She actually upheld the people's trust as she spoke for and behalf of the people. Thank you, Your Honor.
Thank you, Attorney Vidluan. Chair declares a 50... Senator Judge Bam Aquino, before we declare a recess.
Yes, just a quick manifestation, Mr. President.
You may proceed, sir.
Tapos na po tayo sa unang witness. It's taken us maybe a total of 9 hours for the first witness. Ito ho, isang pakiusap sa parehong grupo. Alam ko po may kanya-kanya tayong estilo, may kanya-kanya tayong strategy, but if possible, can we allow the testimonies to be heard? Can we have proceedings that will go straight to the point? Kasi po nanonood ang taong bayan, pati po kaming mga senator judge. Gusto rin ho naming makita itong mga proceedings, yung mga ebidensya na mas madali ring maintindihan. So ito naman po, di ho namin pwede itong idikta sa inyo. But if possible, the succeeding witnesses, and we have a long list, this goes for both parties by the way, let's have proceedings where we can go straight to the point, malaman natin yung puntos ng bawat grupo para makapagdesisyon rin po tayo ng maayos. Ito po this is a plea, no? This is not an order to both parties, but if we can, this is the People's Tribunal, we're watching, everybody's watching, sana po, payagan natin na lumabas yung mga katotohanan, lumabas yung mga ebidensya upang maging mas madali at mas kaaya-aya po yung ating proceedings. Yun lang po, Mr. President.
Thank you so much.
Noted and entered into the records. Chair would like to give Senator Bam, bibigyan ko ng konting pag-asa sa Senator Bam. Usually, ang mga paglilitis tulad nito, parang diesel yan. Sa simula, siyempre dahil una pa lamang, nagkakasanayan, nagkakaestimahan, pero bibilis at bibilis ito sa pagdaloy din ng ilang araw lang ng trial natin. And you will be able to see that the next couple of days. Chair declares a 15-minute recess. We all come back
Your Honor,
Yes,
please,
counsel for the prosecutor.
Before the declaration of recess, I suppose that the reason is for the presentation of the next witness for
Yes.
the prosecution. We manifest, Your Honor, that John Mark Calilong will be our witness for this afternoon. We'll be presenting the next witness during the next hearing on Monday, Your Honor, please.
You won't present Attorney Lotok anymore?
Yes,
today?
Your Honor, on Monday, Your Honor, please. We will utilize the 11 days allotted to Article 4 of for the prosecution, Your Honor, please.
So no Attorney Lotok today?
Today, we'll do that on Monday, Your Honor, please.
So,
Your Honor.
Chair would like to, I guess there's no need to declare a recess.
Yes, Your
Senator
Honor,
Judge
please.
Lacson,
Your
thank you for
Honor.
that manifestation. Yes, counsel for the respondent.
Your
What
Honor,
do you want
maybe
to say?
just clarified if Attorney Lotok is the witness on Monday because they had already
Yes.
disclosed the witness.
I was about to ask that question.
Yes, Your Honor. Attorney Jeremy
Your
Lotok will be presented
On
by the
Monday?
prosecution on Monday, Your Honor, please.
Likewise, can you name us, you manifested that you will also be presenting next week or requesting a subpoena to, yes, to Attorney Lopez and Attorney Director Matibag.
That would be Captain Belinda Bello, Your Honor, please, and NBI Director
Matibag.
And then
Lotok first.
Lotok, Your Honor, please, and then
Matibag.
And then we'll disclose on Bello, Your Honor, please. Captain
the Sergeant at Arms.
Belinda Bello of the House of Representatives, Your Honor, please.
So those two witnesses.
Yes, Your Honor.
We have 3 days, counsel.
No.
Name me one more.
Okay, that would be NBI Director Matibag, Your Honor, please.
Given the manifestation of the counsel for the prosecutor, Chair hereby orders the issuance of subpoena once again to Attorney Lotok for the trial dates on July 13, 14, and 15, as well as for Attorney Melvin Matibag. No need for a subpoena for Ms. Bella?
Your Honor.
Before I recognize counsel for respondent, no need for a subpoena?
There's no need for subpoena, Your Honor, please.
You did not request for a subpoena, counsel.
Yes, Your Honor.
So no need.
No need, Your Honor.
You will produce, can you state the name again for the record, counsel? Can you state for the name of the witness again for the record?
Your Honor, the first witness will be Captain Belinda Bello. That would be Attorney Jeremy C. Lotok. Number 2 is Captain Belinda Bello. And number 3, NBI Director Matibag. And number 4.
Thank you.
That's for no.
Thank you,
For next
counsel.
week, those are the witnesses, Your Honor, please.
Thank you. Counsel for respondent, what is your pleasure?
Your Honor, considering the change in schedule, may we just confirm if that is the exact order of presentation next week?
I believe so. The chair would like to be the one to confirm that. To reiterate,
Your Honor, may I be recognized? I apologize.
yes, the member of the panel of prosecutors, Representative Defensor, what is your pleasure, sir?
Your Honor, may I just correct, since the private counsel is under the direct supervision and control of the
Yes, of
Counsel of
course.
Prosecutors. For Monday, Your Honors, we will be presenting Attorney Jeremy Lotok. For Wednesday, we will be presenting, or Tuesday, we'll be presenting Attorney Zulaika Lopez. And for Wednesday, our third witness, we will be presenting Captain Belinda Bello.
Captain Belinda. So, Director Matibag is not yet going to be presented next week?
Not yet, Your Honor. We will manifest on Monday if we can consider him for the Wednesday's session, depending on how the trial goes or how long the testimonies will take for both parties.
Noted. What is the pleasure of counsel? Chair would like now to discuss and dispense with some administrative matters. The BIR box, which the chair ordered to be returned on July 6, has actually been returned to the BIR, sealed, untouched, and duly received accordingly. And the counsel for the prosecutors have filed a motion for the issuance of subpoena duces tecum at testificandum to the BIR concerning this box. Has a copy been furnished to the counsel for the respondents?
None yet, Your Honor.
None yet? I thought, yes,
Your Honor, we confirm that we emailed a copy to the respondents. Last
kindly
Monday, Your
check
Honor.
so that we can dispense with the need of reading the subpoena. Having said that, given that this has been put in issue rather in the pre-trial brief of both parties, there is counsel for respondent, we will accord the same treatment to this with respect to the subpoena, request for subpoena for the bank accounts of the spouses, Vice President Sara Duterte and Attorney Mans Carpio. Therefore, the presiding officer orders both parties to submit a memoranda on the subject matter of the subpoena of the BIR records on Monday, and we will also schedule the oral arguments for deciding on this issue together with the bank records on Wednesday. Each party will be given 10 minutes without prejudice to a rebuttal and or a rebuttal by the other side for another 3 minutes before the court shall decide.
We will comply, Your Honor.
We will comply, Your Honor.
Thank you. So ordered. In regard to the request for the issuance of a motion for subpoena, asan yung... May I ask if counsel for the respondents were likewise furnished with a copy of the most request for subpoena, although this is ex parte because this is only with respect to witnesses. So there is no need to issue a subpoena to Attorney Melvin Matibag for next week. Honorable Defensor? No need?
No need, Your Honor.
So just Attorney Zulaika Lopez?
Yes, Your Honor.
Chair orders that subpoena be issued to Attorney Zulaika Lopez to appear on July 13, 14, as indicated by the counsel for the prosecutors, given that on the 15th, we might be arguing on the bank deposits and the BIR documents.
We submit, Your Honor.
So ordered. There being no other matters for consideration by the court, and given that the counsel for the prosecutors have manifested that they will no longer present Attorney Latok today, but rather on Monday, the trial is hereby adjourned until 2 p.m. of Monday, July 13, 2026.
Dito pwede. Para hindi kita dito. Mic test.
Kahit last year, ayaw sa akin eh. Ang papangit ng photo ko eh. Okay na po? Okay na po? Good afternoon to everyone. Today was very fruitful for the impeachment court. As to administrative updates, the House panel of prosecutors subpoena request regarding the request for issuance of subpoena to Tecum on the tax documents of respondent Man Scarpio and 22 businesses connected or alleged to be connected to the Vice President. The presiding officer ordered the submission of memorandum on Monday and scheduling of the oral arguments on Wednesday for 10 minutes each side. And then for the renewed request for issuance of subpoena to Tecum for bank records as well, the presiding officer ordered the scheduling of the oral arguments on Monday for 10 minutes as well. The request for issuance of subpoena ad testificandum to Attorney Zuleika Lopez, the presiding officer granted the same and will be issued today. Senate President Sherwin Gatchalian called the session to order and convened as an impeachment court at 2 p.m. earlier with 20 senators present. For preliminary matters, as to the motion to strike out the remarks of Counsel for Prosecutor Attorney Ligutan that was tabled yesterday, the presiding officer equitably resolved it upon the withdrawal of Senator Judge Pia Cayetano of her motion. He, however, gave the same time privilege of 5-minute speech to the respondent's counsel, but reminded all the counsels to avoid concluding speeches and let the evidence be presented accordingly moving forward. For housekeeping matters, the presiding officer has said that there will be a 15-minute break midway every hearing. And the senator judges were asked to keep their voices low because the area where they are is an echo chamber with people in the gallery will be able to hear what they are talking about. As to the continuation of the presentation of prosecution's evidence in chief, the cross-examination of NBI agent John Mark Calilong started, and was conducted by the counsel for respondent, Attorney Narvasa. The presiding officer made several evidentiary rulings on motions and objections of both parties, and after the cross-examination was terminated, clarificatory questions were asked by several senator judges to the witnesses. Senator Judge Rafi Tulfo, Senator Judge Bam Aquino, Senator Judge Kiko Pangilinan, Senator Judge Risa Ontiveros, Senator Judge Joel Villanueva, Senator Judge and Senate President Sherwin Gatchalian, Senator Judge Erwin Tulfo, Senator Judge Amy Marcos, Senator Judge Alan Cayetano, Senator Judge Mig Zubiri, Senator Judge Tito Soto, and Senator Judge Ping Lacson all raised their clarificatory questions to the witness. And without the prosecution conducting any redirect examination and no more recross examination, the witness was excused. The trial was adjourned and will resume tomorrow. Typographical error on the briefer. On Wednesday, July 13, 2026. July 13, Monday, at 2 p.m. for the testimony of prosecution witness. First, Attorney Jeremy C. Lotok, and then the prosecution will also present Attorney Zuleika Lopez and Captain Belinda Bello for July 14 and July 15 respectively. Any questions?
Sir, yung 10 minutes oral arguments, does the impeachment court parang enough na ba yun para maihayag ng defense at ng prosecution yung kanilang stand dun sa issue ng pagsusupina ng bank records?
Yes, it should be enough because as I said earlier, the presiding officer also directed na magbigay po ng kanilang mga memoranda yung magkabilang panig ukol dito sa issue na ito, at yun po ay matatanggap ng ating impeachment court at senator judges sa Lunes, at bibigyan sila ng ilang araw para basahin yon, maintindihan yung legal arguments at posisyon ng bawat partido, at pagdating sa oral arguments, i-reiterate na lamang nila yung pinaka-importanting parte ng kanilang memorandum para sa ating publiko naman.
Gaano kahalaga yung oral arguments gayong meron na silang written memorandum na isusumite?
Yung oral arguments ay magpapakita nung kanilang mga posisyon regarding the issue, at ito ay mapapakita sa publiko dahil maihahayag ito through television tsaka televised video. So yung mga nakalagay sa memorandum na hindi mababasa ng ating mga kababayan ay mailalahad through that oral argument.
Last from me, sir. After the oral argument, do we expect the court to decide on the motion of the prosecution to subpoena those bank records?
Correct. Siyempre, kasama sa oral arguments na yan, yung mga senator judges will be also able to argue or ask questions regarding certain issues na nakalakip doon sa issue ng pag-i-issue ng mga subpoena, katulad ng secrecy of bank records, secrecy ng BIR records. So, maaaring mailahad doon kung paano nakuha yung possible na mga tax records, kung ito ba ay i-issue ng ating BIR commissioner with the consent of the President o wala ba. So yung mga ganong issue kasi yung mga parating nagka-crop up dahil ayon sa Section 270 ng tax code natin, mayroon lamang napakaliit na leeway kung kailan pinapayagan yung pagdi-disclose ng ganon. So doon mailalahad kung meron how they will go about it at kung paano hindi ito mag-violate ng mga batas na mga sinabi ko.
Attorney, pursue ko lang po yung question ni Dexter. Dahil doon sa oral argument, paano po iyon, para lang po ma-picture ng mga kababayan natin kung ano yung magiging scenario after ng oral argument, paano po iyon didesisyonan ng mga senador yung pagpapasabina sa bank and tax records ng Vice President?
Initially po, it will be decided on by the presiding officer, and then if the floor will appeal or the senator judges will appeal that decision, then it will be voted on by the senator judges. So only a failure to get the majority of the appeal will mean na the presiding officer's resolution will stand. Kapag po nanalo naman yung boto ng mayorya doon sa appeal na yon, then the order of the presiding officer will be overturned by the position of the one appealing.
Or pwede pong i-throw na rin sa body ng presiding officer
Pwede rin po,
instead of
isa rin
making
pong
a
option
ruling.
yan. Isa rin pong option.
And then, sir, pa-explain lang po kasi narinig natin kanina at kahapon din, yung mahabang direct and cross-examination dito kay John Mark Calilong dun sa mga technicalities as to the authentication ng mga documents. Bakit po ito kailangan gawin?
Kinakailangan po yun dahil ito po ay mga formalities of the law at nakasaad po kasi sa ating rules of court na supportorily applicable po kung paano po gagawin yon, paano gagampanan po yun ng isang abogado. Kaya yung pagtatanong po ay step by step, kailangan pong ilakad ng abogado nagrepresenta ng testigo yung korte at saka yung mga hukom kung paano nakuha at naging yung isang video na yon o isang dokumento na yon, paano niya nahawakan yon at paano nakarating doon sa korte. So yung buong chain of custody na yon, kailangan niyang patunayan na to be unbroken at wala siyang dinagdag o binawas doon sa prosesong yon. So yun, tama ka po. Tama ka po. So yung mga pagtatanong po kanina, kasama po yung pagtetest ng credibility ng both the testimony of the witness and the witness himself.
Sir, balikan ko lang yung ano.
Teka po.
Sir, naka 3 days na tayo ng trial. Nakakaisang testigo pa lang. Hindi ba apektado yung timeline na inilatag para mas, yung nga si Senator Bam kanina, di ba, nag-request na nga actually na baka pwedeng ma-hazen yung process, attorney?
Katulad nung sinabi ko po last time, yesterday rather, nung tinanong din ako ukol dyan, tinanong tayo na kung madadagdagan ba yung araw o mababawasan ba, depende po yan sa parties. Katulad po ngayon, nakita po natin na naka-schedule po talaga si NBI agent Lotok na ipresenta po today ng prosecution, pero base po doon sa motion ng prosecution o ng House Panel of Prosecutors ay hindi na po nila i-present this afternoon, and they are going to present the witness Lunes po. So because of that, hindi po inasahan natin na gano'n na mangyayari, na mapapaikli yung araw natin today. The impeachment court and the senator judges were ready to hear the testimony of the House prosecution witness. However, pinagbigyan na lang rin yung deferral na yon ng pagpepresenta. Siguro dahil na rin na nakita na rin na baka mahaba rin yung magiging testimonya niya, and kung kahapon yung magiging basehan natin ng pag-testify ng isang witness at tungkol sa authentication na step by step, baka abutin din ulit yun ng 2 to 3 hours. So yun yung mga kailangang balansehin ng korte sa kanyang pagdedesisyon kung i-grant niya o i-deny niya yung isang motion to defer the presentation of a witness to some other date or time. Kaya yun. So kung sa court calendar natin, parte ng kapangyarihan ng isang korte na i-manage yung kanyang schedule at saka yung process ng pagrepresenta. So hahanap naman ng korte. At syempre tatanungin niya rin yung parties in the next coming weeks kung sino ba yung mga witnesses na pwedeng pagsabayin na 2, 3 sa isang araw para makahabol tayo doon sa timeline na sinasabi. So that is within the prerogative of the court. Pero kanina sinabi rin ni presiding officer, itong first 2 to 3 days, we're just trying to get the hang of things in a manner of speaking. Kaya tinitingnan pa natin yung pace ng bawat party, ng bawat abogado, pati ng mga senator judges. And maybe next week and the coming weeks, mas madali na nating ma-figure out paano ililay down yung terms of engagement ng pagpapresenta ng mga testimonya. Meron pa ba?
Attorney, question lang po kung may idea lang sila. Sa 3 araw po so far ngayon ng impeachment trial, nakakamagkano na po kaya ang gastos on the logistics? Kung may idea lang.
Ako, wala sa pay grade ko magtanong ng pera. So, hindi ko masasagot po yan, but babalikan kita sa question na yan, no? Dahil tama ka, isa pong concern din yan, no, ng ating mga sambayanan. So, gusto rin natin malaman. So, siguro I will get the clearance from the Senate President to ask about the allocation of the budget regarding the impeachment trial so that I can give you a better answer next time.
And attorney, isa lang po, mabilis lang din. Napansin po kasi nung iba, especially online, na dalawa po yung nakaupo sa harap dun sa may rostrum. Sinasabi nung iba, baka raw secretary daw po ng presiding officer yung katabi ni Senchis. Pero ano pong explanation nila na dalawa silang nandoon sa taas?
I refer to my previous statement nung Lunes. Nasagot ko na rin po yan, no? Oo, baka maging ulit 'di ba? Baka mabuhay ulit yung mga issue. Pero wala namang issue dapat 'yan kasi it is a symbolic gesture na they are equals, just doing different hats, 'di ba? Wearing different hats. Yung isa ay legislative head at yung isa impeachment court head. So, walang kakaiba doon. Nakita na natin yan. This is not a new optics. This was already an old optics from the time of the impeachment case of the President Estrada na nakaupo yung head ng impeachment court na si Chief Justice Davide sa tabi ng head naman ng legislative function ng Senate, which is the Senate President Aquilino Pimentel. So in that aspect, this is not old optics. Siguro hindi lang nila malaman yung reference na yon dahil baka mga bata pa yung mga natin, yung mga viewers natin.
Sir, itong 3 days po, sabi niyo nga, may experience din po kayo, no? Would you say na nagsukatan lang o nagsukatan na itong dalawang panig po na tipong yung ganun po, tulad niya, nagbago po yung diskarte or masasabi natin na hindi na po na-present yung second NBI agent?
That is a fair conclusion on your part po. Tama po yun. That any person na reasonably pong mag-isip, may isip din yun. Ganun naman po yun para po tayong nangangapa pa po sa mga hindi natin kakilala, kaibigan, asawa, jowa, ganon. So, ganon din po yung nangyari in the first 2 to 3 days natin. Nangapalan ko anong klaseng style ba magtanong, anong klaseng gano'n yung kabilis yung pace nung magtanong, ano yung mga objections na usually nire-raise. So, nagkapaan pa po talaga, tama yun. Objective naman po yung ganong conclusion ng any person sa proceedings.
Po na dapat straight to the point daw po yung mga sinasabi ng parties and dapat ina-allow yung mga testimonies matapos po, or does the impeachment court agree na dapat nga po straight to the point?
Dapat straight to the point yung a matter of style kasi yun but I think the presiding officer is very lenient in giving all the parties their chance or their place under the sun. So, I think yun yung important kasi sa totoong korte, hindi medyo mahigpit talaga. No? Pero dito kasi kailangan natin balansehin yung karapatan din ng ating mga mamamayan na makita yung mga nangyayari at mailahad sa kanila yung mga ebidensya na inilalahad sa harap natin dyan sa plenary. So, kailangan kung magandang yung mga tanong din, medyo diretso, may foundation din, kaya okay naman yon, reasonably naman yung mga request na ganun mula sa senator judge at alam naman ng presiding officer that the the senator judges and even the parties themselves, yung mga abogado under their oaths, will govern themselves accordingly.
Sir, susugan ko lang yung tanong ni Kuya Raymond dun sa time. Hindi ba nasayang yung time ng impeachment court ngayon considering na cross-examination ang nangyari pero ready naman yung mga senator judges na dun sa next witness? At masasabi ba natin na failure or baka hindi ready ang prosecution kaya hindi tinuloy yung pagharap ni Lotto?
We cannot comment po doon sa intention of the prosecution for not anymore presenting NBI agent Lotok today. We have to take their manifestation and motion on its face, kung ano po yung narinig natin. Nasa discretion po nila kung paano nila iprepresenta yung ebidensya. Sila rin po bahala mag-manage nung mga witnesses nila, kailan nila iniisip na magandang ipresenta yung witness na yon. Baka meron silang timing, baka may strategy po sila. We cannot really comment on ano po yun, no? Hindi naman po nasayang yung oras ng korte kasi nga, sabi ko nga po sa inyo, nangangapa pa po tayong lahat. Tinitingnan rin ng korte kung ito ba ay reasonable o hindi reasonable yung pagka-defer. So, siguro ngayon, para medyo masanay muna tayo na mahaba-haba yung mga usapin sa floor, medyo pinayagan siguro muna tayo ng presiding officer na okay lang na wag na muna ngayon si NBI agent Lotok at next week na lang. Pero sabi ko nga kanina, I'm sure hahanap at hahanap naman ng paraan ang lahat ng partido ng chance na para mapabilis yan. Kung maaring yung mga witnesses na yan ay dalawa na sa susunod na mga araw at medyo sanay na tayo sa mahabang mga trial, baka yun yung gawin ng presiding officer.
Thank you, sir.
Ano po? Wala. Thank you po. Enjoy your weekend.
May hearing bukas, sir.
Court to do.
Viral lang ngayon online nung medyo natawa si Atty. Nervasa while asking yung witness natin. Can we know the reason why para lang may paliwanag po na?
Ano po yun? Hindi ko po kasi yung specific naalala niyo ba kung ano yung I won't comment na muna. I won't comment na muna on that one. Oo, dahil hindi ko maano kung ano yung specific. Pasensya na po.
Sir, bakit po tumagaling yung pag-cross-examine ni Atty. Nervasa doon sa affidavit na mula sa Department of Justice? Ano po ba yung gusto natin na ma-establish or mailabas doon?
Again, factual lang, no? We just wanted to show that there are two affidavits, no, of investigation, hindi lang isa. Yun na lang po, no? Ngayon, as to what that translates to, again, I really cannot argue our case in the media. We will leave it up to the impeachment court. Factual lang.
Kaugnay doon sa initial complaint po na inihain ng NBI sa Department of Justice?
Apa. Ang affidavit of investigation kasi, yun basically yung complaint, no, na inihain ng NBI.
Attorney, bago ba yung 2 hours video? Bakit hindi na ninyo ipinurso to play the 2 hours video?
Well, kanina, ang inisip namin, di naman na kailanganin muna para sa witness na ito yung 2-hour video. That's not to say that we will not be asking for the playback of the 2-hour video for some other witness. No? I'm not saying we will, I'm not saying we won't. Parati kong sinasabi, tinitingnan namin base sa takbo ng proceedings kung kailangan ba o hindi. And as I've told you, I think both the prosecution and the defense ayaw rin namin patagalin we play a 2-hour video that will take 2 hours 26 minutes of our time. And of course, judicial time also, no, the time of the court. So, hanggat naman hindi kinakailangan, sabi nga namin, hanggat pwedeng papabilisin namin. Pero kung sa tingin namin kinakailangan, we're still not discounting the fact that we might ask for that whole 2-hour video to be 2 hours 26 minutes video.
Allegations po, response niyo po doon ay yung official context or the big context in the video. Yun nga po, yung Zuleika, yung Auckland Romanov. Pero in brief threats po kasi, tinitingnan din sa elements yung prior or yung prior behavior doon. Tapos isa po sa mga possible witnesses ng prosecution ay yung sheriff po na sinuntok daw si Vice President Sara Duterte. How will you reconcile that fact or respond to
The way I'll respond to that is once the witness is called, the offer is made. If we feel the need to object, of course, we will object to the purpose for the presentation of the witness. Hindi naman, we will be ready to cross-examine that witness.
30 sa Monday, si Atty. Zuleika, no?
Tuesday po yata, bali sa...
Si Lotok sa Monday, and then si Captain Bello. Gaano kayo kahanda dun sa next week na leg natin?
Opo, handa naman po kami dahil expected na po yan. Lumabas na kasi sa pre-trial brief ng prosecution itong mga witnesses na ito. So tayo naman ay handa na as far as of course Agent Lotok, I think no, Agent Lotok and si Bello. Na rin sila sa committee on judging. So, yeah. This for prosecution kasi sila ang nagtawag kay Attorney Zuleika. So, we will just be there to see if we need to ask further questions. The prosecution is done with the direct. We'll see if there's a need for us to cross-examine. Yes, yesterday, nung lumabas yung motion, nakatanggap kami ng kopya ng motion for issuance of subpoena, which included the name of Attorney Zuleika Lopez or Yusek Lopez, we have informed the Vice President of the same. And ano naman siya, as I told you earlier, yung reaction naman niya, wala naman siyang ganong reaction doon. Because I think everyone expected it naman, including the Vice President. I think na-mention na po kanina. Again, I'm really sorry. I cannot talk about the merits. So baka pwedeng balikan na lang natin na na-mention naman kanina yan. No? But of course, one is context. Hindi ba? But I guess to sum it up, it was the transcription. The actual scenes. That's why I have to just state for the record that I'm just trying to be factual and recount what happened inside without saying that we were able to prove this or that.
Sa tingin niyo po ba, well, of course, kahapon pinipillory si Atty. Gina Basa. Ngayon parang ang dating ngayon ay parang pinupuri siya ngayon for his cross. After the cross-examination, ano ang pakiramdam mo si Atty. Gina Basa? Were you able to talk to him after the cross-examination?
Well, si Attorney Narvasa is a very level-headed person. So kung ano man ang mga batikos sa kanya kahapon, pagpuri ngayon, his disposition remains the same. I think sanay naman kaming mga abogado na you can never please everyone at any given time. Ako, I've been spokesperson for a few years and I have my group of bashers and group of friends. So we always support each other naman pagdating sa mga ganyan. But our disposition just be level-headed. Sabi nga natin, di ba, hindi tayo nagbibilang kung sinong panalo, sinong talo sa araw-araw because it will happen. There will be times that members of the public won't like what we do. There are times that members of the public would like it. So sa atin, we're just focus on our job and do the best we can to defend the Vice President.
Kanina parang narinig namin, 10 out of 10 daw yung score ng mga taga-prosecution sa team nila. Kayo, sir, ano score niyo?
Definitely, para sa akin, 10 out of 10 din. Score internally, meaning we're very happy that we hit. I really don't want to do that. As you can see, ang tanong sa amin kanina is bakit kami object ng object kahapon. And then ngayon nakita nyo rin, puro objection rin ng prosecution. And I'm saying, there's nothing wrong with that. There's nothing wrong with the prosecution objecting. There's nothing wrong with us objecting. It's just lawyers doing their jobs.
Sir, para explain lang maigi yung 10 out of 10.
Because we had targets and we were able to meet our targets. So I think we accomplished a lot today.
Okay na po.
Thank you. Thank you very much po. Thank you very much. We'll see you next week. Next week, Monday. Thank you. Thank you.
For public prosecutors and sa private prosecutors, patuloy yung kanilang pag-aaral, patuloy din yung kanilang preparasyon. In fact, wala na nga mga tulog itong ating mga prosecutors. Tino mo, kahit na walang tulog, magandang babae at magandang lalaki pa rin sila. No? That only means that they're confident that they're going to win this case. No? The best part here is that they came prepared and their preparation is paying off. No? Nakikita natin, ang tao ay namumulat sa katotohanan at namumulat dito sa ebidensyang ipinresenta.
Just to add lang po, no, not necessarily in that point, but just to answer the question. Of course, as Kong Zamora has already mentioned, it's really part of the process. We also saw it yesterday in the part of the defense, no? Na the lawyers, it is their job, it is their duty to their client to zealously protect and to defend their cause. So talagang lalabas po talaga yun. It's but normal in the process to have these objections, kahit na marami yan. It's because they have to safeguard really the cause of the interest and cause of their clients. But with that, it's also but normal that lalabas rin yung person natin ng lawyers. Just to answer the question po, no, if you were asking if talagang frustrated po sa pagkakakilala ko working with Attorney Virgil, hindi po. He's just very passionate. And if you review naman po yung nangyari sa trial, even when it was him who was objecting, very passionate naman po talaga siya. So I wouldn't think po na frustrated talaga. But yeah, that's just the way that I saw it po.
Again, ang Article of Impeachment number 4 ay tungkol sa grave threats. No? Ito ay hindi ordinaryong pangyayari, no? Lalo na kung ito ay manggagaling sa isang mataas na opisyal ng gobyerno. Yun ngang ordinaryong tao na nagbabam joke sa eroplano o sa airport, talaga namang pinipigil, hinuhuli at kinakasuhan ng paparusahan. Ganun din naman yung mga sisigaw ng sunog sa loob ng sinihan. No? These are crimes that has to be seriously punished. No? Kaya mas lalo na kung ito ay binigkas o binitawan ng isang mataas na opisyal ng ating gobyerno. Walang lisensya. Ang sino man sa ating gobyerno, ikaw man ang pinakamataas na hinalal ng taong bayan, ay walang lisensya para gawin mo ito.
Good afternoon po. Of course, not to put emphasis on the score or kung victorious po ba yung first week po ninyo. But would you say that hawak po ninyo yung momentum, let's say? Hawak po niyo yung momentum after the first 3 days of the trial?
No, I wouldn't say that. But I would say that it was a good week for the prosecution.
Umpisa pa lang naman ng boxing, ika nga. No? Kumbaga sa basketball, first quarter pa lang ito. Napakahirap pa hong sabihin kung sino yung nanalo, sino yun. Maring maisip ng ating mga kabayan kung sino yung lamang, pero hindi pa masasabi kung sino yung panalo. First quarter pa, marami pa hong time out ito. Kaya yun ang maganda at aabangan natin yan.
In addition to that lang po siguro, and I think we've noticed that po no, since day one, medyo if we look at public perception, naging tali na po yung nangyayari dito. Nagbibilangan po ng puntos, kumbaga. But I think it's very important to remember na this is not the process, the whole process of impeachment trial is not about yung paramihan po ng mga motion that was granted or paramihan po ng puntos na binibilang po ng ating mga kababayan na nanonood. But it's actually about the quality of the questions that are being asked and then whether or not, the question really ultimately is whether or not at the end of the day, evidence is left standing. So it's all about whether the foundation of the evidence is laid out properly and that the evidence is laid out in a clearly understood manner. As to whether or not that was achieved for the prosecution this week, we cannot say. Of course, that's on the merits and it's up to our senator judges. We wouldn't want to say anything that would tend to prejudge the case. But all we can say is that like Attorney Zamora said, Kong Zamora said, it was a good week for the prosecution.
Balikan ko po yung sa ano, parang may pinresent po yata yung defense kanina na website nung Max Score, tapos pinakita po nila dun sa witness. What were your thoughts dun po sa presentation po nila? Parang they're trying to establish po na, let's say, kinu-question ba nila yung naging training ni Kalilong nga po? Kasi parang binabanggit yung mga product services po nung Max Score kanina.
Yes, I believe that was the point of the defense. Kasi ang nilabas nga nila, parang supplier yung kumpanya, no? And I guess, yun ang direction. Kasi sa totoo lang, no, sabi nga ni Attorney Ligutan kanina na nasaan na yung mga tanong in relation to the pictures, in relation to the articles of partnership nga ba yun, kulang ng tanong. But kami po, syempre naisip namin na patungkol yon doon sa training na nakuha ni JM Kalilong. Well, in any case, no, one senator judge, I think it was, I think the Senate President who asked regarding Max Score interventures, and totoo, kinonfirm ni JM Kalilong na supplier to, pero in fact, they had trainers na nagbibigay ng training. So kung sabihin na, kung ang punto ay supplier sila, hindi sila dapat gumagawa ng training to discredit JM Kalilong, well, nasagot naman po ng ating witness na yung training ay binigay ng trainer for forensic tools, and there were certifications. In fact, hawak-hawak nga din po niya kanina yung certifications na I believe sinerox po ng ating Senate staff nung hiningi po ni Senator Judge Robin Padilla ang copy ng kanyang mga certifications.
Last na lang po. Doon po kay, syempre nasabi niyo na po na hindi natibag, na naging napaka-consistent po ng mga sagot ni JM Kalilong. But ano po yung thoughts niyo doon naman sa, kasi alam ko may mga questions po yata kanina regarding inimbestigahan din po ba daw yung Romanov or inimbestigahan din daw po ba yung threats daw po sa Vice President nung pinlay nga po nila yung portions ng video. Parang sinasabi na aside dun sa sa President, nag-investigate din ba yung NBI dun sa iba pang mga surrounding na issues sa Vice President po?
I think nakuha natin sa testimonya ni JM Kalilong na may proseso silang ginagawa sa NBI and sinunod nila, kasama siya sa parte siya ng isang team, no? At sinabi niya na meron siyang executive, meron siyang upper person na nag-direct sa kanila na gawin itong mga hakbang na ito. So he was part of a team who conducted the investigation. And I believe that he was able to show the different steps that he took to conduct the investigation. And kinonfirm naman niya na they looked at different videos. In fact, they even checked nga the alleged threat on the Vice President. So, I think wala naman po silang hindi ginawa based on, I guess, their mandate and what they are allowed to do under the law.
In other words, the witness presented by the prosecution was not impeached.
Sirs, ma'am, balikan ko lang yung parang naging question ni Senator Judge Risa Ontiveros. Yung tinanong niya na kung ito ba ang plano ng defense na i-establish na parang dahil na-oppress yung OVP Chief of Staff, pwede na mag-grave threats. Do you think the Senate Impeachment Court should have allowed the counsel to answer the question of the Senator Judge? Or would you rather not address it?
I think we have to respect the process. We are an impeachment trial. We are prosecutors before a panel of judges, senator judges, and their decision on this matter is absolute and ultimate, and that we would respect whatever decision they would make.
But do you think that was a valid point raised by the senator judge? I mean, was this the reason why the video was presented?
Well, certainly our senator judges would think about that. Kasi bakit nga naman nila ipinapalabas yung video ni Attorney Zulaika Lopez noong gabi na yon, prior to the statements made by the Vice President. So anong connection, di ba? Anong relevance? And I'm sure pare-pareho naman tayo, naisip natin yun na siguro yun ang punto ng kanilang depensa.
Good afternoon po. Yung question ko po yung sinasabi ng defense panel repeatedly na wala pa pong napapatunayan yung prosecution that a contract indeed exists. A contract to kill the President, First Lady, and the former Speaker. Kaya ang kanilang conclusion, ergo, there is no impeachable offense committed on the part of the Vice President. How do you respond lang po dun sa, lagi nila kasi yung ina-argue, even outside of the impeachment court, na there is no physical contract of that supposed kill job. Thank you. Conditional kill job. Thank you.
Okay. Siguro kaya medyo mas sumasagot ako ngayon kasi kasama ako sa threats na team, no? But without going to the merits of the case, without going to their evidence or the prosecution's evidence masyado, no? Siguro at the end of the day, dapat natin matandaan na hindi naman tayo nagpo-prosecute ng isang criminal case. No? Hindi po tayo nagpo-prosecute ng grave threats. Sa isang criminal case, kailangan mo ng elemento, yung mga elemento ng isang krimen. Pero dito po, ano ba yung pinoprosecute natin? Yung impeachable offenses of betrayal of public trust, high crimes, and culpable violation of the Constitution. Yun po yung tatlo na related sa grave threats nating article, yung Article 4. So, tandaan po natin, wala naman specific na elemento itong mga to. Ang sinasabi natin, ang actuations ng Vice President in relation to that November 23, 2024 video ay or constitute betrayal of public trust, or she betrayed the public trust dahil sa kanyang pagbabanta sa buhay ng Presidente, ng First Lady at former Speaker of the House. This is a very general term, no? Betrayal of public trust. So wag po natin tignan ng specific elements ng isang crime under the revised penal code.
So, having said that, contract or no contract, given the actuations of the Vice President, your allegation still stands. Would that be correct? Your allegations will still stand regardless if there is physical contract or not. Would that be correct?
Okay, the allegation that there was an impeachable offense, yes, contract or no contract, it is our position that her utterances made on November 23, 2024 constitute impeachable offenses of betrayal of public trust, high crimes, and culpable violation of the Constitution.
Thank you, ma'am.
Going back sa tanong ni Haji about Romanov, can you tell us the significance of this to the impeachment trial? na-establish po ba na meron ngang Oplan Romanov? And what can you say about it being mentioned by the defense during the trial?
Well, if I may, no, yung Oplan Romanov na yon, wala namang basihan siguro. Dahil unang-una, when the NBI invited the person to which that statement was attributed to, yung sinabi niya na Oplan Romanov, hindi naman nag-cooperate. No? They did not cooperate with the NBI kasi inimbitahan sila, hindi sila nagpunta to shed light on the issue. Kasi this is a serious story that needs to be investigated then. No? Unfortunately, hindi naman nagko-cooperate yung nagsasabing merong ganyang klaseng plano. So where do they start? Perhaps the NBI conducted their own investigation. I don't know what happened to that investigation. Maybe as we speak, meron silang report that they kept confident. I really don't know. But again, no, yung Oplan Romanov was just a side story in the whole issue of the video where the utterance made by the Vice President is material, is important and valuable, ika nga.
All right. Well, it's now the turn of Celerina.
Good afternoon. I'm just wondering, how confident are you that the testimony of your first witness could somehow encourage the senator judges to convict the Vice President with regard to the Article 4 of the impeachment?
Well, hindi pa po natin na ilalabas ang mga iba nating witnesses. So siguro it will be premature to say that his testimony will convict the Vice President. Pero po, for the prosecution, of course, we will only present witnesses who we know are capable of proving our case.
Regarding this petition filed by some of the lawyers allied to the Vice President with regard to Senator Escudero as the presiding officer, may we know, even if there's no decision yet by the Supreme Court, what if the court would decide in favor of them? So how would it affect the impeachment process, this impeachment trial?
Ayoko naman din ho pangunahan ang Supreme Court, but in any case, wala naman po silang nilalabas na TRO or what have you. So tuloy lang po ang ating proseso dito sa Senate Impeachment Court.
So you're not concerned that just in case na baka mapalitan siya?
Hindi po tayo concerned doon. And of course, we follow the Senate Impeachment Court. There was, for all of us, there was a proper election of the presiding officer. And we trust the will of the majority of the senators when they did that. So kami po, syempre, as lawyers and as officers of the court, sumusunod po tayo sa mga hakbang na ginagawa ng isang korte, including the impeachment court.
For Joe Malapas.
Isang tanong lang po. Doon sa cross-examination po ng defense, meron po ba dong part na nagpakaba sa prosecutors? At bakit po?
Kung meron ba pong part na nagpakaba, wala po.
Bakit po, ma'am?
Well, nakita naman po natin na magaling, consistent, ang competent ang ating witness na si J.M. Calilong. So, confident kami na kaya niyang sagutin ang mga tanong. In fact, ang ating presiding officer ilang beses pong sinabi na pabayaan sumagot ang ating witness dahil kaya niyang sagutin ang mga tanong.
Second question ko po ay, lumabas po yung video nung di mo na yung pagbabanta ni VP Sara nung panahong kinukontempt si Atty. Lopez. Kung sakali po na pumalag ulit o may pumalag ulit, o tumanggi si Attorney Lopez na pumunta sa impeachment court, ano pong posibleng mangyari?
Siguro ayaw din namin pangunahan muna yan. Hintayin na lang po natin kung dadating si Attorney Lopez sa day kung kailan po nakaschedule siya to be our next witness. I believe next week po, she will be the second witness.
Okay, we'll entertain 2 more questions.
To Prosex and to spokes barbers po. Ma'am, on the contract and or no contract when it comes to hiring an assassin, on its criminal nature lang po, hiring as an assassin, does it even require an actual paper where the supposed hired assassin would swear that he would kill someone or whatever, the details na nakalatag po, for it to even exist? That's my only question, ma'am. Thank you po.
Wala pa ako nakitang nangyaring gano'n, no? Na kung saan ang isang kriminal ay may kontrata. No? If indeed the person is a assassin or is an assassin, wala naman sigurong kontrata yan. Di ba? Wala naman siguro ding paper. Halimbawa, hindi tumupad sa kontrata, didemanda mo ba siya ng breach of contract? Di ba? Hindi. So I don't, honestly, walang kontrata na dapat tingnan among the contracting parties and the person in the party involved.
Okay.
Well, of course, tama po si Kong Ace, no, na I'm sure wala pang nakagawa na may written contract relating to the hiring of an assassin. I mean, as lawyers, no, wala pa tayong nahawakang ganyang kaso. And ito this is not from a prosecutor, but as a lawyer. Any contract involving hiring an assassin or involving the killing of a person would be illegal because it involves something that is void or illegal. So that the contract itself is void.
Actually, ang follow-up question dyan, kung halimbawa totoong may contract, inonotaryo ba yan?
Judea Bernardo po from DETV News. Just for the record lang po, may reason po ba kung bakit po nausad si Attorney Jeremy Lotok for next week's witness stand po? And why is NBI Director Melvin Matibag not part of the witnesses next week?
It is really a matter of the prosecution strategy, or the prosecution and the threats team strategy to have Attorney Lotok on Monday. After all, paggabi na din naman, and we don't want to waste everyone's time or up to tonight, di ba po? Siyempre, pag naumpisahan na yan, tuloy-tuloy na yan hanggang mamayang gabi, and we don't want to do that. But in any case, I'm sure that Attorney Lotok will be there on Monday, and he will be able to answer all of the questions that will be propounded by both parties and the senator judges. Now, as regards the reason behind Director Matibag not being in the list for next week, we will probably present him the following week dahil 3 days a week lang nga po ang ating trial, and kanina po ang hiningi sa atin ay 3 names lang.
Sorry, follow-up lang. Do we expect yung trial to be longer next week considering na 1 witness lang per day? Kasi kahapon si Agent Kalilong nasa ngayon. So next week 1 witness per day, so mas magiging mahaba.
Alam mo, depende po yan sa testimony ng witness at syempre sa kung gaano kabilis o kabagal ang pag-present ng mga abogado ng testimonya ng witness. So hindi natin masabi na mas mahaba yung kay Kalilong o yung kay Lotok, but we will see po.
I think we have to consider also po no, na there's no strict limitation. Yung 1 day per witness rule, it's the other way around. No, the ideal is that the witness's testimony would be dispensed with within 1 day, not necessarily 1 day isang witness lang po. As you would recall, in fact, what was supposed to happen earlier was a second witness was to be presented because we already had the first witness today po. No, but what we have to remember po with this process is that. It's not exactly, you can't base it on the previous witness. It is not predictable, especially na the line of questioning will evolve po, no? Together with the cross, the redirect, and the recross. It really depends on what has transpired in the previous segment. So we really can't tell. But what we can say, based on what the prosecution has mentioned a while ago, is that they will maximize po the trial dates. And so far, that is what we see.
Okay, on that note, we want to thank our panelists and our friends from the media.
Thank you.
Okay.
See
Good
you
evening.
next week.